ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ವಾಯ್ಸ್ ಆಡಿಬಲ್ ಇದೆ ಅಲ್ಲ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಆಡಿಬಲ್ ಇದೆ ಅಲ್ಲ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಆಡಿಬಲ್ ಇದೆ ಅಲ್ಲ?
ಬಂದ ತಕ್ಷಣ ಮೂವ್ ಮಾಡ್ಲಾ ಸರ್? ಮತ್ತೆ ಅರ್ಜೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಮೂವ್ ಮಾಡಿ ಕೊಡಿ.
ಸರ್ ಎಲ್ಬಿ ಬರ್ಬಿಡ್ತೀವಿ ಎಲ್ಬಿ ಅಂತ ಹಾ ಬರ್ತೀವಿ ಎಲ್ಬಿ ಟಿಬಿ ನಾಳೆನೇ ಬೇಕು ಸರ್ ಪ್ಲೀಸ್ ನಾಳೆನೇ ಬೇಕು.
Friday today, tomorrow.
End of the week.
Not necessary.
Pending. Getting
ಸರ್ ಅದೊಂದು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಸರ್ 23ನೇ ತಾರೀಕು ಅಂತ ಹಾಕಿದ್ದೀನಿ ಸೆಟಲ್ಮೆಂಟ್.
This is a matter, cooperative society matter, my lords, where petitioners are only two. There are only two petitioners, and I have paid court fee of 200 rupees. Now, my lords, the registry is asking me to pay court fee of rupees 18,000 rupees because if the order is passed in your favor, there are 180 people who are going to be benefited from the same. Therefore, my lords, it is as per writ proceeding rules. Thursday.
How to the election?
It's not election matter, my lords. It's a beneficial. Therefore, on Thursday.
For tomorrow. CS or LB?
LB. The last kindly one RN restaurant, my lord, we have obtained the license also. All of a sudden, without notice, without this one on inquiry, issued notice yesterday on Friday, my lord, saying that 24 hours you have to close down the
LB.
Yes, LB, my lord.
ನಾಳೆ ತೋಣ ಟೈಮ್ ಇದೆ
24 ಟೈಮ್ ಇವತ್ತೇ ಮುಗಿದು ಹೋಗುತ್ತೆ ನಮ್ಮ ಅಂಗಡಿ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು
ನಿನ್ನೆ ನೋಟಿಸ್ 2:30 serve it on Pawan Kumar.
My lord, in this matter, the respondent who is a cooperative society, my lord, the petitioner who has already paid the full amount. Now they are trying to create a third party interest to the site which is allotted to the petitioner, my lord. My lord.
Actually, supported an interim order on the recreational club. The deputy registrar has passed an order supporting the ex-office bearers paying my recovery money.
Thursday.
Cooperative society matter. Option sale
23rd tomorrow. ಯಾವ್ದು LB na CS?
LB matter, withdraw.
Tomorrow. LB ಅಂದ್ರೆ
number 70.
ಇವತ್ತಿಂದ this one.
ಚೆಕ್ ಮಾಡಲಿಲ್ಲ ಮಾಡ್ತೀನಿ ಗೊತ್ತಿಲ್ಲ ಇದೆಯಲ್ಲ ನೋಡ್ತೀನಿ ಚೆಕ್ ಮಾಡ್ತೀನಿ.
Page number 55.
55, my lord. This is the petition. 2 weeks time in this matter. Inform the other side.
If I have the request to the council for the petitioner released on 11th April.
Okay.
Page number
63. 63. Senior.
ಏನು
Senior is out of station.
ಅದಕ್ಕೇನ್ ಮಾಡ್ಬೇಕು?
2 weeks.
Council for the petitioner released on 13th April.
Lord, serial number 69, my lord. I am appearing for the respondent number 3, my lord. 6 week of time, my lord.
Respond number 3. Have you informed the other councils?
My lords will inform, my lord. Try to contact.
Only if you inform.
Page number 13. Serial number
77.
77. And AGA accept notice for respond number 1. Counsel for the petitioner has filed a memo seeking memo dated 23/2023 signed by the counsel for the petitioner with the permission to withdraw the above petition, accepting the submission of the counsel and the memo.
Page number 2. Page number
Serial number
Serial number one,
serial
my
number
lord.
1, 2, my lord. Weeks accommodation, serial number 2 in list number 2. Inform the other side.
To the request of the counsel for the petitioner released on 13th April.
Serial number 5, my.
Serial number
5.
5.
Petition may be dismissed as not
At the
after the petition.
counsel for the petitioner submits. She so and so learned counsel for the petitioner submits that the petitioner does not wish to press the above petition, accepting the said submission. Petition dismissed as not pressed.
My lord, serial number 1 in list number 2, I appear for the petitioner. I'm requesting 2 weeks time, my lord. I've informed the other side.
On the request of counsel for the petitioner released on 10th April.
My lord, list number 2, serial number 13. I appear for the petitioner in this matter, my lord.
CL number?
13, my lord. It has been brought to our notice that the petitioner has expired.
Just a moment. Has it been
Sorry.
called out?
Sorry, my lord.
Item number 9, also the petition, request for 2 weeks for accommodation. And for the petition. I've informed the other side.
In the request of counsel.
Serial number 11.
Released on 13th April.
Lord, serial number
11. Serial number 11. 2 weeks time.
11.
1 week time.
Leave your
Now responded to my lord, but I am appearing for corporation. This is in respect of widening of the road.
Have you informed the petitioner?
Our sickle yard noting.
Inform Madidiro Ilvo. They don't.
Lord, serial number 7, my lord, for the petitioner, only for 2 weeks time.
Have you informed the respondent?
I will inform.
Will better. Yes, madam. What is number 13?
My lord,
My lord, in serial number 13, I appear for the petitioner. It has been brought to our notice that the petitioner has passed away. Kindly grant 2 weeks time to file the necessary applications.
It's not ordered on respondent to 13.
my lord, serial number 7.
For the petition submitted, the sole petition has expired. She seeks for and is granted 2 weeks time to bring the legal representatives on record. Released on 13th April.
My lord, list to
Great
serial number
for
7. Respondent advocate is here, my lord.
Serial number?
7. Respondent advocate is here. We pray for 2 weeks time, my lord. I'm the petitioner.
Objections hakidira?
Objection.
The request of the counsel for the petitioner released on 11th.
Serial number 18.
Page number 3. Serial number 15.
Serial number 18. I'm for the petitioner. I have to ascertain the instruction as to whether it survives or not. In the 2 weeks time.
Devendra has entered appearance for respond 1 and 2. Delete T.S. Satish Babu as that appearing for 1 and 2. Have you informed?
I am not informed, your lord.
Then don't mention.
Serial number 19, my lord. Serial number.
Counsel for the petitioner has filed a memo dated 23/2023 signed by the counsel for the petitioner. Stating that the election to the Gram Panchayat was held in the year 2020 itself, and as such, the above petition is rendered infractional, accepting its submission. Petition is
Not with kind permission, lord. Not with kind permission. List number 2, serial number 2 has been adjourned. There is an interim order.
interim order extension.
Inform the respondent.
Now matter.
Serial number 18. Just now.
Serial number
18.
18. Devendra has entered appearance for respond 1 and 2. Delete T.S. Satish Kumar at the request of the counsel for the petitioner released on 11th.
Interim order.
Interim order earlier granted.
Page number 4.
At CL number 21 to 24, my lord, I'm seeking permission to withdraw the writ. 21 to 24. Please. And the memo na nalak. 21. Chamundeshwari Electric Company, yaar.
HB
Devraj accepts notice for respond number 2. Counsel for the petitioner has filed a memo. Stating that the petitioner wishes to withdraw the above petition, accepting the submission and the petition and the memo. The petition is dismissed as not present. 22. H.V. Devraj accepts notice for respond number 2 and the AG accepts notice for the number 3. Counsel for the petitioner has filed a memo, same. 23. H.V. Devraj can respond number 2. Memo dismissed. 24. H.V. Devraj for respond number 2 and AGA for respond number 3. Memo dismissed.
One submission.
One matter.
How the
Fresh matter, Worship. The corporate society matter, Worship.
Thursday.
On submission, my lord. Number 1, serial number 40, my lord. The council and record is not feeling well, my lord. And proxy council, kindly have it next week.
It's for admission.
First matter, I appear for the petitioner, my lords. My lords, I have received the NOC Wakalat by today. My lords, I may be given 2 weeks time to file the Wakalat, as well as I am going to argue the matter on the next date of hearing, my lords.
Original record is okay.
My lords, original records has to be produced by R1 and R2.
Already produced, Mr. Kash.
Much of, but 2 weeks time may be granted to me, my lords. Today itself, I have received the Wakalat.
Records have been secured. Shri B.R. Deepa submit that you would be entering the appearance for the petitioner. He seeks for 2 weeks time to get ready and address his argument. We list on 6th April.
Much obliged, my lords.
Petition. Respondent 4 has to withdraw the amount.
Respond number 4. Nagarajappa. Where are you?
Which time may be done?
We already have given you 3 times.
Final
If you don't want the money, we will appropriate.
video is not showing up. Final chance may be done.
Once again, an accommodation is sought for by respond number 4 to withdraw the money. If the said amount is not withdrawn by 25th, the same would be appropriated for a better purpose. Read this on 28th.
One more clear.
Point number 3 was not served. 10 to 2020.
When have you produced this?
Yes, it was produced along with the memo on 15 to 2023.
Respond number 3. Respond number 3.
Respondent number 3, the M. Pawan Prasad, alias Kannam Prasad, Sana M. Maruti Prasad.
The respond number not being served. The 120 have been filed for sub-service, which is going to be allowed on 2/2/2023. In further thereof, the petitioner has taken out the paper publication on 9/2/2023. In connect to Karnataka, Bangalore edition, which has been produced along with the memo dated 15/2/2023. Respond number 3 has been called out. None answers for respond number 3. Service in respect of respond number 3 is held sufficient. Registry is directed to print the name of respond number 3 with the endorsement served through paper publication. Vacating in
Respondent number 4, Madam, 5.
I appear for respondent number 4 minutes.
I request for a week's time to argue that.
Respondent number 464 and is granted a week's time to address arguments. Relist on 30th March.
Great.
Serial number 4.
What respondent?
Final file ಬಂದಿದ್ಯಾ Mr. Bandari? ಬಂದಿದ್ಯಾ?
Ready, sir.
Ready. Ready.
I'll take it up to 2:30.
30. Pass out.
Of course, much of it.
Yeah, sir.
Respondent, week time may be granted for the petition. The week time may be granted.
ಏನಕ್ಕೆ?
But the official was on leave for 15 days. Today has come. We have by Monday. However, he has filed a civil suit before the court. That is also applied for certificate copy.
Counsel for respondent seeks for and is granted 1 week's time. Finally, to file the report as directed on 28/2/2023. If the report is not filed by 25th, who is to file this report?
Fourth respondent.
Who is the fourth respondent?
Partition.
The Chief Officer, Town Municipal Council, Chandapura, shall be personally present before this court. We list on 28.
Serial number 6. David Narasimhan.
A move for withdrawal, my lord, has been filed.
Counsel for the petitioner has filed a memo dated 17/3/2023 signed by the petitioner and the counsel for the petitioner seeking permission to withdraw our petition. Accepting the statement, petition is dismissed as withdrawn. Pending applications stand disposed.
7. David Narasimhan.
Respondent 6 to 9. The respondent 1 to 5.
Action taken report
Section 16th of March.
16th of March.
17th, my lord, it was listed. Whatever reason, my lord, it was not put up on the statement of.
ಅದು ಹೇಳ್ಬೇಕಾಯ್ತಲ್ಲ ನೀವು. Hakirin objections.
It was brought to my lord's notice and my lord directed the putting up of that objection. And hence today's date, my lord, was fixed.
Already counsel for submit that he has filed a statement.
Please, my lord, I had filed it, but it is not placed on the.
Put up the objection. But what is the endorsement? Non-filing of action taken report by counsel in person of the order dated 12/12/2022.
12/12. Please, my lord, the statement of objections, my lord, can be treated as the action taken report.
12/12 ಅಲ್ಲಿ ಏನಾಯ್ತು?
I was directed to file an action taken report.
So what have you stated in your objections?
But the gist of this is, my lord, is that an original suit is pending adjudication, my lord, that is OS number 2.
You could not take action.
My lord, the next date of hearing is on 29th. My lord, by 29th, my lord, I would be filing my written statement before the trial. Any date after.
7/11.
My lord.
7/11 application act to reject the plaint has not been.
Please, I will.
Hard by law.
I will be filing the necessary application as well as the written statement. My lord, it is posted on the 29th of this month, my lord. Any date after 29th, my lord, I will be furnishing a copy of this also to this honorable.
You appeared on 14/10.
Please, my lord.
You did not file your written statement. It was taken as not filed. It went to evidence.
Please, my lord.
3 dates for evidence has been adjourned.
Please, my lord.
You still are in the process of finalizing your written statement.
My lord, now that it is posted on the 29th, my lord, one date after the 29th, my lord, I will be filing a copy of the written statement as well as the application.
Please keep your law officer present.
My lord, he is present, my lord.
Illidare.
He undertakes, my lord, that is respondent number 4 in this writ petition.
Is he the law officer?
He is not the law officer. He is the respondent number 4, assistant executive.
Asked you to keep the law officer present. Because we are seeing this in all matters where you are served with summons, you don't file your written statement. It goes for an ex parte decree. And then you will come and show us the ex parte decree saying because of the decree, I am prevented from taking discharging my statutory duties.
Apologies to the-
We're not about you, we are about your
Please,
client.
I understand. my lord.
That is why we want a word with your law officer, or it needs to be escalated to the commissioner.
No, my lord, it may be adjourned any date after the 29th, my lord. I would be filing a copy of the written statement as well as,
To instruct the law officer that this is not the way it has to be done. You were served
please, ma'am.
before 1410, you entered your appearance on 1410.
Please.
Sorry, you have entered appearance on 7/9. 7/9 in the you were 6 months. The matter has been adjourned 7 times.
Any date.
Unless there is collusion between your officers and the rest, this could not have happened.
Once at any particular point of time, it is not that I deny anything of this, my lord. But the only thing is that, my lord, the concerned officer, that is who has to provide the para-wise remarks, my lord, he is present before this court. He will give an undertaking, my lord, that as on 29th of this month, my lord, it will be overseen that the written statement would.
And the court will reject it because you have taken 4 days after evidence.
Opportunity, my
He is the one to give instructions.
Respondent number 4, my lord.
For the written statement, he is the one to give instructions. What's his?
My lord, Mr. Pradeep.
ನಿಮ್ಗೆ ಯಾವತ್ತು ಸರ್ವಿಸ್ ಆಗಿದ್ ನೋಟಿಸ್ ಯಾವಾಗ ಸರ್ವ್ ಆಯ್ತು ಸೂಟ್ ಅಲ್ಲಿ?
My lord. 8/20. Basically, it goes to the legal department, my lord, and from the legal department, it has to speak.
ನಿಮ್ಗೆ ಯಾವಾಗ ಬಂತು?
24/11/22.
8/8 it was served and it came on 24th.
My lord, I'll again seek.
Internal communication was 3 months.
My lord,
3.5.
seek clarification, my lord. I'll file a better affidavit to this effect, giving in details, giving all the details, my lord, as to what, when was served on whom.
Counsel for respond number 1 to 5 has filed a statement of objection. We submit that the same can be taken as the action taken report and further the order dated 12/12/2022. He submits that those the notices under section 248(1) and 248(2) had been issued. Respondent corporation could not take any action since a suit in OS number 26373 of 2022 had been filed by respondent number 6 to 12, wherein there's an order, ex parte order of stay which has been granted. A perusal of the orders, case status printout taken from the e-court website gives rise to a very sad state of affairs. Inasmuch as the respondent corporation having entered appearance 7/9/2022, the matter was posted for written statement on 14/10/22, 22/11/22, 13/12/2022. The written statement not having been filed, it was taken as not filed and the matter posted for evidence on 19/1/23, 9/2/23, 16/3/23, 6/3/23, 16/3/2023, and now is posted
29/3.
posted on 29/3/2023. Counsel for respond number 1 to 5 submit that the written statement is under preparation and would be filed on the next date by seeking leave of the court. On inquiry as to when the summons had been served, it is stated that the summons were received by the legal department of respond number 1 to 5 on 8/8/2022, which was communicated to respond number 4 on 24/11/2022.
My lord, the particular date, my lord, I will ascertain, my lord.
File ನೋಡಿ ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದು. ಇನ್ನೇನು ಅಸರ್ಟೈನ್ ಮಾಡಬೇಕು?
I will ascertain this one.
ನೋಡಿ ಫೈಲ್ ನೋಡಿ ಹೇಳಿ.
True, my lord, it is mentioned as 24/11/22. It is mentioned.
It is rather strange that when a suit has been filed and an injunction order, ex parte injunction order passed in the said suit, the corporation has continued to stay quiet for over 6 months and is projecting the said order to be the reason why the corporation could not take action on 248(1) and 248(2) notices which had been issued. The commissioner of the corporation is directed to file an affidavit detailing out the process and procedure that has been put in place at the corporation to address any summons received in a suit and what steps are taken by the corporation for vacating any order of stay which has been passed in a particular matter. The affidavit to be filed on or before
First week of April.
Ashtina
By 29th, my lord, once it is posted, my lord.
on or before 5th April, relist on 6th April, relist on 10th April.
Then I request the further construction to be restrained.
It's already passed one.
That is not there.
Respondent number 6 to 12 are restrained from putting up any construction.
6 to 21, my
21,
please.
6 to 21.
Serial number 8.
This must be probably the 20th matter coming like this. Adike, he said, unfortunately, nim matter tagla kontate.
I can go. Allah, there has to be somebody, my lord, who is answerable to this.
Let him convey the ridiculous 8.
I understand, my lord.
24/11 it goes to the andre. By that time, written statement has been taken as not filed.
True, my lord. True. I
30
understand.
days of written statement active.
My apologies. I'll take the necessary.
Please instruct them properly as to what is the procedure
Please,
and
I
file
will,
a proper affidavit.
please, I will do that.
ಮತ್ತೆ ಅದರಲ್ಲಿ
ಅಲ್ಲ.
ಅರ್ಧ ಬೇಡ.
If-
Half hearted attempt ಮಾಡಬೇಡಿ.
Please. Oblige.
Serial number 8.
Petitioner, my lord.
Court fees.
Petition has been filed by the,
Both fee has to be paid.
that I'll pay, because my lord, earlier it was not paid. In the meanwhile, I request your lordship. to
That
pay.
is the only this one which is being paid.
One prayer I had thought, my lord, during the course of the day, I'll pay it.
We'll pass over. You pay the court fee, we'll take it up.
Already, I'll pay it.
Because without court fee, other objection we can always
Additional they have raised, I'll pay it.
pass over.
Serial number 8. Occupancy.
The coordinate bench not had directed the BP inspect pursuance of interim order of the coordinate bench not spot inspection was done. 248(1), 2 notices were issued. Respondent Milord was also a party to the writ petition. The writ petition Milord was disposed of directing the BBMP to take necessary 8(3). But this Milord was disposed on 1/9/2022 Milords. They suppress all of this. They file a suit for bare injunction before the trial court. On 2
Number 21, you are at 20 and you are 21. So ಲೆಕ್ಕ ಇಟ್ಕೊಳ್ಬೇಕು ನಾವು. 4.
2/9, no action not from BBMP. No action from BBMP.
Application. The present petitioners before this honorable court filed including application.
We'll come to you later, sir. You file a suit knowing fully well that a suit cannot be filed. We'll come to you later, but we are more concerned with the corporation.
On a 248(2) notice, final notice has been ordered, madam. Thereafter suppressing this fact, they approach the civil court, obtain an order of interim order, madam.
What have you done?
Why not instructed the officials to file necessary application to get it vacated, madam. The matter is now posted to 27th.
Served, Mr. Jacob.
I have filed the wakalat on.
ಅಲ್ಲಿ ಇದ್ರಲ್ಲ
ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ because the next hearing date is on 27/3 for filing of written statement.
The interim order was passed on 6/9/22.
Please, madam.
Interim order was passed.
There in March.
6 months has
What
passed.
steps have we taken in last 6 months to vacate the interim order?
I should say consider instruction. In fact, on the last date itself, I called up them and informed as to what's transpired in the court.
Seems to be an hogwash. We have issued notice.
Manoj, I'm extremely sorry to make this submission because we are also not getting the necessary cooperation from the BBMP also.
That is why in the other matter,
I mean,
we directed the commissioner only. Otherwise, probably your commissioner does not know about all this.
After for a week's time, because the matter is posted before the trial court on 27/3. Before that, I'll seek instructions and make necessary submission.
This is yet another case where once a notice under section 248(1) has been issued, the OTC has filed a suit in OS number 26449 of 2022, wherein an ex parte interim order was passed on 6/9/2022. Counsel for the petitioner submits that the said interim order is still in force. Therefore, it is required to be ascertained from the corporation as to what steps the corporation has taken to get the interim order vacated and or the claim rejected on account of the same being barred by law. Shri Jaikirti, counsel for respondent number 124 seeks for and is granted
10 days time.
10 days time to file an affidavit in this regard. Released on 31st March. Interim order earlier granted is extended to next.
Serial number 10, Ajay Jain.
Who is to file wakalat for R2?
Respondent counsel, there is a bereavement. But my lords are also directed me to obtain instructions, my lords. On that aspect, my lords, I have some submission to make.
Yes.
My lords, I had said that there is.
You read what?
Sorry. My lords, I had made a statement that there's a park on the other side of the ring road, which land allocated for a purpose of park on the other side of the ring road, which can be converted to site because it is not being utilized by any person in this. My lords are directed me saying that, look, already sites have been sold to various members of society. You either obtain their no objection or you implement them. The difficulty, my lords, is that what has happened is that now this is a new management. Some records are not available. Also, many members have filed suits for specific performance, where what has happened is that Obrik site korti Vinobrik kodalala. So they have filed a suit and there are injunction orders and things. Then there are matters pending in consumer forum. So they don't have clarity on several persons who are owning the plots. Also, many people, what they have done is they have already sold the sites immediately upon getting the members have sold the site to various people. That also they're not able to get complete track of this. Given this difficulty, I have one submission to make. If my lords finds it appropriate, if MUDA can be directed to inspect only on that aspect of whether that particular.
It's not about MUDA inspecting. It is about a right which is vested with the purchasers that to whom you are sold, that they will be entitled to use a park which is being designated. Now you want to change that park to a site or to sites because of change in law.
My lords, not
so. If they have no objection, we can allow it.
Can I?
No objection, then you can't.
No, I fully follow. I'm just putting forth the submission. All I'm saying is that, my lords, even for the MUDA to consider that submission, my lords, consider whether the park, they have to necessarily issue a public notice. They'll have to call for a hearing, and only after that, my lords, they will allow any modification of the plan. So if my lords can consider that, because the difficulty, my lords, is if I try to now implead 380 people, my lords, it will be 4 years by the time everybody comes on wakalat. My lords, then
you implead them as petitioners.
My lords, how can I?
If they are going to support you.
No, my lords, that is the difficulties, my lords. They are able to gather some 10-20 people as of now. 10-20 people affidavit itkondu madakal because 300 jana iruvaga. How can I just file 10 people and then say that? I mean, I will not be able to make that submission that no, so many people. That's the difficulty.
You have to reject your petition.
My lords, I follow what my lords are saying. All I'm saying is that I'm only asking for a mandamus in consideration of the previous order.
There's no vested right.
No, I follow that. My lords, then my lords, I would only say that I'll try to make one more representation to the MUDA and try to persuade them to take action.
If you are not bringing them on record, we'll dismiss it because you have no right.
I follow.
That's why we give you time.
Yes, my lord, the difficulty is that they are not able to collect the information.
If there's difficulty, then we can't.
No, my lord, I'm not coming.
You have to serve what you have to do.
No, I'm only placing that. I'm only placing what.
If you want, we'll give you another 10 days time. If you bring them, well and good. Otherwise, we'll dismiss.
My lords dismisses it, then it forecloses my right to even approach.
That is why we are giving you time. That you don't suffer. If they support you, well and good. If they don't support, anyway, you don't have a right.
I follow. Not good. Getting 300 300 odd people is the difficulty that I'm facing, my lord.
And help it, because it is their rights that you are seeking to deal with.
My lords, if Muda can be directed to, because I'm not able to pursue, many of them I'm not able to.
How will Muda get it, Mr. Ajay? It's your society, your soul.
Give me 15 days.
Don't try to put this one on Muda.
No, my lords, when a person is swimming and
To
when a
10 days,
person does not know swimming and he's sliding, he will try to grab onto anything that he can
You
get.
know swimming, you know everything. This is additional income that you want to generate. The only reason why you are.
My lords, I see that is.
Somebody else will get some
No,
sides.
that is for the, no matters, because there are suits for specific performance there, and there are complaints, criminal complaints filed against.
So for the petitioner,
15 days.
15, he seeks another 15 days accommodation to bring the site owners on record as parties. If needful is not done, the petition will be liable to be dismissed.
My lords may not record that.
We'll have to remember it. How can you remember? It have to be dismissed, since it is the rights of those purchases which are in question in the present matter. We list on 10th April.
Number 11.
Wasn't the respondents 1 to 4? Just for 2 days accommodation, my lords, earlier my lords had directed a particular council. There was some communication which was not there. An order has been passed as per.
Directed a particular council, directed the nodal officer.
Sorry, my lords, told that.
So Pawan Kumar is the nodal officer. So once he is directed, it's corporation being directed.
They have taken action, but I have not got the report. The demolition order, my lords may kindly see Annexure D, page 13.
But Mr. Banu Prakash, we don't want this submission being made.
No, my lords. Thursday.
I'll ask the law officer to be sitting.
No, not necessary, my lords. I will take it. I'll undertake that on Thursday. I'll have it filed.
The whole purpose of designating Mr. Pawan Kumar is.
I do understand.
That
on Thursday, I'll have it filed.
The Banu Prakash, when it passes for response, the Banu Prakash has filed wakalat for respond number 1 to 3. Hence, registry is directed to delete the name of Mr. Pawan Kumar. As that undertakes to file wakalat for respond number 4. Hence, registry is directed to delete the name of Pawan Kumar as that appears for respond number 1 to 4. Shri Banu Prakash seeks for and is granted a
Thursday
to file the action taken report. We list on 27th.
Serial number 12.
This matter is listed for the purpose of filing the report, my lord.
Nish Kumar has entered appearance for R1 to 4. The name of Shri Pawan Kumar has appearance to respond 1 to 4.
The lordship's order dated 28th February 2023, my lord.
Survey is done, my lordship. He must be in some other court or held up.
So,
This is the second.
let us get the report.
Very well, my lords. This is the 4th time the report is being filed. Second time the report is being filed before this honorable court. What they have concealed is the fact that there was an earlier suit which they filed.
Are you privy to the contents of the report?
I am privy to the contents of the earlier report.
This report?
This report, my lords, not yet.
Let's see what
because they have conducted the inspection.
Regarding the acknowledgements that have been made, the petitioner, and there is a stay of sort of seeking the report from the corporation. So Tahsildar has to file a document or having issued a notice calling upon the petitioner to be present in this part while survey is conducted.
When are you going to conduct a survey?
ಮಾಡಿದ್ದಾರೆ ಮಾಡಿ ಆರ್ಡರ್
The
ಮಾಡಿದ್ದಾರೆ.
allegation is you are not, notice was not served to him anta. Kindly pass over, my lord. If it is there or not, I will make a submission.
Because I have got
We'll fix the.
one date petition. No, I have no objection. The date may be fixed.
You again know whether he was present or not.
Whether the notice was served or not before survey.
Let them ascertain.
I will ascertain and I'll make.
No, what was hard thing. I don't have.
Let us ascertain it. Let us ascertain that, Mr. Abhyarthi.
Last time also it was adjourned later. So that's why one chance may be.
2:30, we will take it up.
Chance may be good because I have got other matters.
We won't do anything. We'll just record a statement. It's unnecessary adjournment and listing for that.
Yeah, I don't. Yes, well, I also support. In fact, I
We'll
want
do one thing. You pay the cost of each adjournment, we'll adjourn.
No, my lord, I'm not a judge. Yeah, my specific instructions from the party through RTI, subsequent to filing of the writ petition, the petitioner applied for the necessary information. He got the information that there is no report submitted as per the directions of this honor. There is a RTI endorsed.
The question is whether you are served or not.
That is also not there.
So that's why he's asking for a pass over. You're passing over the matter. Let us take it on record. Then you can make your submissions later.
No, sir.
Yes, pass over.
Serial number 14.
Please, R1.
I pray for a week's time to comply objection.
Cooperative society.
The standing counsel for R1.
No much.
Rawat Ojida.
17th March.
Notice to respond number 1 has been dispatched on 17th March, awaiting service, released on 13th April. Petitioner to comply with the office objection by that.
Serial number 15. From the mayor.
Yet for the respond number 4, Lord.
R6, what is the problem with Wakalat?
Vacating stay application. I appear for
There's some problem with the Wakalat of R6.
Appeal is not
My wakalat, appeal is not effective. Friends, I'll comply with that. I shall comply.
Counsel for respond number 6 submits that the office objection in respect to his Wakalat Kama will be complied with in a week's time.
Lord, so far as the main matter is concerned, matter is urgent because by virtue of the interim order, putting off the meeting of the municipality has been stayed. So because of the coming election, Lord, if you do not hold the meeting, the entire writ petition, Lord, would become relevant. The point here is.
You are ready for argument, Mr. Arvind?
Yes.
You are appearing for?
I am appearing for the 4th respondent who is the president of the society.
You are appearing for 1, 2, 3, Mr. You are appearing for? R5.
R5. We filed vacating stay application.
AGA is appearing for R1 to 3. R6 Nevidura. Yes, Mr. Basraj.
Just, yes, it can be disposed of with a subsequent development also. It's a pure question of law. I take your lordships to page 4, paragraph, page 4. The purpose of my ready reference, I have called out the section itself. Section 47 of the Karnataka Municipalities Act. The municipal council shall ordinarily hold at least one meeting every month for the transaction of business, which shall be called an ordinary general meeting. The president may, whenever he thinks fit, and shall, upon the written request of not less than 1/3 of the whole number of councillors, date not more than 15 days after the presentation of such request, call a special general meeting. If the president fails to call a special general meeting, as provided in subsection 2, the vice president or 1/3 of the whole number of councillors may call such meeting for a day, not more than 30 days after the presentation of such request, and require the chief officer of the municipal commissioner to give notice to the councillors and take such action as the case may be necessary for the meeting. Now, in this case, a requisition was given to the president on 31/1/2023 as per Annexure C, page 21. 31st of January 2023. He should have called the meeting on or before 15th of February 2023. Annexure C, page 21. 1/3 of the councillors gave a requisition to.
How many councillors are there here?
But Annexure C, page 21.
Councillors in this council?
31.
31 councillors.
Yes. 11 councillors gave the requisition.
11.
Yes.
Page.
Annexure C, page 21.
21 only there are 10 and 11 councillors.
Then the president ought to have called the meeting on or before 15th of February 2023, within 15 days. Then on 20th of February 2023, as per Annexure D, page 22, the requisition was given to the vice president, since the president failed.
147.3. In terms of 147.3.
47, yes, yes, ma'am. Section 47. 47 is one. Let- Now the vice president, if we take 30 days from 20th of February 2023, he had time till today. Vice president.
30 days.
Yes. Ma'am. Now 30 days, whether it starts from the original requisition or from the date of giving requisition to the vice president, there is some scope for interpretation because the fresh requisition was given to the vice president. Now 47, if the president fails to call a special general meeting as provided in subsection 2, the vice president or 1/3 of the whole number of councillors may call such meeting for a day not more than 30 days after the presentation of such request, and require the chief officer or the municipal commissioner to give notice to the councillors and take such action as may be necessary to convene the meeting. Now, the requisition to the vice president was given on 20th of February 2023. Now, the illegality we are finding out is after the.
Is your contention that it is 30 days from annexure D or 30 days from annexure C?
Blood, there is a judgment of the Gujarat High Court on the identical issue, which interprets that 30 days starts from the original requisition. I must bring it to your lordship's notice. It starts from 31/1. Though our contention is, there was no fresh requisition to the vice president. Vice president straight away called. Here, the fresh requisition was given to the vice president on 20th of February 2023.
So, in terms of subsection 3, there is no fresh requisition required or request required to be given. If the president fails to call a special general meeting as provided in subsection 2, the vice president or 1/3 of the whole number of council may call such meeting for a day not more than 30 days after the presentation of such request.
Such request, whether it is the original request or the second request of the vice president, it falls for interpretation of your lordship. But I'll straight away take your lordship to the judgment later.
Is that interpretation an issue in this matter?
No. What happened is this: after the expiry of 15 days, the president becomes, I will not use the word punctus officio, but he had his chance. He could not have called a meeting. Now, what he has done is, on 7th of March 2023, he calls a meeting. After his the time of 15 days is over, the president calls a meeting on 7th of March 2023, fixing the budget meeting on 16th of this month, as per annexure E, page 23. 7/3/2023, he had his chance on or before 15th of February 2023. He calls a budget meeting which was scheduled to be held on 16/3/2023, and the general meeting dated 10th of March 2023, which is scheduled to be held today, 20th of March 2023. Our contention is it amounts to usurpation of the power of the vice president and also the councillors, which he couldn't do. Now, there is a subsequent development that the vice president has already called the meeting now.
Is the meeting of the same council?
Pardon?
Is the meeting of the same council?
Yes, now the president, vice president has called the meeting now in exercise of his power.
What does it matter whether the president, what is your submission? If the president calls for it or the vice president calls for it, so long as the meeting takes place.
After the expiry of 15 days, the power to call the meeting is only vested with the vice president. Because section 47(2) says within 15 days he has to call the meeting.
Yes.
On the requisition. After the 15 days, if there is a failure on the part of the president, the meeting can be called only by the vice president or 1/3 of the members.
It is not necessary to be so also. Because under subsection 3,
is
1/3 of the whole number of the council, the vice president or 1/3 of the whole number of council may call such meeting.
If the president fails to call a special meeting, as provided in subsection 2, the vice president or 1/3 of the whole number of councillors may call such meeting for a day not more than 30 days after the presentation of such request, and require the chief officer or the municipal commissioner to give notice to the councillors and take such action as may be necessary to convene the meeting. Not, I have two submissions to make. When the law requires something has to be done in a particular manner, it has to be done in that manner or not at all. One. And every word in the legislative enactment has to be given full extent, full interpretation to the extent, fullest extent possible. Now, subsection 3 vests the power with the vice president or 1/3 of the councillors. Now, if the president slept over the matter for a period of 15 days, thereafter, he cannot usurp the power of the vice president, especially when the requisition is given to the vice president. Now today, the vice president has already called the meeting now. I do not say that the requisition has become infructuous, but the meeting is already fixed by the vice president to be held on 29th. That may pass on the memo. Therefore, the power now is already exercised by the vice president. The subsection 3 cannot be diluted because it has to be done in a particular, when the law says, when the legislation says that something has to be done in a particular manner, it has to be done in that manner or not at all. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಕರ್ನಾಟಕ ಪೌರ ನಿಯಮಗಳ ಅಧಿನಿಯಮ 1964 47 ಪ್ರಕರಣದಲ್ಲಿ ಉಪಬಂಧ ಒಟ್ಟು 1/3 ಕೌನ್ಸಿಲರ್ ಕೋರಿಕೆ ಸಲ್ಲಿಸಿದ್ದು 30 ದಿನಗಳು ಇನ್ನ ಮೀರದಿರುವ ಕಾರಣ ಸಭೆಯನ್ನು ಕರೆಯಲು ಸಂಪೂರ್ಣ ಅಧಿಕಾರವಿದ್ದು ತಾವುಗಳು ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ನಗರಸಭಾ ಸದಸ್ಯರುಗಳಿಗೆ ಸಭೆ ಕರೆಯಲು 29/3 ಬುಧವಾರ ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ ನಗರಸಭಾ ಕಚೇರಿಯಲ್ಲಿ ಸಭೆ ನಡೆಸುವಂತೆ ಹಿಂದೆ ಸಭಾ ಕಾರ್ಯಸೂಚಿಯನ್ನು ಹೊರಡಿಸಬೇಕು. This is the meeting notice called by the vice president now. Therefore, the notice issued by the vice president, which is beyond his power under section 47(2), is already gone now.
How do you say that, Mr.?
Pardon?
You will have to make good that submission, saying that if he doesn't call for it, he becomes.
But
you rightly said, you will not go to the extent of saying functus officio. He loses his power to call for the meeting.
It amounts to that we made a thorough research. What has happened in one case, the vice president did not call for the meeting. Did not call for the meeting. Under the identical circumstances, the president called the meeting even after 15 days. This Honorable Court has taken the view that since the vice president did not exercise the power, now the vice president exercises the power, you cannot find fault because the vice president should have called the meeting. That is what this Honorable Court has taken the view. In 2011.
The difference is in the dates.
Pardon?
We'll have to keep track of the dates. We'll have to keep track of the dates.
Yes,
We'll have to keep track of the dates.
Yes,
the first date nimdu heliddu 31/3/23. Then 15/2/23 he had to call for the meeting. He did not call for the meeting. On 22/20/23 was when the meeting, when a second requisition was submitted. Despite it being submitted on 22/20/23, the vice president exercised the power on 17/3/23. In the meanwhile, the meeting was called for by the president on 7/3.
After the submission of the requisition to the vice president on 20th of February 2023, the president exercised the power on 7/3/2023.
Yes, the vice president did not exercise. The vice president did not exercise power.
No, the understanding is he has calculated 30 days from the date of requisition, that is 20th of February 2023. Now he has called for the meeting now. This meeting notice is dated.
That also may not be correct, Mr. Basra.
17th he has called for the meeting.
17th is a notice.
Yes.
Stating that the meeting will be on 29th.
That 15 days, whether he can call for the meeting fixing the date after 15 days, that is one subject matter of interpretation. Whether after 30 days, for example, overall period of 30 days from the original requisition, if the vice president calls a meeting, whether it should be called, that also should fall within 30 days or beyond 30 days. Not again.
That anyway you are not addressing. Now,
may simplify this. May simplify this. I will simplify this so that there will not be any scope for misinterpretation from our side. 31st January 2023 is the date on the first requisition was given. Now the president ought to have called the meeting on 15th of February 2023.
Yes.
The vice president, starting the day, considering the date of 31st January 2003 as the starting point, should have called the meeting on or before 2nd of March 2023. Now after that, both the president and the vice president and the councillors, they lose the right to call the meeting. After,
No meeting will ever take place.
never takes place. Now what happens on if the president has called the meeting on 7th and 10th March 2023, that would be an exercise of the power as a president. This is as fair as I can be. Because as on 2nd of March 2023, both the vice president and the councillor, they lost their chance. Therefore,
that argument a little extreme, Mr. Basuraj.
No, I'm saying something in their favor. May make something, I will clear. 31st January 2023 was the starting point.
Yes.
The president after called the meeting on or before 15th of February 2023.
Yes.
Now the president failed. Then another 15 days, because it is not 30 days from the 15th of February 2023. Another, if you add another 15 days, it would fall on or before 2nd of March 2023. That would be 30 days. On or before 2nd of March 2023, the vice president or the councillors, they did not call the meeting. Therefore, even the vice president also lost the power and the councillors also lost the power. Therefore, these two notices issued by the president, at the most, the respondents can argue that this is independent of this requisition in exercise of the power of the president. That's all they can argue.
And 48 requires 7 clear days or 3 short days.
Yes. Therefore, if the president has called a meeting on 7th of March and 10th of March 2023, that would be beyond the power of the president, vice president, and also the councillors, because all of them together, they could have called the meeting on or before 2nd of March 2023. So they did not call the meeting. The vice president, if he had called the meeting on or before 2nd of March 2023, then this argument could have been available. Now, even they did not call the meeting. Therefore, 7th and 10th of March 2023, which the president called the meeting, at the most, they can argue that it is independent of this requisition. As a president, he has called the meeting. But again, the fact remains that whether the requisition of 30 days starts from 20th of January 2023.
The imputation of your extreme argument is that the
latest one or
did not call for the meeting.
The latest one or earlier one?
President did not call for the meeting.
Yes.
Vice president also did not do it within 30 days. The councillors also did not do it within 30 days. Therefore, this 17-3 could not have been issued by.
No. I'm saying something in their favor.
The meeting extreme argument.
I did not make myself. 7/3/2023 and 10th of March 2023, they can argue that it is an independent power of the president. After all this requisition time, everything over, he can say, okay, forget about all that. I am calling the general body meeting in exercise of my power under section 47(1). It is the best argument available to them, subject to the rider that the 30 days starts from 31/1/2023 and not on 20th of February 2023. If it starts from 20th of February 2023, then the vice president was well within his rights to issue notice on 17th of March 2023, fixing the date of meeting on 29th of March 2023. If the entire period is from 31/1/2023.
Please read subsection 3.
Subsection 3.
1/3 of the whole number of council may call such meeting for a day not more than 30 days. So it is not that the notice has to be issued in 30 days. The meeting has to be in 30 days.
President may, whenever it is fit and shall, upon the request of not less than 1/3 of the whole number of persons for a day, not more than 15 days after the presentation of such request, call a special general meeting for a date not more than 15 days after the presentation. So within 15 days, he has to call the meeting, also fixing the date of meeting.
The
Within
day
15
should
days.
be within, the
15
meeting
days.
day should be within 15 days.
Now the vice president shall call a meeting upon the failure of the president for a day not more than 30 days after the presentation of such request, and require the chief officer or the municipal commissioner to give notice to the councillors and say, take such action. So if the vice president were to give the meeting notice, that also shall fall within 30 days from the requisition given to him. That is my argument. Or the requisition given to the president. If he has to call the meeting also within 30 days, then today's meeting would be valid because he called the meeting on 29th.
Yes.
But he called the meeting on 17th. But the meeting notice has to be within 7 days. The meeting notice under section 48 shall be clear 7 days from the date of the notice. It cannot be earlier than that.
Or short notice of 3 days in emergency.
Plus section 48.
8.
My lord. 7 clear days notice of an ordinary general meeting and 3 days clear notice in case of a great urgency. Now it's an ordinary meeting. Even if we take 17th of March 2023, it cannot be today because it's only 3 days. 7 days would be that it can be only on 24th. And I'm trying my best to interpret the provision in a harmonious manner so that both the president and vice presidents are not denuded of power in a democratic institution. Because what happens is this: in many cases, the notices are called for express no confidence against the president. He will not call for the meeting for a period of 15 days. He will simply sleep over the matter to do some horse trading. Then after 15 days, when the time is right, he will call the meeting. Now, this shall not give effect to usurping the power of the vice president or the councillors. If the president has not called for the meeting within 15 days, then he cannot exercise the power after 15 days. That should be the law. I respectfully request your lordship to lay down. Then after 15 days, what happens would be that the vice president can call for a meeting, provided it should fall within 30 days of the original requisition. But under any circumstances, after the expiry of 15 days, the president cannot be allowed, should not be allowed to call for a meeting because that would be in any case.
That argument would be a little difficult.
Pardon?
This last argument that you are addressing, that you won't have the power, is not provided in section 47.
No, that
If the vice president does not exercise.
Pardon?
If the vice president does not exercise powers under subsection 3,
then president can. President can. But in this case, in the Karnataka High Court judgment, where the vice president also did not exercise the power.
High Court Gujarat anta yado kottilla namaga.
I will continue.
This is Gujarat.
That paragraph 6, almost similar. Paragraph 6. The contention urged on behalf of the petitioner proceeds on an infinite interpretation of the relevant provision. The period of 30 days, which the vice president gets for calling a meeting, is to start from the date of the presentation of the request of no confidence motion by not less than the requisite majority of the councillors against the president or vice president. The period of 30 days does not start from the date of expiry of 15 days granted to the president. In other words, the president gets 15 days time from the date of receipt of the written request to call the special meeting for discussing the motion of no confidence. Upon the expiry of 15 days, the vice president gets another 15 days for convening such a meeting. Therefore, in all 30 days, in the aggregate is given to the president and vice president from the date of receipt of the written request. The petitioner, therefore, is not justified in contending that the vice president would get a further period of 30 days after 8/8/1999. In fact, the vice president was required to convene the meeting by 26th of August 2099. That having not been done, the chief officer was justified in submitting the report to the councillor and collector, and the collector was justified in convening the meeting as per his impugned order dated so and so, which was within 1 month from 10/8/1999. The date of receipt of the report of the chief officer. Therefore, the requisition was on 31st January 2023, and the entire time of 30 days would have been over on 2nd March 2023.
Yes.
Now, after 15 days, the president could not have called the meeting. Now, beyond 30 days, the vice president could not have called the meeting.
So no meeting will take place.
Pardon me?
No meeting will take place.
No place. Now, Now the problem is, after expiry of 30 days, the vice president has called the meeting now. Fixing the date of the meeting as in 29. Now both the the reason is that both the meetings have lapsed. Budget meeting is also lapsed, and today it is practically impossible to hold the meeting because many councillors are here. Now the meeting is already fixed on 29. Therefore, my lord, keeping the questions of law open, let the meeting called by the vice president may be allowed to continue.
Lord, the question is with regard to the validity of the meeting notice. The vice president has issued because the notice issued by the president is stayed. That is on that ground. Now, why all this is, your lordship may ask me. Why all this is 27th, the code of conduct is likely to come. So after 27th onwards, we cannot take any decision with regard to any of these issues. Two notices have been issued. One is with regard to budget meeting. Kindly see, Lord, at page 23. Now, this entire argument does not apply to budget meeting. Even this has been stayed now. Annexure E, page 23. Now, what we are concerned with is at page 27. The ordinary general meeting. Samanya Sabha. Now, the net result is, even this budget meeting where we have to approve the budget, approving before the financial year, that also got stalled. Now, with regard to this 20th also, meeting also, now there is an interim order in operation. Now, the argument of my learned friend is that once a requisition is given, President loses the power to call any meeting. That may not be a correct submission because now let us say, my lord, hypothetically, as now the vice president also has not called, he has lost his right to call the meeting. If the Gujarat judgment is to be taken into consideration, total period itself is 30 days, but that the provision is slightly different. In that case, my lord, that provision is different from this provision. So the same thing cannot be applied. Lordship may see that judgment. The provision is at Para 5. Clause 2. The president may, whenever he thinks fit, shall upon written request of not less than 1/3 of the councillors in the case of a motion of no confidence against the president or vice president, and 1/4 of the councillor in any other case and on a day not later than 15 days after the presentation of such request, call a special general meeting. If the president fails to call special general meeting, as may be provided in this clause, vice president shall call such a meeting on a day not later than 30 days after the presentation of such a request. This has been interpreted to be totally 15 plus 15. Now, in the present case, there is no confidence motion. The question of horse trading is also not there. What is the regular business? Regular business is being conducted. Now, my lord, if your lordship look at the provision, section 47, the object is to see that a meeting takes place. Whoever calls the meeting under section 51, it is the president who will preside over the meeting, not others. Any meeting.
To section 51 in Gujarat.
Yeah.
Should also have been there in Karnataka. Provided.
ಇದರಲ್ಲಿ 51 ಆತರ ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಂತ ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಯಾವುದೇ ಮೀಟಿಂಗ್ ಆಗಲಿ ಪ್ರಾವಿಸಿಯೋ ಇದ್ದಿದ್ದು ಇಬ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಏನು ಅನ್ನೋದಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ yeah, Lord, what happens is the object appears to be that a meeting takes place. A continuous president failure to call the meeting should be a consistent failure, not a case he loses his right. That the failure to call the meeting should be persistent. That is, he does not call a meeting despite all this. Then, my lord, they also have a right. 1/3 of the members can go to the chief officer, say that we ourselves are calling the meeting. Now, that does not mean, let us say that all these three things do not happen. When president comes around, calls a meeting, does it mean that the president cannot call at all? The object is to see that the meeting takes place. Now, the failure to call a meeting should be there as a continuous action, because if he does not call for a meeting, then vice president can call. If he does not call a meeting, then 1/3 of the members should call. That does not mean in the meanwhile, president himself comes forward and call a meeting. His right to call a meeting, Lord, still remains. But in case he does not call a meeting continuously, then my lord, the meeting can be called by the others. But to say that president can never call a meeting, he loses his right to call a meeting, my lord, would lead to an absurd situation where even the president, vice president does not exercise and 1/3 of the members will not give. President can, nobody can call the meeting because the right of the vice president is lost and the right of 1/3.
That is why this proviso to section 51, if it was there, that would have taken care of that situation.
Correct. That is why my lord, court's role come only. Yeah. And this is not a case of a no confidence motion or anything. This is a regular business which is being taken place. Now, if I even I will have to now conduct a meeting, I will have to give 7 days notice because it is interrupted in the beginning. Any meeting, my lord, which goes after 26 cannot be held at all because once this financial year starts by first, we cannot collect any property tax if the budget is not approved and if the general meeting.
A short notice of 3 days.
What?
Short notice of 3 days.
Yes, sir. No, they are urgent business. Now we will have to give a short notice in case there were urgent business. But no, because of the stay order, it is interrupted. If stay order period is excluded, my lord, it comes within that period. There is no difficulty because this 7 days notice, then this clear notice in case of great urgency, we will have to once again issue notice and conduct the meeting. The object appears to be that we do not conduct any meeting at all.
I have to issue a notice fixing the date and.
No, but not if the stay order, because of the stay order, it is interrupted. Now, the period for which the 7 days has to be calculated can be calculated excluding the period of stay. That is all. Now, suppose, my lord, another 1 or 2 days are to be given, or your lordship can fix a date, my lord, on which date we will.
That is what you say. 3 days will fix.
Irritate during
short this one and
during this week, my lord. Your lordship may conduct it on direct.
29th again won't serve any purpose.
23rd.
I cannot object. That meeting is concerned tomorrow itself.
23rd.
But the general meeting which is called by the vice president is not challenged. He has already called the meeting.
No, that is right is lost because the meeting is already. Kindly see the notice.
Therefore, the general meeting of the vice president cannot be held to be illegal. He has already fixed the meeting on 29th. The lordship permit whether code of conduct is there on the meeting will be held. But budget meeting, let them conduct the meeting tomorrow itself. We have no objection. But general meeting, the vice president has already fixed the meeting on 29th. That will be held as per the provision of section 47(3) because he already exercised the power.
Let
me deal with that.
This notice issued by the vice president is of no consequence because.
Just give us 3 days. The 7/3/2023, the president exercised his right for the budget meeting.
Yeah.
And it was fixed
on 16.
Budget.
Yeah.
Notice was issued on 7/3.
7.
General meeting.
General meeting.
10th of March
on 10th to be held on 20th.
Today.
10/3/23 fixed it as 20th.
17/3, vice president has exercised the power and fixed the meeting on 29th. That is not
right. Is lost.
Budget meeting may be held tomorrow. And the general body may be held on 23rd because there is formality.
We can't just take those 11 people and say tomorrow.
Budget don't have any objection.
They may not have, but we'll have to give them 3 days notice at least.
Even in the main prayer also.
23rd and 24th.
No other prayer at all.
You give them 3 days, Mr. Shan.
23rd and 24th.
More set of petitions coming.
Budget, let them hold the meeting, but the vice president's meeting is not questioned.
You are only representing 1/3, Mr. Basraj, not the entire thing.
But in a democracy, even a single person has a voice. But under the Municipalities Act, 1/3 is the statutory mandate. Therefore, tomorrow, what happens is this. Even we can call a meeting. Forget about the president and vice president. Under section 47(3), 1/3 can call the meeting on their own. And if there is a quorum, they can, if the president does not turn up, we'll appoint a president. Your lordships are aware of the meetings on Shackleton. Therefore, we can do it. But the vice president's meeting is not questioned. And that is not recalled. He is also a responsible officer in a democratic setup. That meeting cannot be cancelled or it cannot be withdrawn. And it is not withdrawn.
We'll deal with it. Ping pong after.
I'm sorry. I leave to learn.
Petitioner is before this court seeking for the following case. The grievance of the petitioner is that though a requisition had been submitted by that the council consisting of the grievance of the petitioner is that though 11 members of the council had submitted a requisition on 31/3/2023 to call for a meeting, the meeting was not called for by the president within a period of 15 days as required in terms of subsection 2 of section 47 of the Karnataka Municipalities Act 1964. And it is only subsequently thereafter that a notice came to be issued by the president on 7/3/2023, calling for the budget meeting on 16/3/2023. And a notice came to be issued, and another notice came to be issued on 10/3/2023, calling for the general body meeting on 20/3/2023. Shri S. Basaraj, Learned Senior Counsel, appearing for the petitioner, would submit that once the president does not exercise his powers under subsection 2 of section 47 to call for a meeting within 15 days of the presentation of a requisition and or a request for the meeting, the president virtually becomes functus officio and would not have the power to call for a meeting, be it the budget meeting, more particularly a general meeting. We submit that once, the submission is that once the period of 15 days elapses from the date of submission of the initial request, it is only the vice president or 1/3 of the whole number of the councillors who could call for a meeting in terms of subsection 3 of section 47 of the Act of 1964. The vice president, now having called for a meeting on 17/3/2023, fixing the date of the meeting, having issued a notice on 17/3/2023, fixing the date of meeting as 29/3/2023. The said meeting ought to go on, and the earlier notices issued on 7/3/2023 and 10/3/23 are required to be quashed. He relies upon the decision of the Honorable Gujarat High Court in 1999 SEC Online Gujarat 258, more particularly para 6 thereof, which is reproduced hereunder for easy reference. Relying on the said decision, he submits that once the president does not exercise his rights within the period of 15 days, it was for the vice president to exercise the said rights within a period of 30 days from the date of requisition. Shri Ashok Arnaldi, the Senior Counsel, appearing for respond number 4. The president, yeah. You are appearing for the Municipal Council. 5. For respond number 4, the president of the CMC would submit that merely because the president does not call for a meeting within a period of 15 days, he would not be rendered functus officio. Even after a period of 15 days, a meeting could be called for by the president, so long as no meeting has been called for by the vice president and or 1/3 whole members of the council. In the present case, when the budget meeting was called for on 7/3/2023, fixing the date as 16/3/2023, neither the vice president nor 1/3 whole number of the councillors had called for such a meeting. When the notice dated 10/3/23 was issued, calling for the fixing the date of the general meeting as 23/3/2023, neither the vice president nor 1/3 of the whole number of the councillors had called for any meeting. Therefore, the exercise of the powers by the president prior to any such exercise by the vice president or 1/3 of the whole number of councillors was well within the power of the president. However, since The said notices had been stayed by this court. He submits that this court could fix a date for holding both the meetings by giving appropriate notice, taking into account Section 48 of the Act of 1964. He submits that the submission is that the whole purpose of Section 47 is that a meeting is held. If neither the president nor the vice president were to call for a meeting could never be called for, which is not the purpose and ambit of Section 47 of the Act of 1964. Shri Arunasham, Senior Counsel, appearing for respond number 5, adopts the submissions of Shri Ashok Karnataka, the Senior Counsel, and further submits.
51, my lord. Whoever calls meeting, my lord, the president has to pay.
Our submission.
No, 50 quorum. 50, 1/3 is the quorum. Section 50. Otherwise, no meeting can take place. Section 50. 1/3 is the quorum.
And the submission which could have been made by respond number 4, not by you.
Just what assisting the court. He in fact submitted, my lord.
I refer to 51.
But we filed, my lord, vacating the interim order.
Of the submission of the Ashok Karnataka, the Senior Counsel. Third, the points that could arise for determination in the above matter are: 1, whether a president not calling for a meeting within a period of 15 days as prescribed under subsection 1 of Section 47 of the Act of 1964 would be rendered functus officio, depriving him of the right to call for a meeting thereafter. What is the period, from when is the period of 30 days to be calculated in terms of subsection 3 of Section 47 of the Act of 1964? Whether in the present case, the president could not have called for the budget meeting by notice dated 7/3/2023 and called for a general meeting by notice dated 10/3/2023. Whether in view of the stay which has been granted by this court, which is in operation till today, the notice issued by the Vice President dated 17/3/2023 calling for a meeting on 29/3/2023 is to be acted upon. What order? Point number 1. Section 47 of the Act of 1964 reads as under. A perusal of subsection 1 of Section 47 indicates that a municipal council shall ordinarily hold at least one meeting in every month for the transaction of business, which shall be called an ordinary general meeting. The whole purpose of subsection 1 of Section 47 is that one meeting is to be held in every month for the transaction of business, thus fixing a boundary of 30 days for a meeting to be held. It is in the background of subsection 1 of Section 47 that the meaning, purport, intent, and application of the other subsection of Section 47 would have to be determined. Subsection 2 of Section 47 indicates that the president may, whenever he thinks fit, and shall, upon a written request of not less than 1/3 of the whole number of councillors, call for a meeting within 15 days of the presentation of such request. The subsection 2 contemplates of two distinct possibilities. Firstly, the president could call for a meeting anytime in that given period of month when a meeting is to be held in terms of subsection 1 of section 47. Secondly, whenever a request is submitted by 1/3 of the whole number of councillors, a meeting needs to be called for not more than 15 days from the presentation of such a request. Thus, it is clear that the president is required to call for a meeting within 15 days of a request being submitted. However, subsection 2 does not deal with a situation where if the president were not to call for such a meeting, he would be rendered functus officio. In this regard, subsection 3 of section 47 would also have to be looked at, which provides for a situation where the president pays to call a special general meeting in terms of subsection 2. The vice president or 1/3 of the whole number of councillors may call such meeting for a day not more than 30 days from presentation of such request. This is also this power of the vice president and 1/3 of the whole number of councillors is further circumscribed by requiring the chief officer or the municipal commissioner to give notice to the councillors and take action as may be necessary to convene the meeting. Thus, a reading of subsection 3 would indicate that the vice president or 1/3 of the whole number of councillors may call for such a meeting, which in contradiction to the word shall used in subsection 2 of section 47 would only be an enabling provision for the vice president or 1/3 of the whole number of councillors. In fact, if the president were not to call for such a meeting, there is no requirement for the vice president or 1/3 of the whole number of councillors to call for such a meeting. It is only if they choose to do so, then the vice president or 1/3 of the whole number of councillors may call such a meeting. Once as mentioned above, it is not that the vice president or 1/3 can call for such a meeting by themselves, but the same would be required to be done through the chief officer or the municipal commissioner, who is required to give notice to the councillors and take action for convening the meeting. Such being the case, I am unable to answer point number 1 by holding that merely because the president did not call for a meeting within a period of 15 days, you will be rendered functus officio. It is only if after the period of 15 days, either the vice president or 1/3 of the whole number of councillors exercise their right under subsection 3, that the president cannot call for such a meeting after such exercise of power by the vice president or 1/3 of the whole number of councillors. To make it more amply clear, as in if a notice had been issued by a request has been made by 1/3 of the whole number of councillors, the president is to call for a meeting within 15 days. Call for a meeting, fixing the date of the meeting within 15 days of the request. If no meeting is called for by the president, fixing the date of the meeting within that 15-day period, then the vice president or 1/3 of the whole number of councillors would call for a meeting within 30 days of the initial request having been submitted. and require the chief officer or the municipal commissioner to issue notices to the councillors. If the vice president or 1/3 of the whole number of councillors were not to exercise such powers under subsection 3, there is no embargo under section 47 for the president to call for a meeting, though beyond a period of 15. Point number 2. Answer to that. A reading of subsection 2 and subsection 3 of section 47 also gives rise to issue as to the manner of calculation of number of days from the date of request being submitted. Subsection 2 indicates that the president shall call for a meeting fixing a date not more than 15 days from the date of presentation of the request, which would make it amply clear that the calculation is from the date of the request. Subsection 3 gives rise to an interpretation, since in terms of subsection 3, the vice president or 1/3 of the whole number of councillors may call for such a meeting for a day not more than 30 days after the presentation of such request. The interpretation sought to be given to this is that the period of 30 days is to be calculated after a period of 15 days provided to the president. The reading of subsection 2 and subsection 3 harmoniously, in my opinion, would however give rise to a different result. Inasmuch as what is required to be seen is the calculation of the days is from the date of presentation of the request and not from the date on which the president was required to call for a meeting. The date of presentation of the request being paramount, the president firstly has a right to call for a meeting within 15 days of the presentation of the request. In the event of the meeting not being convened within that 15 days, automatically the vice president or 1/3 of the whole number of councillors would get a right to call for a meeting within 30 days of the date of submission of the first request. The same can never be calculated from the date of the inaction on part of the president, inasmuch as the powers under subsection 2 and section 3 are circumscribed by the powers under the mandate under subsection 1 of section 47, requiring at least one meeting in every month to be held of the municipal, 1 month in every month to be held of the municipal council for transaction of business. If
Basuraj gave me a judgment, similar view is taken
in Gujarat.
2011, ನಮ್ಮ ಹೈಕೋರ್ಟ್
ಕೊಡ್ಲೇ ಇಲ್ಲ ನಾನು.
ಅಲ್ಲಲ್ಲ ಅದು ಅವ್ರಿಗೆ ನೋಡ್ತಾ ಇದ್ದೆ ಕಾಮೆಂಟ್ರಿ
ನೋಡ್ಕೊಂಡು ನಮಗ್
ಕೊಟ್ಟೆ
ಇಲ್ಲ ಅದೇ ಸುಮ್ನೆ ಹೇಳ್ಬಿಡ್ತಾ ಇದ್ರಲ್ಲ.
If the vice president or councillor do not call, then what the president is called, that is holds to you. Unless the vice president or the councillor exercise the right, as your lordship just now held.
Circumscribed by so and so within 1 month. That's the period of 30 days is required to be taken into consideration in terms of subsection 1 of 47, meaning 30 days from the date of presentation of such a request. Similarly is the view which has been expressed by the Honorable Gujarat High Court in 1999 in Bharatbhai Ganeshbhai Patel's case. One aspect that I would like to advert to in respect of the Gujarat decision is that that section 51 of the Gujarat Municipalities Act makes an additional provision providing for a situation where the president and vice president fail to call for such a meeting, for the chief officer to make a report to the collector, who shall call the meeting on a day not later than 30 days from the presentation of such a report. It is for the legislature to examine whether a similar provision could be incorporated within the Karnataka Municipalities Act 1964, providing for a situation where the president or the vice president or 1/3 of the whole number of councillors do not call for such a meeting. Answer to point number 3. The contention of Sri S. Basraj, Learned Senior Counsel, is that in the present case, a request has been submitted on 31/3/2023. The meeting had to be convened by the president in terms of subsection 2 of section 147 by 15/2/2023. Thereafter, the president having become functus officio, no notice on 7/3/2023 could have been issued, calling for the budget meeting on 16/3/23, and no notice could have been issued on 10/3/2023, calling for the general meeting on 20 March 2023. The aspect of functus officio has already been answered in point number 1. The further contention of the S. Basraj, Learned Counsel for the petitioner, is that the vice president, now having exercise powers under subsection 3 of 147, while notice dated 17/3/2023, having called for a meeting on 29/3/2023, the said meeting could go on.
You searched in the SCCR, like you didn't get. Sometimes the traditional research, it's better than this online research. In the commentary of the.
Now, very shortly, that repository will be ready. Yes. Repository, all the judgments, including daily orders, will come. Neutral citation will come for everything. So then the searching will become
Subject wise.
that may take
Research.
a longer time, but word search will be available.
Word search is
Anybody to do a word search.
And searching adjust after. Sometimes you don't get.
This statement I didn't get. This directly on the point.
Rubbish out. Any question ಕೇಳಿದ್ರೆ ಅದೇ ಬರುತ್ತೆ.
Clear repository, word search was there. It was very nice.
No, the repository, if you have any suggestions to make, you can always
It
make.
was there, my lord. By word, my lord, we could able to search the judgments directly. ಹೌದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಮಾಡಿಫೈ ಮಾಡಿದ್ಮೇಲೆ ಸಿಗ್ತಾ ಇದೆ.
ಏನ್ ಬೇಕೋ ಕೊಡಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. Technology is not the master. Technology is the slave. So anything that you want
Keywords
can be done.
Keywords search ಮಾಡಬಹುದು.
If that is what the advocates prefer to do and want to do, it can be done. In the present case, the vice president, neither the vice president nor 1/3 of the whole number of councillors having exercised their powers under subsection 3 of section 47, I have the considered opinion that the power exercised by the president on 7/3/23, calling for the budget meeting on 16/3/23, and or the power exercised on and or the notice dated 10/3/23, calling for a special general meeting on 23/23, cannot be faulted with. As held above, it is only if the vice president or 1/3 of the whole number of councillors had exercise powers under section 3, subsection 3, then the right of the president to call for the meeting would have come to an end. The president having called for these meetings prior to the vice president exercising powers on 17/3/23, the said notices are deemed to be valid in the eye of law. Having held so, the contention of Sri S. Basraj, Learned Senior Counsel, that Since the meeting has been fixed on 29/3/23, would have to be held, would result in an anomalous situation. Inasmuch as the notice of 7/3/23 and 10/3/23 being valid, held to be valid, the Vice President could not have exercised rights on 17/3/2023, calling for a meeting on 29/3/2023. In that view of the matter, the notices issued by the President being valid, though there is no particular challenge as such made to the notice issued by the Vice President, the validity of the notices issued by the President would itself amount to making the notice issued by the Vice President invalid. Answer to point number 4. The above petition has been filed on 14 March 23. A interim order has been passed on 15/3/23. Both the meetings dated 16/3/23 and 23/23 could not be held. These notices now having been held valid, there being an urgency in holding the said meetings on account of the possibility of the code of conduct being enforced from 27th March 23 has given rise to a special circumstances requiring this court to also exercise powers under section 48 of the Act of 1964 and direct the holding of the meeting by issuance of a 3 clear day notice on account of the great urgency which has arisen in the matter. As such,
Now we are date 23rd budget, 24th general meeting.
as such, ಎರಡು ಒಂದೇ ದಿನನಾ ಬೇರೆ ದಿನ?
ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ. 23rd budget meeting, 24th general.
View thereof, the order being passed today, the budget meeting is directed to be held on 23rd March 2023 as regards which Sri S. Baswaraj, 23rd March 23, and the special general meeting to be held on 24th March 2023. On both days at
11 a.m.
11 a.m. Since the counsel for the petitioner and counsel for respond number 4 have no objection for the set dates to be fixed.
No objections ಅಂತ ನನ್ನ ಕಡೆ ಕೋರ್ಟ್ ಆರ್ಡರ್
ಇಲ್ಲ ನಾವು ಹೆಂಗ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು?
ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್.
ಡೇಟ್ಗೆ
ನನ್ನ ಸರ್ ಹೆಲ್ತ್ ಅಲ್ಲ
ಅದೇ ಹೇಳಿದ್ರಲ್ಲ
ಯುಗಾದಿ ಹಬ್ಬಕ್ಕೆ ಊರಿಗೆ ಹೋಗಿ 20 ವಾಪಸ್ ಬರ್ತಾರೆ, ಅದು ಬೇರೆ ಒಂದು ಪ್ರತೀತಿ. 22nd ಇರೋದ್ರಿಂದ 24 and 25 ಅಂತ ಕರೆಕ್ಟ್ ಇರ್ತದೆ ಅಂತ. ಯಾಕಂದ್ರೆ ಹಬ್ಬ ಮಾತ್ರ
22nd ಯುಗಾದಿ
ಬೇರೆ ಡೇಟ್ ಇಲ್ಲ. 25th is holiday.
ಅಲ್ಲ 27th is the code of conduct. 25 ಆದ್ರೆ ಏನು
25th ಏನಕ್ಕೆ ಹಾಲಿಡೇ? 25th ವರ್ಕಿಂಗ್.
4th Saturday. Second and 4th Saturday.
No option about that.
ಯುಗಾದಿ ಅಲ್ಲೇ ಸೆಲೆಬ್ರೇಷನ್.
We will issue formal notice, communicating all the members.
Formal notice to be issued by respond number 5 in this regard to all the councillors.
But may I request for operative portion on
The operative portion today. The fifth respondent to act on the operative portion of the order without insisting for the entire order, as also act on a printout of the uploaded copy of the order without insisting certified copy. The Aruna Sham, the senior counsel who has entered appearance for respond number 5, who has addressed arguments for respond number 5, is the instructing counsellor. Srivatsa, who has entered appearance for respond number 5, is directed to inform the chief officer of respond number 5 of the above order and take necessary action forthwith, without waiting for a copy of the order.
Hearing are yes,
Pending IAS and
ಮಾತಾಡಿದ್ದಾರೆ 31/3/2021 31 ಗೇಟ್ ಸರ್ ಕಾಂಪ್ರಮೈಸ್ ಇದೆ.
likelihood of settlement in this matter, my lord.
Likelihood of settlement.
Settlement report ಮಾಡ್ತಾರೆ.
But
16, both the councils seek for and are granted 10 days time to report settlement released on 31/3 at 2:30 p.m.
Please.
17. Mr. Suha.
4 to 11.
Who is appearing for respond number 3 now?
4 to 11, my lord.
First 3 yarrow. 3 jana councils idare. Who appears for respond number 3?
NK Ramesh.
Madam, number 3, madam. Madam, absolutely the copy ಬಂದಿಲ್ಲ madam. NVC ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ಒಟ್ಟಿನ ಪಿಟಿಷನ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
You ಯಾರ office?
NK Ramesh.
NK Ramesh has entered appearance for respond number 3. Delete KN Puttegoda and H. Devendrappa is that appearing for respond number 3. Copy ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಇವಾಗ ಕೇಳ್ತಾರೆ ಮೊದಲು ಕೊಟ್ಟಿದ್ದೀವಿ ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡ.
NVC ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಾ ಪಿಟಿಷನ್ ಕಾಪಿ ಬಂದಿಲ್ಲ. BBMP ಇಂದ
You have sent all the papers earlier.
Impleading ಏನಿದು?
Including, my lord, these are, my lord, who are restricted now, Sakari Nagar. And, there's a park, which is, open space as of now, and a park has been allotted to the petitioner. And, we have filed a public interest litigation. And, the matter is seized by the division bench, by the justice.
I haven't been there, but a member of this club.
Not this. Not the most interesting part of it is, my lord, on 21st, court officer, please pass it on. And
I am a member of.
oh, you are, sorry, my lord.
I haven't been there.
Sorry, my lord. Then I'll withdraw my. Before someone else, my lord, that's fine.
Pose before a bench of it.
I'm sorry, my lord. Sorry, I was not able.
ಕೇಳಿಸ್ಕೊಂಡಿಲ್ಲ ಸರ್ ಸ್ವಲ್ಪ ವಯಸ್ಸಾಯ್ತು ಇಲ್ಲ ಇಲ್ಲ ನೀವು ಓದ್ತಾ ಇದ್ದೀರಿ ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ರಿಪ್ಲೈಂಗ್
18.
And be permitted to withdraw IA number 1 of 23.
Only IA you have withdrawn.
Now the problem is
Which IA you want to withdraw?
1 of 23, where they have paid off.
1 of 23. There's no 1 of 23, there's only 2 of 20. 1 of 23 is here. Counsel for the petitioner seeks permission to withdraw IA 1 of 2023, accepting his submission. IA 1 of 23 is dismissed as withdrawn. All these objections are for that only.
For that.
IA 2. Yes.
Second,
Ready?
not they have, I've received the copies. They have served the copies to me, but in that objection, no, that will not deny. That's what makes a difference.
No, now IA 1 is withdrawn, so.
The 1 of 22, that was.
23.
Please, no.
IA 2 is for production of documents.
Please.
Is there any objection on that?
No. Certain allegations are made that, no, these officers demolished the structure. Otherwise, I have no objections. In fact, the statement is also ready from my side.
Have you filed it?
And,
Now the officer is transferred, I will not think it's affidavit.
So what is to be done now?
I'm ready to argue.
But if they withdraw it, fine, my lord, I have no objections. Then.
Not the report to address the argument of something which is withdrawn. Have you filed your objections and are you ready?
Not for withdrawing the objection, they have no objection, not them.
That is over, sir. Have you filed your objection to the main?
Yes, my lord, I have filed it.
Are you ready for argument now?
They may not be because my father is not even admitted to hospital. So.
Stayed in it.
And it's not the one submissions. Since the objections are not complied on IAS, the matter being listed in the orders list, this has to be only B group.
This pertains to my lord, visa of a site. I made an application in 3/9/2020. Till now, my layout is withheld. Under extreme stress, my lord. Short date.
From 2020.
2020.
Lord, we have filed a report, my lord. Still development has to be done by the petitioner.
I accept the report.
We have filed reports. Still entirely they are not developed. It was done.
Accept report, Allah, duddu, money for that. I'm ready to deposit money.
How
much is the cost?
17 lakhs in order.
17 lakhs is a penalty that they've imposed. As per what they've said, I've not done. It's a soak pit for 1.5 lakhs. And they've said, I've not put the fencing. Fencing will cost me 20,000. And they've said
20,000.
for a park. For a park, not for the entire layout. For the park.
Not civic community sites, they are not really, and overhead tanks that are not being completely built. We have filed a detailed report, my lord.
And one submission that I would make. Not,
Mr. Ponnappa, be very clear. I'm very clear, my lord. If we find things which are not done. No, my lord. I'm very clear. That's why I've said I've not. What they have said in the report is I've not done. But there are reasons I've explained also.
So do it now.
It is there, my lord. On record, I've explained. And I am not in a position to do that. So I'm saying I will deposit the money, whatever is there. Because as per the act, you have to carry out. For 1 crore, I carry out the entire development. Why will I not carry out for 2.5 lakhs, my lord? One soak pit, one fencing, and one footpath. Layout is entirely developed. Roads are formed, parks are relinquished, CS sites are relinquished. Will I not do a soak pit, my lord?
What are the things pending?
not I. Of the officer. Not, they have formed a temple there in site number 122, 123, 124. Right. That is not.
Did you file the report, Mr.
Report was filed on
23rd, my lord. 23rd February.
3rd February.
Yes, my lord.
What has not done?
The last page.
The last page, from I'll read it from para 4, my lord. What they have not done. ವಿರಾವಣ ಉದ್ಯಾನವನ ಜಾಗನ ಪರಿಸ್ಥಿತಿ ಕೆಳಕಂಡ ಅಂಶ ಗಮನಿಸಲಾಗಿದೆ. ಅನುಮೋದಿತ ವಿನ್ಯಾಸದಂತೆ ಅಳವಡಿಸಿರುವ ಉದ್ಯಾನವನಗಳ ಪೈಕಿ ನಕ್ಷಲಿ ಗುರುತಿಸುವಂತೆ ಉದ್ಯಾನ ಒಂದು ಪೈಕಿ ಫೆನ್ಸಿಂಗ್ ನಿರ್ಮಿಸಿದ್ದು, ಮರಗಳನ್ನು ಬೆಳೆಸುವ ಕೆಲವು ಗಿಡ ನೆಟ್ಟು ಆಸನಗಳು ಅಳವಡಿಸಲಾಗಿದೆ. ಉಳಿದಂತೆ ಉದ್ಯಾನವನ್ನು ಸಂಪೂರ್ಣ ಅಭಿವೃದ್ಧಿ page 4 in Roman 4 million. ಉದ್ಯಾನವನ ಅಭಿವೃದ್ಧಿ. All this ನೀರು ಸರಬರಾಜು ಒಳಚರಂಡಿ, STP has also not been done.
ನೀರು ಸರಬರಾಜು
ಒಳಚರಂಡಿ ಉದ್ಯಾನವನ ಅಭಿವೃದ್ಧಿ, that has also not been fully done. And we have affixed the photographs and mark the which portion has been developed and which has not been done in the entire.
overhead tank illa.
Overhead tank is there, my lord. I have not given the water connection. The reason being, my lord, the overhead tank is for 2 lakh liters of water. As of now,
We'll pass the order and won't give you this.
no, sir. There is a borewell connection also. The problem is there are only 4 residents. If I store water in the tank and supply, they come to stagnation. That's why for now I have given them direct connection from the borewell. The tank is there, the pictures also they have produced. Because 60% of the sites was released earlier and they are residing there.
The connection has to be given, whether you close it or not, we'll see that later.
Connection is there, my lords. The connection is there. Only the water is not being stored in the overhead tank.
There is no Bobby borewells illa antane ide.
No connection at all.
There is no water. STP also not been provided.
That's mandatory requirement. STP is not
The
provided there.
effluents lage biಡ್ತಾರೆ.
How will people stay there?
My lords, the soak pit is there. I've said in my affidavit, it has been demolished. Now, my lords, there are 3 survey reports ordered by this honorable court. If I only take to the facts of this case. In 3/9/2020, I approached the authority saying my layout is complete. Please release the sites. For 1 year, there is no response from their end. So on 13/9/2021, I approached this honorable court. As per the requirements of section 17 of the act, all that I am required to do is give NOCs from the concerned departments. All those NOCs are given. Then for the first time, they respond to my application for release of site by way of objections in the writ petition. Various allegations were made. They were reckless in nature. So the coordinate bench ordered a survey. They carried out a survey, issued 2 reports. On the day of survey, at page 188, 189 of the writ petition. Annexure AE.
189. Yes.
Translated copies at page 191.
Yes.
The last portion, they have not made any of this. They said it is as per the sanction. Where does it say so?
Type copy 191.
191 is the type.
191 AF. Third paragraph. Only they say that it is not fully developed.
He only says, I have to develop trees, plant trees. That is the only observation that is made.
So fresh order was made for the assistant director of town planning.
India needed a Civic communities has not been provided. Nagarika Solabhu. Civic community is there. Saria. Civic community is there.
After that, another report was called out from this honorable court. This report was filed by the commissioner. Then assistant director of town and country plan has directed. That is the report which is on 23rd. It says,
there is one more report. This report was filed. Then he issues me another report at next year, day of the restriction, imposing various penalties and all that, alleging delay on my end. I have challenged that report before this honorable court. At annexure A, page 29 on. Page 35 onwards are the observations. They are in
35 of?
35 of the rectification. His observations, the third paragraph. ಅದರಿ ಪುಷ್ಕರಣಿಯನ್ನು ಅಭಿಪ್ರಾಯಿಸುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಅದರಿಂದ ಪುಷ್ಕರಣಿಯನ್ನು ಅಭಿಪ್ರಾಯಪಡಿಸುವುದು 3 ಮೀಟರ್ ಹಸಿರು ಪಟ್ಟಿಯ ಒತ್ತುವರಿ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು 3 ಮೀಟರ್ ಅಗಲದ ಸಂಪೂರ್ಣ ಹಸಿರು ಪಟ್ಟಿಗೆ ನಿರ್ಮಿಸಿರುವ ತಡೆಗೋಡೆಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಅನುಮೋದಿತ ನಕ್ಷೆಯಂತೆ 3 ಮೀಟರ್ ಅಗಲದ ಹಸಿರು ಪಟ್ಟಿ ಕಡ್ಡಾಯವಾಗಿ ಕಾಯ್ದಿರಿಸುವುದು ಸದರಿ ನಾಗರಿಕ ಸೌಲಭ್ಯ ನಿವೇಶನ ತಂತಿ ಬೇಲಿ ನಿರ್ಮಿಸಿ ಭದ್ರಗೊಳಿಸಬೇಕಾಗಿರುತ್ತದೆ. In point number 15, he imposes a fine on it. Yes. There is no pushkarani in the village map. There is no pushkarani in my commencement certificate. If they ask me to develop a non-existent pushkarani, it is impossible for me. Now, because I have challenged this report and it was heavily contested, the court ordered another survey. Nothing is mentioned about this pushkarani. Nothing is mentioned about the 3-meter buffer zone. Nothing is mentioned about the Taregode.
Is there a temple for a pushkarani to be there?
Not existence, it is in existence. They don't deny that. I have filed my photographs there for statement.
Even the temple, it is not there in the village map. There was some Nagara Kallugalu. I relocate them. He said, why did you relocate? The respondent number 2. Now I bring it back to its own position. He says, you are constructing a temple.
Not pursuant to the order of the Honorable Court, not to conduct the spot inspection. Not in the spot inspection, not that is, not what all the defects are there, what are the, not things which has to proceed with, so that not the layout is in conformity with the approved plan. Not thereafter, after the survey is being conducted, the report is being done. Not the site number 121, 122, 123, 124, these are the sites. Have been all they've been demolished and made into one composite and temple is built there. Kindly take from the photographs. This is not permitted under the layout. Because the sites. Unless because you withdrew this, I did not. Because the statement which I collected ready since he withdrew it, I did not file this. This is one after the survey report called by the Honorable Court. After that, he has done this. Keeps on doing lots of things. How do we not be?
No, they said I have removed the temple. Now the temple comes back to the original position. They said you are constructing a temple.
Done in the sites.
I've given the site numbers also there. Survey, spot inspection ಮಾಡಿದ ನಂತರ ಇದು ಮಾಡಿದ್ದಾರೆ ಇವರಿಗೆ. I've given the date also there. Not if this thing, how do you order? These are the sites, all 4, 5 sites are there.
But this is being done only on one side.
No, it's entire site, composite site, all the sites.
One side. My lord might see.
One side.
Kindly see the photograph, entire thing is demolished there, it's being made a plane. Kindly, I've given the site numbers also in fact.
There's a boundary which is the foundation.
Yeah, I do agree that, but it has been not the entire, the chambers and everything been leveled there, and all one has been done as in one. Kindly not appreciate that fact.
Chambers are on the left side, not on the right.
Ikade chamber, because it's a huge site. These are the sites of 30, 40 dimension sites. Sir, nantra madakuttada idu. Ee tara madidre this is not.
What are the things which are remaining to be done?
I will note it is in terms of the report that is called by the Honorable Court. It has to be done by him.
This way it will keep on happening.
I would.
So what
in fact I had given them.
What you do is you say what are the things to be done which will not be done. Put a money to that. We'll ask them to pay it to you.
That is what I'm keeping telling them. They're not ready in fact.
Now
one thing. Second point, my lord, there is a delay on their part in not completing the project in time in terms of notice in 2018. If they don't complete it, my lord, penalty of 3% is attracted. That's what the calculation has been now to 17 lakhs. That is the notification which they have not done. They don't challenge notification, but they come and say that no, we don't file.
There appears to be more to it than meets the eye. The kind of objection that you are raising
It is not the notification says so.
In fact, they don't get 5 crore compensation be given to me by them.
They were exempted.
You want us to go to the depths of it, we'll go to the depths of it.
They were exempted for 1 year. If the layout is not developed within a particular period of time, if it is done after that, they have to not pay the penalty. That's what the section says under the
You want us to go to the depth of it, we'll go through that.
That's not, this has to be not heard.
Then there may be something which will come up against your officers.
That's what I wanted to,
What you see here doesn't appear to be the way that it would normally have to happen.
ಇದು ಇಲ್ಲಿ ಒಂದೇ ಆಫೀಸರ್ ಎಲ್ಲಾ ವರ್ಷ ಇಲ್ಲ 3 ತಿಂಗಳು ಒಬ್ಬ ಆಫೀಸರ್ ಚೇಂಜ್ ಆಗ ಹಂಗಾಗಿ
ಅದಕ್ಕೆ 3 ತಿಂಗಳು ಒಂದೊಂದು ಪಾಯಿಂಟ್ ಬರುತ್ತೆ.
ಇಲ್ಲ ಹಾಗೇನಿಲ್ಲ. ನಾನು ಯಾಕೆ ಹೇಳಿದೆ ಅಂತಂದ್ರೆ because if at all something he had there in his mind, not I understand. Now they have lodged a complaint to the Lokaयुक्त also saying that the demand under this petition is 17 lakhs. They allege that I have demanded 1.5 crores. Where the this shows their
that is based on the layout value, not on city value.
18 ಲಕ್ಷ ಡಿಮಾಂಡ್.
You want to wait for that report?
ನಾನು ಹೇಳ್ತಾರೆ ನಮಗೆ
one more
what extent they are going for that ಡಿಮಾಂಡ್ ಇರೋದು 18 ಲಕ್ಷಕ್ಕೆ 1.5 ಕೋಟಿ ನಾವು ಡಿಮಾಂಡ್ ಮಾಡಿದ್ವಿ ಕೇಳ್ತಾರೆ ಅವರು.
Ramesh, it is not that.
And I'll that is there on the in the report called by the Honorable Court.
You have been raising one issue after the other for the last 2 years, only depriving them of the completion.
No, it is not that.
What reason is very clear.
I'll call the officer to return because again the new officer is now there since the election transfers. I'll call him and I'm not. I'll do that.
Later. Now you first file a report. What are the things not to be done? What is the amount? And that is the final report.
Right. That's what I keep telling them from the beginning. Like, why don't you? I just need because 1 week because since father then
1 week.
2 weeks time.
And you also get instruction that if they pay that amount, by when will you release the sites?
That I kept on telling him from the beginning, not now.
Manoj, work as per the latest report sought by the court because if they add additional work, because there is a report filed.
Punappa, you have got into quicksand here. Try and get out of it. Ramesh Kumar, Lieutenant Counsel, appearing for respond number 2, seeks for and is granted 1 week's time to place on record the works which are allegedly not completed by the petitioner, with a quantification of the amounts required to complete the said works, which the respondent number 2 will carry out if payment is made by the petitioner. Released on 30th.
They have to do it.
38 provides for you to complete. Okay, this has been going on for last 4 reports.
We have come after 10 years, my lord.
So now you complete it, finish it.
My request for 29.
29. 29 till 30th or 31st?
31st, my lord.
31st.
I withdraw this. I filed it.
Okay.
Registrar General. Notary.
The registrar, a report of the Registrar General has been filed. The same is taken on notice.
Thank you. MD Keshav Reddy.
The petition. Arthur directed not to disperse the price amount. At 1 o'clock, that already is already dispersed. That is not coming. I'll make it.
It's not already.
Not on that. It is not mentioned in the order. Yeah, God. Now it is been done on 27 to 23.
File necessary application.
Will not survive because before filing we already dispersed the account.
But it is in the account of the Gram Panchayat. We will make an application, let them deposit the Gram Panchayat, we deposit before dishonorable court. And we will include the Gram Panchayat by serving them a copy of the repetition.
Gram Panchayat is not a party?
No, Maharaj.
However,
Direction of
price distribution is on 24th of this.
Jilla
Panchayat is a party. Respondent number 3.
Correct, Maharaj. We will serve a copy of the repetition also fast letter.
Not says that it is not at all disposable.
The whole purpose will be lost, Mr. Mithra. If you do like
Then my lord make a mention only in respect of the petitioners. It will be, because we are making a price distribution on 24th. It will come in the way. This order may come in the way.
Only start
enter statement.
Present petitioner, Maharaj.
what is the incentive for a Gram Panchayat to do his work? Here's the prices that you are paying. One sati or one, if they get the prize once, they'll not be eligible for the prize at all. They'll stop doing that work.
That is issued at least prior to the submission of the forms, probably. I'm for the Gram Panchayat, but that letter circular which was issued was subsequent to the selection process also, my lord. So probably might not stand the.
Because the selection process are already heard in the month of December only.
I can only act as per the government.
So page 26, Maharaj, I was declared as the highest scoring Gram Panchayat for the said Taluk, Maharaj. Subsequently, they issue a note circular stating that
It is on
they are not
21,
eligible.
23, circulars come. May make a submission that this interim order will not come in the way of the distribution of the other this award is there.
When you once distribute Marmita, then what will?
Not with respect to this petitioners, petitioner Gram Panchayat.
You'll give them a special prize.
Because every time we installed Milan, entire state will be having that ramification.
If you are going to give them a special prize, they'll be acceptable.
Because it will be inadvertently affect the other awards also.
Consistency, one prize for them.
Well, I agree, Mr. That
If they go on performing well,
I agree, Milord.
you should encourage this.
There should be a special mentioning of this.
Yes,
Milord, I
will record it, they'll be happy with that. They want recognition for what they've done. They want recognition for what they've done. And they worked hard for it.
I agree, Milord. We'll hold this particular Gram Panchayat will not disperse, Milord. Any award amount also not, prizes all not.
Even if you give an award to whoever you selected,
No.
if you give them also one award, they'll be happy.
Recognition cannot be within the doors, my lords. The recognition cannot be within the doors. It's got to be along with the others. I mean,
Yes.
being fair to the petitioner.
So they've done their work, so recognize them. Give a recognition apart from the other person. So consistently and in special mention.
That will consider in you. I agree, Milord.
get instructions, we'll record that and we'll dispose of it. Sir, it will come in your way.
And not make a application that will distribute the amount. What will happen, my lord? If this the particular Gram Panchayati will not dispute amount also, totally also. Particular Gram Panchayat. Because function is on 24th.
ನಾವು ಹೇಳಿದ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
Got it, my lord.
ಅಲ್ಲೇ ಮುಗಿಯುತ್ತೆ ಅಂತ.
Mainly pass over.
ಇಲ್ಲಾದ್ರೆ once we pass over.
Yes. 13.
Preparing for the petition. PL pending.
Parcel for the petition. Public interest litigation is still pending. Released on 14th August. Interim order earlier granted to the expensive.
21. Seshagiri Rao.
Number 4.
What is permission to prosecute? Permission to prosecute.
Some person has passed over. ಬಂದಿದೆ permission to prosecute ಯಾಕೆ ಹಾಕಿದೀವಿ ಅಂತ an application has been made.
We'll allow this application, Mr. IA 1 of 32 has been filed by petitioner 1 to 3, seeking permission to prosecute the above matter since the original petition number 1A expired on 15/9/2020. Accepting the said, accepting the contents of the affidavit in support of said application, IA 1 of 22 is allowed. The petitioner is permitted to prosecute the matter. The NNRH seeks to and is granted
1 week.
a week's time. You want to file your objections or you want to file a statement of objection? Objections, if any, by 29th, released on 31st.
The writ papers we ordered to be.
They just need to put up the WP number.
WP number.
WP number. So, witness in WP. 22.
Government advocate.
The petitioner's lands had been reserved for public and semi.
GA accepts notice for respond number 5 and 6 also.
The petitioner's lands were reserved for public and semi-public purpose. That is CDP. After the expiry of 5 years, if the lots were to turn to page number 47.
47.
Yes. By an order dated 9/8/2018, the lapsing was noted. And these lands were permitted to be used for residential purposes.
Where is the lapsing?
Not second paragraph. After the reference, second paragraph. Sadri ಜಮೀನಿನ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಪ್ರದೇಶವು ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಂಡ ಮಹಾಯೋಜನೆಯಲ್ಲಿ ಉದ್ಯಾನ ಬಯಲು ಜಾಗ ವಲಯದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ. ಸದರಿ ಜಮೀನಲ್ಲಿ ವಸತಿ ನಿವೇಶನ ಮಾಡುವುದರಿಂದ ಸಾಗರ ಪಟ್ಟಣದ ಅಭಿವೃದ್ಧಿ ಹೊಂದಲು ಸಾರ್ವಜನಿಕ ವಹಿವಾಟಿಗೆ ಅನುಕೂಲವಾಗುವುದರಿಂದ ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿ ಹೊಂದಿರುತ್ತದೆ. ಸರ್ಕಾರದಿಂದ ಅನುಮೋದನೆಯಾದ ಮಹಾಯೋಜನೆಯಲ್ಲಿ ಸದರಿ ಪ್ರದೇಶವು ಸಾರ್ವಜನಿಕ ಮತ್ತೆ ಅರೆ ಸಾರ್ವಜನಿಕ ವಲಯದಿಂದ ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದ್ದು ಸೋನ್ಸೋ ಕಾಯ್ದೆ 69(2) ನಿಗದಿತ 5 ವರ್ಷಗಳ ಅವಧಿಯಲ್ಲಿ ಭೂ ಉಪಯೋಗವಾಗದಂತೆ ಪ್ರಾಧಿಕಾರ ಭೂ ಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಲು ವಿಫಲವಾದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಿದ ಭೂ ಉಪಯೋಗ ರದ್ದಾಗುತ್ತದೆ. ಸದರಿ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರ ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಕಾಯ್ದಂತೆ ಭೂ ಸ್ವಾಧೀನ.
When did the RMP or CDP come in force?
Not sir, this had come into force in 2008, not is what I am informed. Yesterday I had informed that date, 2008 that CDP had come.
ಎಲ್ಲಿಂದ ಜಾಗ ಇದು? Where is the location?
This is in Sagar, Shimoga. Sagar Taluka of Shimoga district.
So needle ಬಂದಿತ್ತಾ CDP?
Now after this they have collected even the amounts which is not in dispute. About 1,75,000 rupees for each one of the lands they have collected.
Yes.
I have made an application seeking conversion, which your lordships will find at annexure D1, page 55. Annexure D series of the application seeking conversion on 10/7/2019.
Yes.
Towards the, if your lordships were to see, the caption on the left-hand side, it says deemed conversion. At annexure D1, there is a reference, it's called as deemed conversion. But the reason why it is referred to as deemed conversion is because after the insertion of proviso to section 95(2) in the year 2018, now there is a deemed conversion wherever the concerned land use is permitted. Therefore, the amount has been collected as deemed conversion. But now for issuance of the conversion orders, there are circulars which is regulated between the intersect between the town planning department and as well as the revenue authorities.
Deemed conversion.
Kindly have a look at this, the proviso.
We'll have a look at it, but from what we understand, it's for what is shown in the RMP.
What's shown in the RMP?
So in the RMP, public, semi-public.
Now that
So
is.
if you want to change of land use.
Yes.
Or conversion to that purpose, then no early fine is to be paid.
Yes, now what they are now.
You want it now for residential.
Now residential. Now they are now, yes, now they are, now the conversion application is pending, every report is set up. Now only thing which is remaining is an NOC which is required to be issued by the planning authority. Now planning authority says, now we have started the process of acquiring the properties. Proposals are sent for the purpose of acquisition of these properties because this is the only piece of property which is in the middle of this sagar for the purpose of public and semi-public purposes. So therefore, we are not issuing the NOC. That's all what they have stated. But so far as conversion is concerned, it is an automated process which has to take place if there are no other impediments. In view of the annexure C series which I have now referred at page 47, conversion may not has to happen. Ultimately, if they acquire the property, they'll pay the compensation in terms of the converted property. Probably that's what they don't want to pay me. As a matter of fact, this honorable court dealt with a similar situation where even a preliminary notification is issued. Consistent view expressed by the honorable court is that even if there is a preliminary notification, conversion should be granted.
That is there, but this can't be deemed conversion.
Because the proviso says that, of course,
not tenure to your benefit.
now, if the lapsing takes place by virtue of the operation of section 69(2), and by orders of the competent authority of the town planning authority, if this land has already been designated for residential purposes, they should also be deemed to be the purpose for which it is reserved in the RMP, because it's by virtue of the orders.
Where is it designated for residential purpose?
Pardon?
Where is it designated for residential purpose?
Under this order, circulars, annexure C itself.
Can it be done like this?
It is lapsed, once it is lapsed.
Lapsing the.
Yes, this is by the competent authority. This is by the commissioner who has passed an order. Can you have a look at page 48?
Yes.
The operative portion on 9/8/2018. But after referring to all these survey numbers, Vairappa ವಿ ನಾಗಪ್ಪ ಪ್ರದೇಶವು ಉದ್ಯಾನವನ ಬಯಲು ಜಾಗದ ವಲಯದಿಂದ ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. After reference to that 17 guntas, ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 7/5 5 ಗುಂಟೆ, Vairappa ವಿ ನಾಗಪ್ಪ ಪ್ರದೇಶವು ಉದ್ಯಾನವನ.
Like this. You cannot do it like this.
That they have done it. That is not under challenge by any person.
We are challenging. When we find something wrong, we can.
No, certainly not. 1,75,740 rupees has been collected. Whether it is residential or otherwise, I have sought for a conversion.
How to do this, Mr. Gide, your client has issued.
No. This,
You are appearing for whom?
I appear for the CMC, fourth respondent.
There is a town planning authority.
By statement.
Who is appearing for town planning authority?
That is fourth respondent.
Fourth respondent is commissioner. You appear for whom, Mr. Gide?
Fourth respondent, the commissioner, member secretary, town planning
Town
authority.
planning, this is your client only who has issued.
There seems to be some lapse, not in this order, but subsequently, proceedings have been initiated for acquisition of this land, including this land. 61 acres are proposed for acquisition.
It anyway is beyond 5 years. We are only concerned, can you designate by an office order particular land from public, semi-public to residential without inviting public, without following section 14. If power is given to your officers, you will designate anything to anything. By just collecting 1,75,740.
Not that there are various other lands also, my lord, adjoining lands also.
Yes.
There also, my lord, they have collected the amount.
I think
This is pertaining to about 7 acres. They have actually converted about 60 acres in north. But most of the properties have given NOC and they have been converted.
That may not be correct, my lord. We have.
They have the power to do this, which you are relying on for
They will have the power. The reason being this. Once it lapses under section 69(2), there is no designation for those properties.
Yes.
So once there is no designation for the properties, the commissioner will be the competent authority for that purpose.
So it
Commissioners passed an
the
order.
power shows. Which section?
Sorry.
6900.
Section 69(2), there is a deemed lapsing.
Yes, but where is the power to designate?
I just indicate.
This subsection 3 of section 69 which has to be followed. Subsection 3 of section 69. Subsection 3. Has that been followed here?
Amendment is 14(2) and 69(3). This has been done, so that information can be gathered. I can get that information. Because
to place it
the
on
order
record.
refers to, if your lordship were to see, the order refers to the report, the second paragraph. Patrika Prakatane agide, page 60, annexure C1, page 47. ಅಧಿಕಾರ ಮನವಿ ದಿನಾಂಕ 25/1/2016 ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ಸಾಗರ್ ಸಂದೇಶ ದಿನಾಂಕ ಸೊ ಪ್ರಾಧಿಕಾರವು ಸಭೆಯ ದಿನಾಂಕ 9/1/2018 ನಿರ್ಣಯ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ so procedure is because I am not saying that I will use this property. Ultimately, if I go for the planning purposes, they may refuse. But what I am now requesting is let them give me an NOC for the purpose, limited purpose of conversion of the property to residential. If ultimately they acquire the property, you know, it's, of course, eminent domain can be exercised at any time.
That they will have, not on that. Today, whether the requirements of subsection 3 have been satisfied.
Yes, Lord. Both these ingredients are forthcoming. If your lordship is going to see annexure C1.
Now, if you have designated it to residential, then the proviso to 95 to.
But annexure R1 may kindly be similar. I have filed my statement of objection. The deputy commissioner, my lord, has directed the respondent number 4, my lord, not to issue NOC till a final report is received.
Final report on what?
Lord, ಸಾಗರ ನಗರಸಭೆ ರವರು ಸಾಗರ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯ ಚಂದ್ರಮಾನಕೊಪ್ಪಲು ಗ್ರಾಮ ಸಭೆ ನಂಬರ್ ಸೊ ಭೂ ಪ್ರದೇಶದಲ್ಲಿ ಜಮೀನಿನ ಮಾಲೀಕರು ವಸತಿ ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಉದ್ದೇಶಿಸುವ ಸದರಿ ಭೂ ಪ್ರದೇಶವು ತಗ್ಗು ಪ್ರದೇಶವಾಗಿದ್ದು ಮಳೆಗಾಲದಲ್ಲಿ ನೀರು ನುಗ್ಗುವ ಸಂಭವ ಇರುವುದರಿಂದ ಇಲ್ಲಿ ವಸತಿ ವಿನ್ಯಾಸ ನಿರ್ಮಿಸಬಹುದೇ ಎಂಬ ಬಗ್ಗೆ NOC ನೀಡುವ ಕುರಿತು ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ವರದಿಯನ್ನು ಅನುಸರಿಸಿ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ನಿರ್ದೇಶನ ಕೋರಿರುತ್ತೀರಿ. ಈ ಕುರಿತು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು PWD ರವರಿಂದ ಸಮಗ್ರ ಪರಿಶೀಲನಾ ವರದಿ ಪಡೆದು ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವುದು ಅಲ್ಲದೆ ಅಂತಿಮ ವರದಿ ನೀಡುವವರೆಗೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ NOC ನೀಡಲು ತಾತ್ಕಾಲಿಕ ತಡೆ ಹಿಡಿಯಲು ನಿರ್ದೇಶಿಸಿದೆ.
But they should have done it when public notice was issued. When subsection 3 of 69 was followed.
Yes,
they should have done that at that time. They kept quiet at that time.
This is subsequent to annexure C, my lord, page 47. which my learned friend referred to. Annexure C1, page 47 is dated 9/8/2018.
The paper publication was on 6/3/2017.
Please,
So they should have objected to it. This is 1/7/2019.
yes, my lord. Annexure R1 is subsequently issued, my lord, by the deputy commissioner.
They are not having objection at that time, they've lost their right.
Based on this, my lord, the NOC was not issued, my lord, I have said in my objection. And subsequently, further proceedings have taken place. In 21 also, my lord, the matter has been proposed for acquisition, and the deputy commissioner, the assistant commissioner has been called upon to
Acquisition for what purpose now?
for the purpose of constructing a sports complex, park, and public infrastructure facilities to the public, general public.
Look at your deputy commissioner. Taggu Neeru Adanne Yoga Stadium.
If it is taken up, whatever
They will also do it.
for residential
Only you will do it and they can't do it.
possible, my lord. It is nothing like impossible.
Well, look at the kind of things that you are.
No, not
They
only
don't object to the 69. ಆಮೇಲೆ ತಗ್ಗು ನೀರು ನಿಲ್ಲತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ.
This is by the side of Varada River, my lord. This area is just by the side of Varada River.
Same thing applies to you. Can you build a sports complex beside a Varda river? Or are those sites of sports complex?
For both the same yardstick could apply. The risk of life risk is more in case of a residential layout. If it is flooding and other things.
That when they come for the plan sanction, you can reject that.
They are serious about it. Conversion will in no way take me any further. At the most, I can say this.
You already designated.
Yes.
Once you are designated it, you can't say. Then the petitioner is before this court seeking for the following relief. The petitioner came to the owner of survey number 7-30, Chandra Mavina Populu in Sagara town. The land of the petitioner was earlier designated for the purpose of open space and green belt. Open space and green belt, Mr.
Green zone, open space and green zone. There is no green belt in this. It's a green zone. As for park.
Your para 2 says green belt.
The park zone, open space to residential. The green space. Actually, it's a park area, it was designated. Green belt and gray.
Where is the plan?
It is referred to in that order itself at page 47. May I just refer, that Vishaya, just 3 lines from the bottom. Vairappa bin Nagappa, Chinnamana Koppulu, Sagara Pradeshu, Vistiranada Pradeshu, Udyanavana, Bailu Jaga.
Open space.
Open space and these parks are denoted by the green space. Udyanavana, Bailu Jaga. Park and open space. It was designated for park and open space.
Parks and open spaces. In the year 2008, the same not having been acquired in terms of subsection 1 of section 69. The reservation having lapsed. An application is submitted by the petitioners for reclassification of the land as residential, which was so reclassified on 9/8/2018. Thereafter, the petitioners have submitted an application under section 95 of the Land Revenue Act, seeking for conversion of the land from the earlier agriculture to non-agricultural residential purposes, as regards which the no objection was not issued by respondent number 4. And it is in that background that the office of release has been sought for. If DR revision to let the counsel for the petitioner would submit that once the land which had been designated for a particular purpose in the master plan, in terms of subsection 12, in terms of section 12 of the Town and Country Planning Act, and the said public purpose and in furtherance thereof, not acquired in the subsection 1 of section 69, the same would lapse, thereby conferring a right on the landowner to seek for both conversion and change of land use. The respondent cannot hold back a no objection certificate in this regard, and in that background, a mandamus is required to be granted. So Vishwanath Hegde, learned counsel appearing for respondent number 4, would submit that on the basis of a letter issued by the Deputy Commissioner on 1/7/2019, wherein the Deputy Commissioner has observed that the lands in survey number 7, 8, 9, and 13 being a low-lying area, there is a possibility of water stagnation, and as such the same should not be permitted to be used for residential purposes. That apart, he submits that the respondent number 4, respondent number CMCL.
Because response 2 and respondent number.
Who has initiated that? CMC is not a party.
CMC is not a party.
That CMC, Tadara has now initiated a proceeding for acquisition of the land for establishment of a stadium,
Sports complex,
sports complex,
park and other amenities.
park and other amenities. And since the said acquisition process is commenced, the change of land use cannot be done. And in that background, no objections have not been issued. Correct. Third, so and so produce papers. In terms of section 12 of the Karnataka Town and Country Planning Act 1961, in the master plan, which is prepared by the concerned town planning authority, there are various areas which are required to be earmarked. Section 12 is reproduced hereunder for easy. The earmarking of a particular area relating to a private person imposes a restriction on the landowner from making use of the land for otherwise than for which it is earmarked in the master plan. It is for that reason that a corresponding obligation has been imposed on the planning authority across the state to acquire the land designated in the master plan for public purposes in terms of section 69 of the Act of 1965. Section 69 is reproduced hereunder for easy reference. Section 69 imposes an obligation on the planning authority to acquire the land designated in the master plan for public purposes by agreement or exercising rights under the right to fair compensation, transparency in land acquisition, Rehabilitation Resettlement Act 2013. This acquisition to be made within a period of 5 years from the date of such designation in the master plan. In terms of subsection 2 of section 69, the land designated for public purpose under subsection 1 of section 12, except clause B thereof, would lapse within a period of 5 years. Clause B of subsection 1 of section 12 deals with complete street pattern indicating major and minor roads, national highways and state highways, and traffic circulation, etc. That is, apart from a designation in terms of clause B of subsection 1 of section 12, any other reservation made under section 12 for public purpose, more particularly under clause C of subsection 1 of section 12, would lapse if the same is not acquired by the planning authority within a period of 5 years. In the present case, admittedly, the land of the petitioner was designated for public and open spaces, which is a reservation in the subsection C, as clause C of subsection 1 of section 12. The land admittedly not having been acquired by 2013, the period of 5 years having lapsed, the designation having lapsed, the landowner had a right in terms of subsection 3 of section 69 to seek for designation of said land to another purpose by making necessary application thereunder. In terms of subsection 3, on an application being made, advertisement, a public notice was admittedly taken out by respondent number 4 on 6/3/2017. No objections have been received thereto. The application of the petitioner submitted on 25/1/2016 was considered by respondent number 4 in its meeting on 9/1/2018, and the said land designated for residential purposes by collecting necessary amount. Once the said land, the designated purpose has lapsed and the said land is designated for a different purpose, it is this different purpose which is what is to be held to be the designated purpose under the master plan or the development plan. As on the date on which an application for conversion has been made by the petitioner, the said land has been reserved for residential purposes in terms of clause A of subsection 1 of section 12. In terms of section 95 of the Karnataka Land Revenue Act, any land which is designated for agriculture purposes can be delineated for non-agriculture purposes. In terms of proviso to subsection 2 of section 95, if an agricultural land held comes under the local planning authority and the master plan designates the use of the land for a particular purpose, the permission for conversion is deemed to have been granted subject to payment of fine prescribed under subsection 7 of section 95. The proviso, subsection 2 and the proviso thereof of section 95 is hereunder reproduced for easy reference. In view of the above, the land of the petitioner now being designated for residential purposes, an application for conversion having been made by the petitioner, the said conversion application would have to be considered in terms of the present designation of the land as residential. And the procedure prescribed and provisional to subsection 2 of section 95 be followed by the planning authority. Insofar as the objection raised by the deputy commissioner as regards the land being situated, being a low-lying area which cannot be used for residential purposes, the same would only arise for consideration once an application for plan sanction or layout plan sanction is made by the petitioner, which could be considered by the planning authority. In view of the above, I pass the following on. The petition is allowed. A mandate is issued directing the respondent number to issue necessary no objection to the petitioner for the purpose of conversion in terms of the designation of land as residential as observed here and above. Within a period of
2 weeks, 4 weeks.
4 weeks from the date of receipt of a copy.
Even this could not, because of the election process, none of the officers are available.
8 weeks from the date of receipt.
Grateful with us.
Bill number 20, Rashid Khan.
Wait for the second respondent. Wait for 10 days after time.
Russia ಏನೋ ಕೇಳಿದ್ದೀರಾ
It has not been issued as a converted land. A partition has been made between the family members after conversion. So whatever share, plan to share of the petitioner, I made an application, necessary application for paying necessary fees for effecting kata in my name. The converted land.
Even an endorsement saying about that kata cannot be effected in respect of a portion of the land that was bifurcated, because it is contrary to one of the terms and conditions of the.
So you issue notice to them. We'll reserve your right to issue notice to them and process it. Like what we do for Kodi Prati, Kodi Durasti.
On their application, not the
You issue ಕಷ್ಟಪಟ್ಟು partition ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ಮತ್ತೆ ಅವರು ಬರಲ್ಲ. You issue notice to them. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the petitioner having acquired title to a portion of the land in survey number 41/1, measuring approximately 10,000 square feet, on an application being made, wide a partition deed, on an application being made for issuance of kata, the respondent number 2 has issued the impugn endorsement stating that partial kata cannot be issued and an application has to be made by all the landowners of that particular survey number. Correct. The petitioner, admittedly, there is a partition deed which has been executed between the petitioner and his family members as regards 1 acre 24 guntas in survey number 41/1, which has been converted for residential purposes. Such being the case, the respondent could always have issued notices to the other claimants under the partition deed before effecting the kata in favor of the petitioner after allotting of sub numbers to the properties. In view thereof, I pass the following order. Petition is allowed. Respondents are permitted to issue notice to the other sharers under the partition deed. Carry out necessary what is that called for? Demarcation of the properties falling to the share of the different parties, assigning new municipal numbers thereof, and thereafter assign katas to the respective owners.
Conditions for motion order. The condition was that the layout plan has to be approved by the.
Layout plan, if they form a layout for sale to third parties, if there is internal division between the family members, layout plan in effect. There's a road, they'll surrender it. Is a road and a road, needless to say that in any passage or road between the properties assigned to any of the sharers shall be surrendered to the corporation. You want to implement?
One of the land.
Okay.
One of the land.
Owner of the land, you.
Impugned order line notice ಇದೆ ನಮ್ಮ ಪಿಟಿಷನ್ ಹಾಕಿ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಆಗಿದೆ ಪ್ಯಾರಾ ನಂಬರ್ 7 ತಗೊಳ್ಳಿ impugned order
Page.
Page 9. Page 8 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
8 ಇಲ್ಲ ಇಲ್ಲಿ.
The number which is
Page number. Starts at
running page
number 8.
petition page number 8.
ಪಿಟಿಷನ್ ಅಲ್ಲೇ running page
In page 12. 12, yes.
The writ petition number 4444/2000 filed by Virupaksha Vadaya Mutt in Bairamangala represented by Matadipati Virupaksha Vadaya in Ramnagar Taluk against the administrator DBMP commissioner DBMP DAGP present appellate Srimati Parvatama against whom a provisional order has been provisional order confirmation order. We are the owner of the.
You are
As on the date of passing, my lord. We are the owner of the submission. Property. As on the date of order, property belongs.
wants an adjournment to file an application. Consider the application.
In the meanwhile, my lord. In the meanwhile, the BBMP has issued a confirmatory order for demolition of. ಅದನ್ನ 1.5 ವರ್ಷದಿಂದ ಇಂಪ್ಲಿಮೆಂಟೇ ಮಾಡಿಲ್ಲ. Your lordship see that an order has been passed in the. ನೀವು ಬೇರೆ they have not implemented it. Then another petition has been filed, your lordship, it has been incorporated in that order. I will send, I will show to your lordship only the interim order passed in that return. This is the order passed by the WP number 13, the interim order, why they are not implemented the order. Then the advocate appeal for that one, they have issued notice and take appropriate action.
21 notice yarg issue ಆಯ್ತು.
It's not issued to the previous owner, not to me.
To the previous
Previous owner, one Parvathaman issue ಮಾಡಿದರೆ, not issued.
submission today by the.
No notice issued to the actual owner, Khatedar. Satish Kumar Mutt is the owner. As on the date of construction.
Where are the documents on?
I have produced the document at annexure D, my lord.
Page.
Page 28, in page 28. Ata extract and that has been set aside by the joint commission. Other subsequent developments, as I have produced that order.
When was the 321 notice issued?
It was issued on, it is a annexure.
248.
321 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
321.
When was it
Number
issued?
6/3/2021. My lords, there is one difficulty in that. I have brought the original records also. I wanted to make that submission.
Can you issue in 21/6?
Lords, I wanted to make that submission for this honorable court. Since he has made his submission, I didn't want, otherwise I would have made that submission. The original records also I bought it. Even the plan sanction was also issued in the favor of the petitioner. But I wanted to make the submission. The original records also is with me, my lords. But there is a lapse on.
Then plan
You have to accept that, my lords. I cannot be on that.
248 you will have to do.
But it was 2020 act came, but the notice came to be issued in 21. They have issued an earlier notice. Based on that itself, the writ petition needs to be.
What happened?
But then
Immediately after foundation has been stone has been laid, we filed an objection. On that basis, 321 notice has been issued. Now they are having completed the construction in violation of the order of this.
Whom has it been issued? Whom has the 321 notice been issued?
the previous owner.
The previous owner, what happened? One then shared this. Previous owner claiming on the basis of the will. She filed a petition for the civil court for probator.
As
And we have challenged it.
issued to them.
They have challenged it. Then they withdrawn the petition. So on that basis, she executed a trust deed in favor of this petitioner. When she has no right at all, and she is not the owner of the property, they have created a trust and executed a trust deed in his favor. Then on the basis of the trust.
Brother, this is not a civil suit. When a civil suit happened, ಅಲ್ಲಿ ಇದೆಲ್ಲ argument ಮಾಡ್ಕೊಳ್ಳಿ. ಇದು 321 proceedings.
Also.
We are only concerned who is in possession. Whether notice has been issued or not. It's not been issued, and anyway, 321 in the year 2021 cannot be done.
What I am submitting,
The petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that the petitioner being the owner of the property,
pending ಇದೆ ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಅಂತ
the Tata standing in the name of the petitioner without issuing notice to the petitioner, the respondent by notice to the section 321 has issued the confirmatory order and is proposing to demolish the property of the petitioner. The HP Leader and counsel for the counsel submit that he would wish to file an impugned because he claims a right over the property. The impugned notice and 321 has been
That's
issued.
not the impugned notice, sorry to.
Appeal.
Same came to be challenged under an appeal, my lords. The appeal has.
appellate authority also upheld this.
The note, the mail appeal, the confirmatory order has been challenged in appeal. The appeal also came to be dismissed on 31/1/2022, which is under challenge in these proceedings. The 321 notice, the earlier 321 notice had been issued on date and
On 6/3/21.
6/3/2021. Admittedly not to the petitioner, to the previous owner. Be that as it may, in the year 2021, the BBMP Act having come into force, it is the proceedings under section, it is the right under section 248, which had to be exercised, and the powers under section 321 was no longer available for the respondent's officers to exercise. In that view of the matter, I pass the following order. Petition is allowed. The respondent is the order passed by first respondent, appeal number 7 of 2021, dated 31/1/2022 at Annexure A, is hereby quashed. Consequently, the notice dated 18/3/2021 at Annexure 8 and 321/1 notice under on 18/3/2021 and 321/3 notice dated 6/3/20. 321/1 and 6/3/21, 321/3, 18/3/2021, Annexure J and H respectively are hereby quashed. Liberty is however reserved to the respondent to initiate such proceedings as may be necessary under section 248 of North Bangalore Mahanagar Palika.
ಈ proceedings ಯಾಕೆ drag
Intent of the
ಯಾಕೆ drag on ಆಯ್ತು ಇದು
ನೀವು ಹಿಂಗೆ ಮಾಡ್ತಾ ಇದು ಡ್ರ್ಯಾಗ್ ಆನ್ ಆಗುತ್ತೆ.
ಪೆಂಡಿಂಗ್ proceedings
But we also refer to the proposed impleading applicant to agitate his civil rights as may be available.
I'm sorry, my lord, may I make a submission? The impleading applicant, my lord, has sought for implementing the very same impugned order in the other writ petition. That also has to be. ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ. ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಅದಕ್ಕೆ ಅದನ್ನ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ಮಾಡಿ.
Consider it on the day that it matters.
Let it be taken up, my lord, tomorrow or day after tomorrow.
This is done. So the memo for you in this list.
Very well, I'll file that memo.
Come back at 2:30.
submission. Serial number 50. Waiting for petitioner. Other side will inform ಮಾಡಿದ್ದೆ.
58.
Next week.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ petitioner?
Petitioner. Serial number 58.
ಅಭಯಾನಂದ್ ಸುಂದರರಾಮನ್ ಅವರೆಲ್ಲ ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ವಾ ಈಗ?
ಇಲ್ಲ ನಾ NOC ವಕಾಲತ್ PDC
Jyoti but is appearing for respondent. I think she may object for adjournment.
58 ಅಲ್ಲ?
ಇಲ್ಲ moment ಇಲ್ಲ. Jyoti but is appear for respondent. She may object. She has go or waiting.
Objection.
68.
68.
ಹೇಳಿದ್ರು.
For petitioner. I have weeks time.
ದೇಸಾಯಿ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? At the request of the petitioner released on 11th April.
79 ಏನಾದ್ರು ಬೆಳಿಗ್ಗೆ ಟೈಮ್ 79 ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ತಗೊಂಡ್ರೆ
ಸರ್ 29 29 ಇದೆ
ಮುಂದೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 54 ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 54 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 54 ಮೇಡಮ್ 54 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆನಾ ಏನ್ ಅಡ್ಜನ್ ಆಗಿದೆ?
ಇದೆ ಮೇಡಮ್ ಅದು
ಇದೆ. ಆಮೇಲೆ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ 16 ಮತ್ತೆ 29 ಮೇಡಮ್.
29 ಇದೆ ಮೇಡಮ್, 16 ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್
50
60
0 ಇದೆ ಮೇಡಮ್.
ಓಕೆ ಥ್ಯಾಂಕ್
ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದೆ 4053 ಬಟ್ ಸ್ವಲ್ಪ ಆಗಿದೆ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಬ್ರಾಂಚ್ ಯಾವ ಬ್ರಾಂಚ್ ಕೊಡ್ಬೋದು?
ಚೆನ್ನಾಗಿದೆ ಬಿಫೋರ್ 34 ಒಳಗಡೆ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಮೇಡಮ್.
ಇದು 230ಗೆ ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ತೀರಾ?
ಇಲ್ಲ 230ಗೆ 230 ಮ್ಯಾಟರ್ಸ್ ತಗೋತೀವಿ ಮೇಡಮ್. ಆಮೇಲೆ
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
230ಗೆ ಕೊಡ್ತೀವಿ.
ಲೋಕೇಶ್ ಭುವನಹಳ್ಳಿ ಅಲ್ಲ
27ನೇ ಮ್ಯಾಟ್ರ್ ಇದು. ರಿಪೋರ್ಟ್
ಇಲ್ಲಾಂದ್ರೆ ಯಾಕೆ ಲೋಕೇಶ್ ಭುವನಹಳ್ಳಿ ದೂರ ಬಂದ ಕಷ್ಟ.
ಸಾಕು.
ಇವತ್ತು ಅದು ಇನ್ನು ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ. ಹಂಗಿದೆ ಅದು ಬರ್ತೀನಿ.
ಇದೊಂಚೂರು ಮಾತಾಡಿ ನೋಡ್ತೀನಿ. ಇದೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಚೀವ್ಮೆಂಟ್ ಆಯ್ತಲ್ಲ.
77. Madam, I was actually, it's the fourth one. And ಅದು ಇದೆ, ಆಮೇಲೆ 28 ಅದು ಇದೆ. ಈಗ 20 ಡಿಸ್ಪ್ಲೇ ಕರೆಕ್ಟ್ ಇದೆ ಅಲ್ವಾ ಸರ್?
ಅಷ್ಟೇನಾ ಮೇಡಮ್?
ಹಾ ಅಷ್ಟೇ ಎಲ್ಲ ಕೊಟ್ಟಾಯ್ತು.
ಇಷ್ಟೇನಾ? ಸಾಕು.
ಏನ್ ಮಾಡ್ತಾರೆ ಯಾವ ನಂಬರ್
ನಂಬರ್ ಮಾತ್ರ ಕಾಣಿಸುತ್ತೆ.
Serial number 11 in second list. I inform other side.
ದಿನ ಟೈಮ್ ಬೇಕು
Next.
11 seconds. Request to counsel for the petitioner released on 13 days.
Serial number 58 first list. Other side complete. Next week any date.
58. The PD Surana has entered appearance for the petitioner delete Navaya Anand counsel. Counsel for the petitioner seeks for and is granted 2 weeks time to get ready and address arguments released on 10th April.
Serial number 67 objection only 10.
Petitioner ಹೇಳಿದ್ದೀರಾ?
Petitioner I will inform.
Will ಬೇಡ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ಮೇಲೆ
230 matter. Serial number 82.
Link continuation, my lord. I'm sorry, on 20th February, Ashit given such a direction, my lord. I'm not noted, and my order is also not uploaded.
not upload.
I only filed today, I filed only.
20th February in upload ಆಗಿದೆ.
I am not even applying certified copy.
ಅದಾದ್ಮೇಲೆ 7/3 counsel for respondent has filed a memo dated 23/23. Revenue officers ಗೂ ನಿಮ್ಗೂ ಏನು ಸಂಬಂಧ?
Revenue officer and they are the department ಖಾತಾ ಎಲ್ಲ
There will be BBMP ನಿಮ್ಮಲ್ಲಿ ಬರ
ನಮ್ಮಲ್ಲಿ ರೆವಿನ್ಯೂ
ಇದೆ.
ಅವರು ವಿಡಿಯೋ ಖಾತಾಸ್ ಎಲ್ಲ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ಮಾಡ್ತಾರೆ.
ಅದು ಇನಿಷಿಯಲ್ ಟೈಮ್.
ಹೌದು ಇನಿಷಿಯಲ್ ವಿಡಿಯೋ ದೆನ್ ಇದತ್ತು ಅಪಾರ್ಟ್ಮೆಂಟ್ ರೆವಿನ್ಯೂಸ್ ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡೋದು ರೆವಿನ್ಯೂ ಆಫೀಸರ್.
That is only for the initial. Now that may not be relevant.
ಅಲ್ಲ ಈ ಝೋನ್ ಒಬ್ಬೊಬ್ಬರು ಇದ್ದಾರೆ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ಅವ್ರ ಮೇನ್ ಖಾತಾ ಆಗಿದೆಲ್ಲ
ಹಳೆ ಕೆಲಸ ಇದೆ. ಸುಮಾರು ಅಷ್ಟು ಈಸಿಯಾಗಿ ಮಾಡಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ ಮೆಜಾರಿಟಿ ಮಾಡ್ತಾರೆ ಎಂಟೈರ್ ಓಲ್ಡ್ ರೆಕಾರ್ಡ್ 77, 76 ಇಂದ
ನಿಮಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಶುಡ್ ಕಮ್ ಎಲೆಕ್ಟ್ರಾನಿಕ್ಲಿ.
ಇವಾಗ ಮೊದಲಿಗಿಂತ ಸ್ವಲ್ಪ ಬೆಟರ್ ಇದೆ.
ಬೆಟರ್
ಲಾ ಸೆಕ್ಷನ್ ಗೆ ಒಂದು ಹೇಳಿದ್ದ ದೇ ವಿಲ್ ಕೋಆರ್ಡಿನೇಟರ್ ತೆಗೆಸಿ ಸ್ವಲ್ಪ ಇದು ಮಾಡ್ತಾರೆ.
ಒನ್ಸ್ ದಟ್ ಇಸ್ ಅಚೀವ್ಡ್
ಆರ್ ಬೆಟರ್ ಮೊದಲಿಗಿಂತ ಸ್ವಲ್ಪ.
And a memo enclosing the letter dated 17/3/2023 of the secretary BDA to the council. The same reads as under. That Shri K. Krishna and the council seeks for and is granted 3 weeks time to report compliance with the order dated 22/2023, as also further compliance as regards the digitization of the records of the BDA. Released on 10th April at 2:30.
Order may be the upload.
Upload.
Second 20th.
Passed over matters. Number 1, serial number 4.
What is the file?
Yes. I have not asked about you.
Both
And here to see only last occasion at when the matter has come up. When he made an application for revised plan and another date bit. Either reference it to documents or the honorable court or direct him to other aspects on record admitted.
Yes, please.
May mix. But the petitioners or challenged Annexure G order passed by the respondent number 1. Page 42, my. Page by passing an order as accepted the view taken by the third respondent authority for return of the gifted property to the respondent number 2, my lords. But the facts of the case, my lords. But the petitioners are the residents of Kirodian Lane, Mangalore, my lords. But the Kirodian Lane is very narrow cross way road. There is a small road, my lord. To reach the Kirodian Lane, my lord, from Kaur main road, there is called as a 6th cross main, my lord. That 6th cross main, my lord, please, which was also narrow around 8 feet. The respondent number 2, my lord, for the better understanding, my lord, please, I produced the sanction plan by the respondent number 2 authority in favor of respondent number 3, my lord. That is at page 29.
Produce location of the property and
the location of the property.
When did you produce it?
My lord, at Annexure B, page 29.
29.
Plan copies. My lord can get it.
Yes.
My lord, this plans for either right. North right.
Yes.
My lord, this downwards existing 2.40 meter road down, that is the eastern side. That is east of the property of the respondent number 2.
Yes.
My lord, the left side, my lords, please, one line, my lord. That is called Kirodian Lane, my lord. That is the southern side of the property belong to the respondent number 2. My lord, the main road goes ahead to this eastern side, which goes further, and from that main road, this portion of the property road. My lord, the respondent number 2 being absolute owner of this property, who was intending to put up construction on his property, my lord, please. He applied for sanction plan and license. By that time, the respondent number 1 corporation authority, in pursuance of their procedure or some rules followed there in my lords, please, he has to leave a portion of his property for widening the road. That is 0.3 meter area in his property he has to leave to an extent of 1 feet, adding to the existing 8 feet, and opposite side also, who was to, if he start to put up construction, he should also leave 0.3. In such a manner, this plan is sanctioned. My lord, for both these sides, both southern side and the eastern side, you were to leave. Accordingly, my lords, please, he was agreed to leave 2.5 cents of his property, both on the eastern and southern side.
Malad, he has executed a registered gift deed in favor of the government, that is corporation, on government, my lords.
Page.
Page 25, Annexure A, my lord. Page 25, Annexure A. My lord, as per this, my lord, page number 27, my lord, is the total extent of portion which he has left is also referred. And what particular portion, what extent is specifically mentioned in this plan towards specifically eastern side. Eastern side of his property, 0.3 meter he has to add to make it total 3 meters, that is 2.4 already existing and 0.3 from his side and opposite side while putting up construction he has. My lord, subsequently what happened, Your Honor? My lords, please. He on obtaining sanction plan, my lord, he started to put up construction, my lords, please. Without thereafterwards, he did not leave.
Second respondent.
Second respondent in favor of government, like government, represented by the commissioner on behalf of the governor. The property is gifted.
Who are you?
My lord, we are the residents of this Herodian lane, where towards the southern side road, I mean property, our road here on the property attached houses owners.
The other side of the road.
Other side. My lord, as per the plan, my lord, this left side, my lords, please. That is towards
East of the road.
East of that road.
South of the road.
Our road is south.
South of the road.
That full line bandide. As continue, it will go. Num property, one of the petitioners' property, munde continue down this road of left side. So, my lords, please, the benefit for us and to the petitioner also, I am not on the point. My lord, he started to put up construction. He has completed the construction also. My lord, we gave representation to the corporation to utilize that 1 feet per road. It can be widened and helpful to all, as it is only a small portion of 8 feet existing there, my lords. Then not upon, my lord, the corporation authority, my lords, please, after receipt of the representation, my lord, annexure E prakara, 3-4 representations put, they gave a letter as per annexure D to the petitioner.
D.
Annexure D, page 33, my lord. According to this letter dated 21/12/2015, my lord, on taking into consideration the representation of the petitioners, my lord, the states Raste Viskarane Bittukotta, Jameen Swadhina Padise, Raste Bittu Kodisada, Kuritu so and so, representation of petitioners' names, my lord. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಅರ್ಜಿಯ ಕುರಿತು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಮಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯ ಕೊಡಿಯಾಲಬೈಲು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 10/3 ಏರಲ್ಲಿ 16.45 ಸೆಂಟ್ಸ್ ಜಮೀನಿನಲ್ಲಿ 121.92 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ನೆಲ ಅಂತಸ್ತು ವಾಸ್ತವ್ಯ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ಶ್ರೀ ಬಿ ವಸಂತ್ ಇವರಿಗೆ ಸಮಯ ಸಂಖ್ಯೆ ದಿನಾಂಕ ಒಂದು ಕಟ್ಟಡ ಪರವಾನಗಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ದೂರ ಅರ್ಜಿದಾರರು ಈ ಮೂಲಕ ತಿಳಿಪಡಿಸುವುದೇನೆಂದರೆ ಕಟ್ಟಡದ ಕಾಮಗಾರಿ ಕೆಲಸ ಬಾಕಿ ಇದ್ದು ಪ್ರವೇಶ ಪತ್ರ ನೀಡುವ ಸಂದರ್ಭದಲ್ಲಿ ದಾನಪತ್ರದ ಮೂಲಕ ರಸ್ತೆಗೆ ಬಿಟ್ಟುಕೊಟ್ಟ ಸ್ಥಳವನ್ನು ಪಾಲಿಕೆ ಪಡೆಯುವ ಕುರಿತು ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗಿದೆ. My lord, they have intimated us in 2015. My lord, he completed the construction. He already occupied. We are not on that. My lord, in spite of this, they did not take action even though construction completed. We filed a writ petition before this honorable court, my lords, please, which is order copy at page number 38, annexure M, my lord. Annexure M. My lord, this honorable court is pleased to direct the corporation to consider our representations with regard to take position of that 1 feet. So, my lord, in meantime, during pendency of this writ petition and also our representations, my lord, some proceedings are started to initiate by the respondent number 1 corporation. My lord, in that we were also asked to appear. We have also submitted our statement, whatever the court order and request. More and above, we are not claiming as a matter of some right over the property. My lord, the corporation authority, since they did not comply with the orders of this honorable court, a contempt application. Afterwards, this annexure G order came to be passed. So now, as per annexure G, my lords, please, the corporation authority, the respondent number 1 passes an order saying that he has issued notice to the respondent number 2. Respondent number 2 appeared and filed the statement according to this order at page number 43, my lords. Let's there are 3 minutes. para 2 from para 2 in page 43. ಪ್ರತಿವಾದಿಯರಾದ ಶ್ರೀ ವಸಂತ್ ಇವರು ಸದರಿ ಕಟ್ಟಡಕ್ಕೆ ದಿನಾಂಕ 18/10/2016 ಪ್ರವೇಶ ಅನುಮತಿ ಪತ್ರ ಕೋರಿ ಸೋಣಸೋ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಅರ್ಜಿಗೆ ಸಹಾಯಕ ನಗರ ಯೋಜನಾಧಿಕಾರಿಯವರು ದಿನಾಂಕ 26/10/2016 ನೀಡಿರುವ ವರದಿಯಂತೆ ಪ್ರಸ್ತಾವನೆಗೆ ಸಂಬಂಧಿಸಿದ ಕಟ್ಟಡದ ನಿವೇಶನದಲ್ಲಿ ರಸ್ತೆ ವಿಸ್ತರಣೆಗೆ ಈಗಾಗಲೇ ದಾನಪತ್ರದ ಮೂಲಕ ಪಾಲಿಕೆಯ ಹೆಸರಿನ ನೋಂದಾವಣೆ ಮಾಡಿರುವ ಜಮೀನನ್ನು ಬಿಟ್ಟುಕೊಟ್ಟು ಆವರಣದ ಗೋಡೆ ನಿರ್ಮಿಸಿದ ನಂತರ ಹಾಗೂ ಉಳಿಕೆ ಖಾತೆಯೊಂದಿಗೆ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಪ್ರತಿವಾದಿಯರಿಗೆ ದಿನಾಂಕ 5/11/2016 ಇಂಬರಹ ನೀಡಲಾಗಿದೆ. He has to left and then he has to file. Then my lord. ಈ ಮಧ್ಯೆ ದೂರ ಅರ್ಜಿ that is our application and court proceedings are next para my lord. ಪ್ರತಿವಾದಿಯವರು ದಿನಾಂಕ 12/7/2017 ಸಲ್ಲಿಸಿರುವ ವಿವರಣೆಯಲ್ಲಿ ಕಟ್ಟಡದ ನಿರ್ಮಾಣಕ್ಕೆ ಪಾಲಿಕೆಯಿಂದ ಪರವಾನಗಿ ಪಡೆದಿದ್ದು, ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪಡೆಯುವ ಮೊದಲೇ ರಸ್ತೆ ವಿಸ್ತರಣೆಗೆ ಜಮೀನನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ಬಿಟ್ಟುಕೊಡಲಾಗಿದೆ ಹಾಗೂ ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಇರುವ ಆವರಣ ಗೋಡೆಯನ್ನು ಪುನರ್ ನಿರ್ಮಾಣ ಮಾಡಲು 3 ಲಕ್ಷ ರೂಪಾಯಿಗಳ ಅಗತ್ಯವಿರುತ್ತದೆ. ರಸ್ತೆ ವಿಸ್ತರಣೆಯ ಉದ್ದೇಶಕ್ಕೆ ಜಮೀನನ್ನು ಬಿಡಲು ನನ್ನ ಆಕ್ಷೇಪವಿಲ್ಲ. ಆದರೆ ಪ್ರಸ್ತುತ ಆರ್ಥಿಕ ಸ್ಥಿತಿಯಲ್ಲಿ ಆವರಣ ಗೋಡೆ ಪುನರ್ ನಿರ್ಮಾಣ ಮಾಡಲು ಅಡಚಣೆ ಉಂಟಾಗುವುದರಿಂದ ಸದರಿ ಕಟ್ಟಡಕ್ಕೆ ಪ್ರವೇಶ ಅನುಮತಿ ಪತ್ರ ನೀಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಹಾಗೂ ದಿನಾಂಕ 24/11/2017 ನೀಡಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆ 22.5 ಸೆಂಟ್ಸ್ ಜಮೀನನ್ನು ಕ್ರಯ ಸಾಧನದ ಮೂಲಕ ಪಡೆದುಕೊಂಡಿದ್ದು, ಸದರಿ ಜಾಗವನ್ನು ಪಡೆದುಕೊಂಡ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಜಾಗಕ್ಕೆ ಹೋಗುವವರೇ 4 ಫೀಟ್ ಅಗಲದ ದಾರಿ ಇರುತ್ತದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಇಬ್ಬರು ಅಣ್ಣ ತಮ್ಮಂದಿರು 0.30 ಸೆಂಟ್ಸ್ ನಂತೆ 0.60 ಸೆಂಟ್ಸ್ ಜಾಗವನ್ನು ಉಚಿತವಾಗಿ ನೀಡಿದ್ದು 16.5 ಸೆಂಟ್ಸ್ ಉಳಿಕೆಯಾಗಿರುತ್ತದೆ. So he explained already he has put up construction of compound wall, new wall on the same property by encroaching additional 1 feet of existing 8 feet also. That in para 9 of my writ petition that also has
existing 8 feet additional.
Now ತಗೊಂಡಿದ್ದಾರೆ, ಅವರು ಬಿಟ್ಕೊಡ್ಲಿಲ್ಲ. That he encroached whatever he has already gifted, that he encroached, and out of 8 feet existing in the road which was already made as per 2.4 plan prakara, there also he has taken 7 adi. Then my lords, please, now the respondent number 3, my lord, now the planning authority of BD according to them, my lord, page 44 may kindly be paged. ಪ್ರತಿವಾದಿಯವರು ದಿನಾಂಕ 8/2/2018 ಪಾಲಿಕೆಗೆ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯಲ್ಲಿ ಪರಿಷ್ಕೃತ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯನ್ನು ಪಡೆಯಲು 60 ದಿವಸಗಳ ಕಾಲಾವಕಾಶ ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಅದರಂತೆ ಪ್ರತಿವಾದಿಯವರು ದಿನಾಂಕ 23/6/2018 ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ದಿನಾಂಕ 19/6/2018 ನೀಡಿರುವ ಏಕನಿವೇಶನ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಹಾಗೂ ನಕ್ಷೆಯನ್ನು ತಿದ್ದುಪಡಿಗೊಳಿಸಿದ ಪರಿಷ್ಕೃತ ಆದೇಶವನ್ನು ಪಡೆದು ಪಾಲಿಕೆಗೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನಾವು I have actually amended the writ petition because ಇದೊಂದು ಆರ್ಡರ್ ಸಪರೇಟ್ ಆದ್ರಿಂದ to avoid complication. Now my humble submission to this honorable court, my lord, once he has already gifted the property in 2015, my lord, he has already put up construction as per the sanction plan. While in 2018, since he did not left and corporation did not utilize that portion, we pursued the application. Subsequently, during pendency of all these proceedings, my lord, according to this planning authority, they accepted his application of 2018 and they wanted to issue a revised plan to him. My lord, when once the corporation has taken the property, he has gifted to the government, I can say.
So in terms of this modified plan, one is given back.
Now order is this order is on the basis of that modified plan. Now the corporation has taken the view order portion. May I read the order? Yes. My lord, the Mangaluru Nagarapalike Vyaptiya I'll just skip up that one. My lord. ವಿನ್ಯಾಸ 13/2015 ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪಡೆದಿರುವ ಜಮೀನಿನಲ್ಲಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪ್ರಕಾರ ನಿವೇಶನದ ಪೂರ್ವ ಹಾಗೂ ದಕ್ಷಿಣ ಭಾಗದಲ್ಲಿರುವ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ಬಿಟ್ಟುಕೊಡಬೇಕಾದ ಜಾಗವನ್ನು ರಸ್ತೆ ವಿಸ್ತರಣೆಗೆ 86.90 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ದಾನಪತ್ರ ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ ಡೇಟೆಡ್ 21/5/2015 ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ಪಾಲಿಕೆಗೆ ನೋಂದಾವಣೆ ಮಾಡಿರುವುದರಿಂದ ಹಾಗೂ ಪ್ರತಿವಾದಿಗಳು ವಿಚಾರಣಾ ಸಂದರ್ಭದಲ್ಲಿ ನೀಡಿದ ಹೇಳಿಕೆ ಪ್ರಕಾರ ತಮ್ಮ ಜಮೀನಿನಿಂದ ಈ ಮೊದಲೇ ರಸ್ತೆಗೆ ಜಾಗ ಹೋಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಂಗಳೂರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ ದಿನಾಂಕ 19/6/2018 ಪರಿಷ್ಕೃತ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪಡೆದು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಈ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯ ಆಧಾರದಲ್ಲಿ ದಿನಾಂಕ 21/5/2015 ನೋಂದಾಯಿಸಲಾಗಿರುವ ದಾನಪತ್ರದ ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ ಸೋಣಸೋ ದಸ್ತಾವೇಜನ್ನು ದುರಸ್ತಿ ದಾನಪತ್ರ ಮಾಡಬೇಕಾಗುತ್ತದೆ. So ಆದುದರಿಂದ ಪರಿಷ್ಕೃತ so and so ಮಾಡಿ ಅಂತ ಕ್ರಮ. My humble submission, my lords. When once the property is gifted to the government on behalf of government corporation, whether the either planning authority, my lords please, or the corporation authority are having any powers to return the property under the provisions of the municipal corporation or any other act. That this portion of 1 feet already enclosed up, 1 feet he has to left, that also yes. Now it's a narrow road, it's useful for general public. When once it is given to corporation, my lord, it is the bounded duty of the corporation authority. Till 2018, my lord, sir, when they issued this annexure, my lord, annexure D, my lord, please, a letter to the parties, my lord. Till 2015 also they says that they will take action. But all of a sudden, having hand in glove with the respondent number 2 to return the property and giving a revised plan, how corporation plan can be revised by the planning authority, my lords, please. Annexure B, corporation authority has sanctioned the plan. How that can be revised indirectly by the planning authority, my lord? Yes. And my humble submission is that this order passed by the respondent number 1 is without powers, and moreover, a property of public property, my lord. How he can, under what provisions or on what basis he has ordered to see that modified, idana durastindra according to them amended deed kodabeku anta, what is their clear?
Really, please, Your Lordship. The total land, sorry. The total land what I have purchased is 22.50 cents. That is in the year 10/6/1981. I have produced R1. Sale deed I have produced. At that point of time, plan also has been produced. There was no road in the eastern side. Thereafter, my lord, I have sought for conversion of the said land, the entire land, 22.50 cents. That was accorded as per annexure R2 and R3, page number 20 and 21 of my objection statement. Thereafter, I have gifted 3 cents each to my brothers. That is in the year and on 3/6/2011. My lord, after gifting this, my lord, at that point of time, at the request of the corporation authorities, I have given 1.70 cents of land to the corporation authorities to form a land in the eastern side. The entire land is given by me, 2.4 meters into 12.65 meters. 2.4 meters into 12.6 meters I have given in the eastern side. The entire land I have given. There was no document has been made at that point of time. Thereafter, my lord, I have applied for layout plan. My lord, the layout plan has been accorded. As per the, while applying for, there was a mistake by my side, my lord, that while instead of, deducting all these lands, whatever I have given, that the remaining land was only 14.5 cents. Instead of applying for 14.5 cents, I have applied for 22.5 cents. As for annexure R6 R7. At that point of time, they have directed me to give the land, that is 2.15. It is a mistake, that is the excess. Instead of giving 1.75 cents, I had to go 2.15 cents, because without considering whatever the land I have given for the corporation authorities, and also ordered to my brothers. That is already done 2011 itself. I have applied for this the layout plan in the year 2015. At that point of time, I have committed a mistake while applying for 22.50 cents. I have applied for that 22.5 cents. They have asked me to leave 2.15 the cents of land in favor of the corporation. That is how I have executed. To get a sanction plan from the corporation, it was a mandatory requirement. I have done that. Later on, when they have complained about not fulfilling these things, that I have not left the land that is in the eastern side, 1 feet, they have encouraged. It's all not incorrect. It is not correct. I have not encroached any land. 2011 itself, I put up the compound, not fresh. A new compound wall has not been erected. 2011 itself, it has been erected.
I have said I need not have to leave, I mean, remove that compound wall. Whatever I had to leave, I've already left. So far as the corporation is concerned. Then Millard, again, then they have asked for, then you get it modified. According to you, you have stated these things. These has to be deducted. You have to apply only for 14.75 cents. So you apply and you get it modified. Then Millard R2, 11 and R12 Millard. R11 and R12, they have given this modified, in the sense revised plan. That is only the layout plan, not the annexure B. The only layout plan has been, revised. As per that plan, Millard, I had to leave only 1.75 as already left. That is the order has been made. Now, the last para, what my learner friend read, please, Your Honor, in the order itself. I'll read that now, please, Your Honor. Para number 41, the last page of that order. May I read, please?
This is a orientation of this land. What you are showing is north. How does this match with the sketch at?
ಅದರಲ್ಲಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ರೋಡ್ ಅಂತ ನಾನು ತೋರಿಸಿದ್ದು ತಪ್ಪು. ಅದು ಇಟ್ ವಾಸ್ ನಾಟ್
Annexure B ಅಲ್ಲಿ.
Annexure B.
B.
Annexure B was, yes, Miller. Annexure B is R10 and R11. I mean R9 and R10. By I have produced this.
That is the
Building plan.
Building plan.
Building plan, Miller. It is
So
not
this is-
modifications.
This building plan is which portion of this property at R12?
R12, Miller. The friend, that this is the
So this
site number. It is meant as site number 1.
Site number 1.
1. That is the only portion. Only 14.75%. 75 cents. Only for that I should have applied for. I have applied for 22.50 cents at that point of time while applying the first time. That is the mistake I have committed. Therefore, I have asked to exit the gift deed, annexure A.
So you are saying 0.60 meter already left for the road.
Not 0.65 meter. 2.4 meters already left. The top.
It is a 2.4 meter already. So therefore, it has to be 3 meter road.
According to them, 3 meters. When the other side leaves, a portion, automatically it comes about more than that, please. The entire line, why should I give? That is what I am asking for.
Other side leaves, it would be 10.
In terms of meters, it will be 3 meters.
Is it?
In terms of feet, it will be around 3.
Total is 9.75.
Including 0.75 meters that you have to leave. You are on this side. You are on the.
No, I have.
southern
That is
side.
for total 3 meters.
So after you leave 0.75, it becomes 3 meters.
It will become 3 meters.
Have you left your 0.75?
Minutes, please.
Have you left your 0.75 meters?
No, I am not opposite. Opposite side.
He's just passing through this road. You want to be.
You are passing through the road.
Passing through the road.
We are passing.
Public interest mitigation alone.
Passing through the road.
If you are next, ನೀವು ಅವಾಗಿಂದ ಅದರ್ ಸೈಡ್ ಅಂತ ಹೇಳಿದ್ರಿ ಅದಕ್ಕೆ ನಿಮ್ ಕೇಳಿದ್ದು ಯು ಆರ್ ಆನ್ ದಿ ಸದರ್ನ್ ಸೈಡ್ ಅಂತ.
Southern side. We are on southern side.
Immediately abutting or later?
No, after passing through. 1 minute, please. My lord, this road, southern side road, please. This side.
Not in the western side. This the road.
How map on annexure B ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದೀರಾ ಹೇಳಿ?
ಒಂದು ನಿಮಿಷ. Annexure B ಗೆ ಬಂದಾಗ. Annexure B ಗೆ ಬಂದಾಗ this is north.
ಹೌದು.
This is south. Southern side on road, my lords, please. What?
Yes.
Yeah. City of India. So that's abutting that road. This side we are having also. This side up to down up to here.
So on the southern side you are abutting.
We are that to cross.
So you are supposed to give 0.7.
We have to cross. We have to move from this road only to reach our houses.
ಆ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಎಲ್ಲಿದ್ದಾರೆ ತೋರಿಸಿ. ನೀವು ಎಲ್ಲಿದ್ದೀರಾ ತೋರಿಸಿ. ಹೌದು.
ಇಲ್ಲಿ ಒಂದು 2-3 ಪೆಟಿಷನರ್ಸ್ ಹೌಸಸ್ ಇಲ್ಲೇ ಬರುತ್ತೆ ಈ ರೋಡ್ ಕಟ್ಕೊಂಡಿ. ಇನ್ನೊಬ್ರದ್ದು ಸ್ವಲ್ಪ ಅದೇ ಇದೇ ರೋಡ್ ಕಂಟಿನ್ಯೂ ಇಲ್ಲಾದ್ರೆ
ನೀವು 3 ಜನ ಅಲ್ಲಿ ಅಂಟ್ಕೊಂಡಿದ್ರೆ 0.75 ಮೀಟರ್ಸ್ ಬಿಟ್ಟಿದ್ದೀರಾ?
ನಮ್ಮ ನಮ್ದು ಏನ್ ರೋಡ್ ಎಷ್ಟಿದೆಯೋ ಆ ಕಾಲಕ್ಕೆ ಅಷ್ಟೇ. ಈಗ ಕಟ್ಟೋರ್ಗೆ ಮಾತ್ರ
0.75 meters.
It's a must also. Even
So ಇವಾಗ ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು ಅಂತ ಅದೇ ಕೇಳ್ತಾ ಇಲ್ಲ ಮಿಸ್ಟರ್ ವಿಶ್ವನಾಥ್
ಈಗ
ಅವ್ರಿಂದ.
ಬಿಡ್ತಾ ಇರೋರು ಬಿಡ್ತಾ ಇದ್ದಾರೆ.
ನೀವು ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ
It
ಕೇಳಿ.
is the rule. ಮೊದಲು ಕಟ್ಟಿರೋರ್ದು ಹಾಗೆ ಇದೆ ಸರ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಮಿಸ್ಟರ್ ವಿಶ್ವನಾಥ್. ನೀವು ಬಿಟ್ಟಿದ್ದೀರಾ, ನಿಮ್ ಕ್ಲೈಂಟ್ ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ನಮ್ದು ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್. ನ್ಯೂ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾತ್ರನೇ it is being adopted my lord.
So you don't want to leave any land of.
ನಾನ್ ಕಟ್ಟೋ ಬಿಟ್ಟೆ ಕಟ್ಬೇಕು
It's a public.
ಅಂಡ್ ಆಮೇಲೆ ಈಗ ಬೇರೆಯವ್ರು ಕಟ್ತಾ ಇದಾರೆ, ಅವರೆಲ್ಲ ಬಿಟ್ಟೆ ಕಟ್ಟ ಬ್ಯಾಕ್ ಸೈಡ್ ಕಟ್ತಾ ಇದಾರೆ. ಇಲ್ಲ, ಆಲ್ ಇಟ್ಸ್ a procedure being followed my lord.
It cannot be a private interest litigation, Mr. Vishnu. It is a public interest litigation. If you are claiming a road, file a PI. Then we can put you on terms also. And use this name.
Then liberty may be given.
Petitioner is before the court seeking for the following reasons. The contention of the petitioner is that ಇದನ್ನೇ ಕನ್ವರ್ಟ್ ಮಾಡ್ತೀರಾ ಹೊಸದ್ ಹಾಕ್ತೀರಾ?
ಇಲ್ಲ, ಇದನ್ನೇ ಕನ್ವರ್ಟ್.
After arguing for some time, when it passes for the petitioner seeks permission to treat the above petition as a public interest litigation, he seeks for 3 weeks time to file the second set of papers. He is so permitted. Once the second set is filed, the registrar judicial is directed to place the matter before the Honorable Chief Justice for necessary orders. Here, banda in terms of
Serial number 8.
8. What we cut to the
Authority to represent, there is one resolution. He is the authorized signatory. He has filed the petition on behalf of the association. I'll make necessary corrections and produce.
counsel for the petitioner submit that the court fee has been filed, and insofar as authorization is concerned, the signatory is the
Authorized signatory to pursue the litigation. There is a resolution to that effect. I'll produce.
has been authorized by whom?
The association.
Committee or the
Apartment owner.
committee na general body na?
Committee.
The managing committee of the petitioner has authorized the signatory to represent the petitioner. He seeks for a week's time to produce necessary documents. Which time is done? Yes, lady.
The building was completed during the year 2017, my lord. Already 60 families have been residing. And subsequently, it appears that, my lord, there were some proceedings subsequent to 2019, wherein we are all not parties, my lord. Now there is a direction by the BBMP to remove the additional floor, and also, my lord, with regard to certain deviations that has occurred. My submission, my lord, we are all not parties to the BBMP, and all of a sudden, my lord, they have directed the BESCOM to disconnect the power, and also
No notice has been issued to you.
to the association of the.
Pawan Kumar. The Pawan Kumar accepts notice for respond number 1 and 2. The contention of the petitioner is that no notice has been issued to the petitioner before directing petitioner and or its members before directing the demolition of a portion of the building. Before any such demolition is carried out, it is what's required that necessary notice and opportunity is provided to the aggrieved party. In view thereof, the response are restrained from carrying out any demolition activity till the next date of hearing. Responding copy of the petition to be furnished to Shri Pawan along with annexes to Mr. Pawan Kumar. Objections if any by 31st, released on 6th.
Serial number 12. Authorized Shetty.
Sorry, this much I was not. I
They have
apologize.
to file a report with
The report is ready. Pass down to the other side. Just now, permitted. I'll go through it. We need to file objections. There are two things. In this, they say there is no deviation. My only request is, they did not produce the photographs, because either its commissioner, no notice was given, we are not present. Neither any photograph has been produced as to the violations. Lordship may get produced. Therefore, let.
There is a major drawn where the commissioner is present and the signature is there.
Other petitioner is present.
Yes.
Measure is there. Is there.
Where is the measure? Page number?
That's a measure is inside. I produce the measure.
Please drop an ID.
Petition was present.
Yes. Photographs are there.
I just wanted to bring to your lordship's notice. This is the second round of litigation which is brought about by this very person. Not she instigated two others who are not even the residents of this area to file a section 91 suit before the civil court by stating that there is no sanction plan at all and that there are deviations. In that civil suit, an order of injunction had been granted. It was challenged before this honorable court.
It's not, the petition name is not there.
Somebody, the representative is there. Photograph, produced, I can produce the photograph. There is no.
What was said was petition is present.
We have,
Not on that direction. The case is, if there is no violation, there is no case, Manoj. My case is, Manoj, instead of basement, no basement is constructed. It is constructed on the stage. Ramp is put up and it has been done.
No basement is done, a stilt is.
A stilt is put on.
No stilt, my lords, as per my instruction.
So let the photographers, let the commissioner be appointed. Let the truth come out.
In the ramp area, in the this what we call setback area, the ramp can be placed. That is permissible
Not as per the plan.
bylaw. That is as per the bylaw, please. That also copy we have produced.
Bylaw under one thing to be done. The question is that per the plan sanction? Simple question, Manoj.
My lord, the second aspect is, there is a basement floor, a ground floor, first floor, second floor, and a terrace floor.
So you said it's a basement.
Deviation, there is a deviation.
Deviation in the terrace floor, which is within 5%, so it's fine.
Less than 5% it is there.
It's fine.
With regard to setback also, please, 1.35% is there. Height of the then height of the building 12.10, whereas the permitted is 11.0. That's the FAR that is applicable is 2.25. What they have sought, is only for 1.75 FAR. So still, please, the FAR can be loaded into. So
We
cannot, my only instructions are, there is not much of a.
We are only concerned with two things from your statement here.
Please.
Number one, whether it is a basement or a stilt which has been signed.
Only a basement.
And if it is a basement which has been constructed.
Yes, yes.
So photographs will clearly.
I can request the officers. I only did not produce the photographs because of this reason.
That will close that issue.
Yes, please.
Second issue is as regards the setback violation.
Yes, Miller.
Now, can the setback violation be compounded?
Yes. Yes, Miller.
So both of them 1.35% only.
1.35, please.
So if it can be compounded, show us the provision.
Absolutely.
The up area, we are aware it is 5%. Setback anywhere.
4.5%.
The learned friend says, as you are aware, you may have an FAR of water 2.53. The permissible developable area depends upon your plot size and the setback area. You may have 2.25. If your plot size is only 2,400, you can build only 1.25 or whatever it is. So therefore, my lord, to say that the short point is, what an affidavit has to be filed is it as per the plan sanction? My case is not, bylaws may permit 101 things. Has he constructed the building as per the plan sanction? If it's not,
The plan sanction.
I produced it along with the writ petition.
The total coverage permissible in terms of the bylaw is 65%. My total coverage comes to 61.09% as it stands today. Before that, I wanted to say this. He had sponsored one litigation. There is a story behind this, Manoj. He had sponsored a litigation under section 91 of the Code of Civil Procedure. And he had gone to the civil court. An interim order was granted at the first instance, against which we came in a writ petition. There is a lot of proceedings which took place before this honorable court. A coordinate bench, Manoj, directed the commissioner to file an affidavit as to whether there is a plan sanction and what are the deviations. It was already submitted pursuant to the coordinate bench's orders of this honorable court.
But that also be placed.
That is in WP number 21811 of 2022.
Your objection, Mr.
No, this is the first appearance after the day before yesterday.
Filing it.
No, I'm just indicating, Manoj, that.
You don't want oral submission.
Very well, Manoj.
Everything on record. Mr. Monish, is this as per the measurements which you have done?
Yes, Manoj.
Is as per the Building bylaws or as per the sanction plan?
We are as per the sanction plan, please, my lords, and reflected in the report.
Sanction. Deviation against sanction plan.
That is what it says, my lord. My
Lords, as we have, that finds a mention, my lords, may I respectfully submit, my lords. Floors, as per sanction plan, as per actual, the deviation, all three columns are there, please. For every floor. It supposes not that there is a sanction accordingly.
I'm in the next house. Given not, I'm not being. But I don't want to dispute what the authority.
I will produce the photographs. No. This is doubting, please, no, I will produce the photographs. And they were present, my lords. Mahajar has been drawn.
No, it's not.
Their representation.
Considering one of our present, who was present, please tell me.
I will produce the photograph.
Where is the area for, 366, 342, 247, yes. It all matches with the plan sanction.
Yes.
Legend is at the bottom.
Yes.
That's what we are taking into account. They are taking into account. The only issue that remains is whether it's a basement or estate. That you are putting your.
Exactly, as a Russia, we should contact the. In fact, your small violations of your Russia.
The small violation we want.
I don't want to, I don't think, my problem is here and light is not that basically, because it's not light or first.
If it's a small violation, it can't necessarily.
That is what, that's why I'm not. The photograph shows what is the come out. I understand, but I'm not. Your Worship, my minor thing is,
The Municipal has filed a memo along with the inspection report. The same is taken on record. Copy thereof is furnished to the petitioner and respond number. You're appearing for whom? Notice has not been offered.
I am appearing for 4 and 5, 5 and 6.
So who will take notice?
Wakalat is filed by my learned friend.
1 to
Sir,
4.
I am appearing for 1 to
Akshay,
4.
your lordship. Akshay. Yes.
Say what? Full name and.
Akshay, yes, Vasisht, your lordship.
Very. So also accept this for respond number 5 and 6. The respond is granted a week time to file a statement of objections. Shri Monish Kumar seeks for a week time to produce photographs of the property in question. Released on 30th March.
Can I make one? Or maybe upload it.
Every order gets uploaded. Just in a while, it may not.
Just that.
Please, Milods.
Grateful.
The number 13. Keshavar Agnihotri.
My instructions are there. There's no notice was served to the petitioner. Now we'll survey the.
We'll record your permission. Or you know, he is busy somewhere else.
Please.
Shri Learned AGA submits that no notice had been served on the petitioner before the survey was carried out. For the say of the council petitioner, released on 27.
Please.
The number 19. Keshav Reddy.
The government has come forward with some.
We are, as a special case, we are giving a what to this petitioner also. It should not be present to others. There are same solutions.
But you should revise this.
Next year will not, we have separate classification for these cases.
Customary.
Because I understood the problem.
You understood the issue. You should not encourage everybody.
Not push back otherwise performing panchayat.
In life, they won't be able to understand. In 20 varsha, yaru eno madala.
Even the autos will not reach the houses to collect the garbage.
There's no point in having such kind of ideas. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the petitioner had on the earlier occasion been conferred with the Gandhi Grama Award for the year 2021-22. However, despite the petitioner having done that, and being of the opinion that it would win the same award this year also, the petitioner is deprived of the same on account of a policy decision having been taken, on account of a decision which is taken, that an earlier winner of the award cannot be conferred the same award thereafter, and it's only another grama which could be conferred the award. After arguing for some time, the internal and AGA submits that as a special case this time,
We have a draft, GO also is ready.
the petitioner will also be considered. It's not for the Gandhi Grama Award, but for a special award on similar line as the Gandhi Grama Awards, without reference to the restriction which has been imposed. We further submit that going forward, next year, there will be a special category which will be created for the purpose of conferring awards on grammars which had already won the award on earlier occasions. His submission is taken on record. The Red Council for the petitioner submit that if the petitioner's case is considered as a special case, the petitioner would not press the petition.
Along with the prize money. Award with.
ಅಷ್ಟೇ ಬರುತ್ತೆ ಅಂತಿಲ್ಲ, ಏನೋ ಒಂದು ಬರುತ್ತೆ. ಅದೇ ಅನ್ಕೊಂಡು ಎಲ್ಲರಿಗೂ ಕೊಡಕ್ಕಾಗಲ್ಲ.
GO ಆಗಿದೆ same amount.
Award ಅಷ್ಟೇ ದುಡ್ಡು ಕೇಳಕ್ಕೆ
It should be limited to this petitioners. Not act as a
petition disposed of.
There should be a line because the award function is on 24th. Before
made clear that in error.
It shall not act as a precedent in other cases.
It's made clear that the above order shall not act as a precedent.
Be permitted to file my wakalat.
Figure number 25, Dayanand is party.
I'm for this. My lord, in this case, we are seeking for mandamus to directing respondent number 2 and 3 to consider our representation regard dated 23/5/2014 to conclude Adugodi Gram Panchayat.
Policy decision. And ATA accepts notice for respondent number 1, 2, 3, he seeks for and is granted 10 days time to make a submission released on 6th.
Anil Kumar, yes.
What is the status?
But this application is not to be found at all. He says that, my lord, in 1991, he filed an application for change of law. Kindly see, my lord, annexure F 131. (1991). According to him, my lord, he says that he had filed this application with scanty details. Lord, he does not say anything. Kindly see the second paragraph. I purchased site number 11, so and so, 50 into 30, survey number 1, Jodi Rannathpura village, Malleshwaram. No details. Which is that class? What is that, my lord? Identification of this property itself is very difficult. One. Secondly, my lord, 1991. From 1991, my lord, we are in 2023. Let him, my lord, come up with a separate application. Now that under Sakala Services Act, my lord, he is supposed to file an application under the online. He is supposed to file it. Let him file it, and it will be looked into, and accordingly, appropriate orders will be passed.
What are the documents in support of all these things, Mr.?
Absolutely no documents. Even application copy is also not produced before your lordships.
Where is your sale deed?
Sale deed, my lord, your lordships will get it at annexure P, annexure A. Annexure A and B are the two sale deeds.
Where is the Chatbandi boundaries?
Page
Type
17, my lord.
Type copy in page 17.
Pradakshina.
ಇದು ಎರಡೂನು ಮ್ಯಾಚು ಆಗಲ್ಲ. ಬೌಂಡ್ರೀಸ್ ಎರಡು ಸೇಲ್ ಡೀಡ್ ಕಂಪೇರ್ ಮಾಡಿದ್ರು ಬೌಂಡ್ರೀಸ್ ಮ್ಯಾಚ್ ಆಗಲ್ಲ.
ಮೆಜರ್ಮೆಂಟ್ ಮ್ಯಾಚ್ ಆಗ್ತಲ್ಲ.
ಮೆಜರ್ಮೆಂಟ್ ಮ್ಯಾಚ್ ಆಗಲ್ಲ, ಬೌಂಡ್ರೀಸ್ ಮ್ಯಾಚ್ ಆಗಲ್ಲ. ಒಂದ್ ಕಡೆ ಪೈಪ್ ಲೈನ್ ಅಂತಾರೆ, ಆ ಕಂಟಿನ್ಯೂಷನ್ ಪೈಪ್ ಲೈನ್ ಇಲ್ಲ. ಎರಡು ಅಡ್ಜಸೆಂಟ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. Since I can't go through it, I cannot go into these aspects, my lord. Let him file afresh and it will be considered. Online I'll apply madly, whatever the sale deeds they have, whatever documents they have.
Annexure H then.
Annexure H, on the last date they pressed it, they did not press it into service.
Because regarding title, my lord, title is already confirmed by the trial court. After the.
On your vendor.
On his vendor.
Please, my lord.
What about you? Your vendor has been conferred. Where is this property in that?
I purchased from them.
One small property in that
Entire layout, my lord. Entire layout only, layout was approved, my lord.
Identification in the Pramana.
Identification.
Because the same, my lord, the entire layout, 325 by 400 feet was the layout, my lord. There the property was purchased by me. Later on, when possession was disturbed by vendor, vendor went to the civil court.
There is a plan sanction to identify your location.
Please.
ಇದರಲ್ಲಿ approved by D then CITB ಅಂತ ಹೇಳ್ತಾರೆ.
That is what, my lord.
That has not been produced before your lordship.
That plan. If you don't produce all these things again,
No, it is there, my lord. Please, my lord.
you don't produce all these documents again, they're written.
This is what has happened, my lord. It's already 90 years, my lord. After the re-establishment of civil court in 1980, because as your lordship knows, my lord, municipal court was abolished. Civil courts came into possession, my lord. The papers were lying with the appeal court, my lord. Later on, it was numbered. MSA was filed by the respondent, so-called respondent here. They have contested throughout. They have lost. Till today, it is attained finality. RFA also, it was dismissed. They carried it to Supreme Court. Supreme Court also confirmed the title of the vendors.
I'm not going into those aspects at all.
About your vendors, we are concerned about location of your.
Location of his property, coarsely elli anta.
That is what.
Tomorrow another 10 people say I have purchased and it is there on the madam.
Not that.
So you have to produce some documents to show that.
Two sides, they say that it has been, they have purchased it.
For the following review, Shri Anil Kumar, Lieutenant Counsel for the petition submit that he does not press prayer B. Shri B.S. Satyananda, Lieutenant Counsel for the respondent submit that if petitioner were to file a fresh application accompanied by all necessary documents, the same would be considered.
Online. It's all online.
Online ಇದೆಲ್ಲ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
ಅದರಲ್ಲೇ ಕೊಡ್ಬೇಕಾ? ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೋದು. We can upload it.
Upload ಮಾಡ್ಬೋದು.
Yes. It can be uploaded.
Filing and last time ಕೇಳಿದಾಗ
Because now manual service is not available. It has been dispensed with.
ಬಂದಿದ್ಯಾ?
ಹೌದು.
ಅವರಿಗೂ ಬಂತಾ? To be a
In my case, it has come up.
get directed in other matter for that to happen.
Sorry,
Thankfully, it has happened.
And 2018 itself, government order is there to do all these things.
ಇಲ್ಲ ಇದೆ, but 2021 ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
ಇರ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಈಗ ಸ್ಪೆಷಲ್ ಆಗಿ ಹೇಳ್ತಾ
ಇವಾಗ ಏನೋ ಒಂದು 6 ತಿಂಗಳಲ್ಲಿ ಆಗಿರಬೇಕು. B.S. Satyananda, Lieutenant Counsel for the fund to submit that the corporation has now made available an online facility for all residents make their application to the Khata by uploading all relevant documents pertaining thereto. In the same way to be done by the petitioner, it would be considered in accordance with
As prescribed under that law itself. 30 days is there as well. Our apply madly, within 30 days it has to be considered.
There are implications either one.
Now our apply madly.
They are aware of that one.
Yes.
Submission is understood. You there are a party petitions party allowed. Online application, submitting documents.
Humble request would be to the annexure H may be quashed.
ADL are not going to.
First ಅಂತ last time ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Because let that not come in the way, Miller.
That will observe.
Please, let it not come in the way because already title has been confirmed.
The consideration of the application shall be made without reference to order dated 6/8/2021 at Annexure H.
Please.
Track of the and pertaining to has been kept under suspended animation on the ground lots that the area which the petitioner had purchased had been delineated as a park under the master plan of 2003-2000.
Yes.
Which had been prepared by the BMACP. Since then, not there's been no acquisition or not the mandate of 69 not being applied. That
Is denoted as what?
as a park.
Park and open space.
Yes, as an open space. And just to running page 39.
213 Mr. Congress.
India.
2 is government lots. 2 is government. I think
2 is government.
2 is government.
3 idu GM Anand barte. GM Anand.
And AG accepts notice for respond number 1 and 2. Should GM Anand accepts notice for respond number 3. Counsel for the petitioner serve copy of the petition along with annexures. ಕೊಡಕ್ಕಾಗಲ್ಲ. Relist on 6th April. Dispose the matter. Accepting the reasons stated in support of IA 1 and 1 of 23, the production certified copy of annexure A1 and A2.
28. Study pages.
Petition. Yes, petitioner to ensure it of mandamus directing respondent number 1 and 2 to remove the unauthorized construction constructed by respondent number 3. Respondent number 3 without obtaining any necessary permission for the certificate and necessary plan.
No plan sanction.
I will take it. No planning. Whatever action they have taken, I will just place it on.
See the photographs. John Kumar. Respond number 1 and 2 are directed to carry out an inspection of the premises bearing number 18, data number 14/1, ward number 187, 18th, 22nd Main Road, Ramana Road, Ayodhya Nagar, JP Nagar 5th phase. On 31st March 2023, commencing at 10:30 AM and submit a report by 6th April 2023, indicating deviation, if any, from indicating if there is a sanction plan obtained, deviation, if any, from the sanction plan. We made clear that the inspection will be carried out in the presence of the petitioner and respond number 3. 11.
29. B.S. Nagaraj.
But I appear for the petitioner in this case.
I request for about 10
In the last hearing, date, 2 weeks time was granted.
And is granted 10 days time to prepare instruction and make a submission. The interim order earlier granted is extended till the next day. Relist on 6th April.
30. So nearly connected matter.
Pass or it won't reach.
Because there is some urgency, my lords. It may be taken up tomorrow, my lords.
This is that fish thing.
Please, my lords. Fish market.
At the request of the council for the petitioner, we list on 24th.
31.
Grateful.
21.
Regarding ground rent matter,
Um,
the demand, what is that? And annexure F at page
The Pawan
90.
Kumar accepts notice for respond number 234. AG accepts notice for point number 1. We have the order passed by this court in only ground rent. With the plan sanction. With the plan sanction.
Yes, Your Honor.
Plan sanction table. The order passing so and so. Connect with WP number so and so. When is this, Pawan?
5th April.
5th April.
32.
Yes.
This is I'm appearing for appeal. Petition. Kindly see, the property which is subject matter of this petition is purchased by the petitioner from the registered field at Annexure A. This is, my lord, my vendor sealed at Annexure A. That is, my lord, 26/3/1980. Kindly turn to, my lord, the in page number 47 schedule. That is 58/7 and 58/8 for survey number 1/1, 98/2, 98/1B, 92, 99/2, 100, 100/1, 100/1A3. So there are several survey number. Site has been formed. This is absolutely private property. Then possession certificate has been issued on 10/2/1980 Annexure B in page number 48. Then, my lord, the certificate Annexure C, my lord, has been issued by the Office of Revenue Bangalore Development Authority on 5/2/1981 Annexure C, typed copy in page number 50.
Yes.
Then, my lord, we have paid tax to receipt. Then, my lord, subsequent to that, my lord, the vendor has executed sale deed, absolute sale deed Annexure A in page number 53 in favor of, my lord, the first petitioner. That is on 7/7/1980. And another sale deed, my lord, has been executed. That is, my lord, the B scheduled property Annexure G. Then, my lord, we have approached BDA. There are some mistake. Rectification deed also executed. That is in page number 69. Both rectification deed I have produced. And, my lord, subsequent to that, my lord, the similar circumstances, my lord, public investigation has been filed. Writ petition. In the meanwhile, my lord, I draw your lordship's attention that, my lord, the Bangalore Development Authority has issued notice, refused to transfer Kata. Then we have approached Honorable City Civil Judge, and, my lord, by filing a suit for a declaration. Kindly see in page number, my lord, 74 Annexure A. Annexure K. The S.R. Rajgopal, Nalini Murthy in favor of Bangalore against Bangalore Development Authority. The said suit, my lord, initially decreed. Same has been decreed, my lord.
You sought for in this
Declaration. Order at page 115, my lord. The both suits filed by the respective plaintiff are hereby decreed, declaring that plaintiffs in their respective suits are the absolute owners in peaceful possession enjoyment of the respective plain scheduled properties, and it is further declared that the plain scheduled properties does not form part of any of civic community sites.
Yes.
Subsequent to that, my lord, this judgment has been challenged before this honorable court by the, my lord, BDA in RFA 70 of 2005 Annexure L in page number 128. Subsequent to that, my lord, this honorable court was pleased to set aside the order, remanded back the matter for fresh consideration, directing the trial court to frame an issue. Specific issue has to be framed, and accordingly, further time has been granted for cross-examination and leading evidence to the BDA. Then, my lord, kindly see operative portion of the order 139. In the circumstances, decree and judgment set aside, a matter remitted back to the trial court for raising proper issues.
The trial could also pass the same order as earlier.
Yes. Then, my lord, no. Trial was conducted and additional issue has been framed. declared, my lord, as I am the absolute owner. That
Same decree as earlier ಅಂತಾನೆ
issues ಆಯ್ತು ಆಮೇಲೆ ಅವಕಾಶನೂ ಕೊಟ್ರು ಅಂತ ಅಷ್ಟೇ ಸಾರಿ
decree ಅದ ಆಮೇಲೆ
ಆಮೇಲೆ this order, my lord, attained finality. And in the meanwhile, my lord, kindly see, Bangalore Development Authority, another writ petition came to be filed before this honorable court. In the meanwhile, one of the site, that is in the same layout, site number 1 has been allotted. Then, my lord, public have filed writ petition in 21428 of 2013, LBBBMP PI. In that, in page number 204, annexure L. In that, Bangalore Development Authority has, my lord, counter statement saying that this is a private layout. There is no, my lord, relinquished deed has not been executed. Therefore, nothing to do with this file and then they have filed counter affidavit. Kindly see, it is the contention of the second para. It is the contention of the petition that the Ramrao layout plan is a private revenue layout and it was approved in the name of Ramrao by then CIT. Such layout plan is available, which is Bangalore Development Authority, and however, no signature of the competent authority are found on the plan. Then, my lord, BBMP also party, another verifying affidavit that I have statement of objection filed by the lord BBMP in the same writ petition. They have said it is a private layout. My respectful submission before this court is, my lord, subsequent to that, my lord, the writ petition also came to be disposed of on 2013, similar circumstances, my lord. That is, my lord, 213. This is, my lord, as against Bangalore Development Authority. Under similar circumstances, my lord, this honorable court has passed order, not for this layout, insofar as where there is no relinquishment deed.
213 petition was dismissed as withdrawn.
That sorry. 213, this is pertaining to the same property. In similar circumstances, my lord, kindly see. Sorry. In the writ appeal, my lord, annexure W230, in page number 230.
230.
Yes, my lord.
Yes.
Here, my lord, this is, my lord, as against JSS Mahavidyapita and Bangalore Development Authority, petitioners have filed. Here, my lord, this honorable court hold that if there is no relinquishment deed by the layout owner or the owners of the land, then, my lord, it is not a, my lord, form of part of this Bangalore Development Authority property, and, my lord, the civic communities cannot be, my lord, declared, and it cannot be transferred. Relevant portion, my lord, of the order I may permit it to read. Kindly see 240. It is now page 240. It is now submitted that the BDA has leased all sites in favor of society.
That is single bench order.
This is division bench order.
What you are reading is the single judge.
Single bench order. With this observation, my lord, the court uphold that the court also observed that, my lord, when there is 32(5) is not there.
In this judgment, the single judge's order has been set aside. And you are reading the single judge's order.
But however, my lord, set aside, kindly see, insofar as, my lord, when there is no relinquishment, admittedly, kindly see, I may page 7, para 242, page 242, para 7. Admittedly, land was not transferred to the respondent authority either in terms of the agreement or provision of section 32(5) of the BDA Act. This is also evident from various circumstances addressed by on behalf of the society to the BDA. While its letter dated 2592, the society sent a draft copy of the relinquishment deed in respect of the land, but admittedly, relinquished deed was neither finalized nor executed. Then, my lord, I'll draw your since, my lord, this is, my lord, set aside, and, my lord, the insofar as that layout is concerned, my lord, since it is not, my lord, BBMP has no power and BDA has no power. That is the finding. Trial court also, my lord, has held the same thing, that this is not a civic community sites. BBMP, neither BDA has no right over the property. My respectful submission, no, they are not transferring kata, even though there is a direction from the city civil court. Kindly see final order.
asking for certiorari to quash annexure V, T and U.
Kindly see
T and U.
judgment, operative portion of the judgment.
So, but you are asking for quashing of annexure V, T and
Annexure
U, and
V,
you are asking for stay for V, T and U.
Yes.
ಬೇರೆ ಎಲ್ಲ ಕಥೆ ಹೇಳಿ ಅದ್ರ ಬಗ್ಗೆ
ಅಲ್ಲ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್ they have my lord passed notification which is also challenged before this court. When the notification has been issued by BBMP saying that my lord this property is my lord belonging to the BDA, BDA has handed over to BBMP, therefore they have issued notification. Under my lord the park and under the just a moment, my lord. Under section 26 of the Karnataka Parks and Field and Open Space Preservation Regulation Act 1985 prakara, they have issued notification in respect of my property also.
has it been designated as a park and playfield?
No, since my lord, the Bangalore Development Authority has no right. BBMP, my lord, during the pendency of my lord, the original suit for declaration, even though they have approached.
What is annexure V, T and U that you are challenging here?
Here is my lord, the notification annexure Q, my lord. Annexure Q.
Q ಎಲ್ಲಪ್ಪ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ನೀವು?
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಹೇಳ್ತಾ ನಿಮ್ಗೆ
Annexure 288.
Please come to your prayers. What are you challenging?
Issue writ of certiorari appropriate order directing respondent authority impugned annexure 2 to the notification dated 15/4/2021 bearing SLD number UDD 351 MNU 2000 insofar as serial number 2930 of part 4A published in the Karnataka Gazette notification dated.
As per annexure V.
Yes, my lord.
T and U.
Yes, my lord.
Is what you challenge, not
yeah, we my lord 225.
So what have you challenged?
This notification, my lord, insofar as my lord, serial number 29 and 30, ink page number 288. That is what I am trying to show.
Serial number
29, ink page number 228. Either 29 and 30 is my property. That is Katriguppe Ramrao Badavane Atada Maidana ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ರಾಮ್ ಮೈದಾನ ಆಟದ ಮೈದಾನ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. This is 2011.
You are challenging a 2011 notification now.
No, my lord. So far as my lord, since Bangalore Development Authority, my lord, suit was pending. And my lord, we have made an application. Suit for declaration was pending. We are not aware. When we have made an application for transfer of Kata, they have issued endorsement.
Understood. Learned AG accepts notice for respond number 1. Shri Pawan Kumar accepts notice for respond number 2 and 3. Shri K. Krishna accepts notice for respond number 4. Counsel for the petition serve copy of the petition along with annexures.
One submission.
Counsel. We can stay at 2000.
State. When after decree 2018, we have made an application for transfer of Kata. Then, my lord, they have taken.
Pass any order without a notice.
I am not. Since my lord, this notice delay.
Mr. But you have wasted 15 minutes of time without leading anywhere. It is only for a notice. 2011 and
no.
Alex Sati Kedve. Ian, what are you challenging? 2011, we can't stay. We would have issued notice.
I'm not interim order. I'm not pressing. But so for a delay, I'm explaining. Sorry.
First, ade ಹೇಳಿದ್ರೆ ಮುಗಿತಾ ಇತ್ತಾನೆ. Next.
Babu.
case, madam. Day before yesterday matter, madam. For illegal road construction, madam. From Mudigere, Chikmagalur district, madam. This case, the petitioner is seeking mandamus, my lord.
Yes, madam, what happened?
Stop the illegal construction. The same is going on, my lord. Today they made the copy.
Nagarajappa has to make his submission.
Ashok N. Naik.
You are going to appeal now.
R4 to R6.
Ashok Naik has entered appearance and respond number 4 to 6. Registry is directed to print his name as such and delete the name of Shri A. Nagarajappa as appearing 4 to 6. Where are you constructing this road now?
I'll get the inspection and make the.
We will stop the construction if you want time. We ordered notice on 17/3. You don't want to say anything, then we'll stop it.
Next hearing you.
Council for respond 4 to 6. Seeks for a short accommodation to obtain instruction, make a submission. Correct. In view of the said request made, the respondents are restrained from putting up construction on the scheduled properties till next date of hearing. List on 31st March.
Ashok.
But this is a case wherein on the objections filed by some third parties, the B Khata entered in the names of the petitioners were changed without notice to them. Your Lordship may kindly turn to Annexure A, B, C, D. These are the orders passed on the same day. There is no dispute with regard to the ownership of the plot.
Yes.
My lord, Annexure A 3/2/2023, an order passed by the fifth respondent. That is, your Lordship may kindly say Ullaika, Akhila Karnataka Raitara ಮತ್ತು ವ್ಯಾಪಾರಿಗಳ ಒಕ್ಕೂಟ ರಾಜ್ಯಾಧ್ಯಕ್ಷರು ಅವರ ಪತ್ರ 31/1/2023. ಸದರಿ ಅವರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ ದಿನಾಂಕ 31/1/23. ನಮ್ಗೆ ಯಾವ್ದು ನೋಟಿಸ್ ಬಂದಿಲ್ಲ, ಸೇಮ್ ಡೇ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಾರ್ಡ್ 55ರ ಸಿಂಗಯ್ಯನಪಾಳ್ಯ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ 4212 ಕಟ್ಟಡಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಅಖಿಲ ಕರ್ನಾಟಕ ರೈತರ ಮತ್ತು ವ್ಯಾಪಾರಿಗಳ ಒಕ್ಕೂಟ ರಿಗಾರ್ಡಿಂಗ್ ರಿಜಿಸ್ಟರ್ಡ್ ರಾಷ್ಟ್ರಾಧ್ಯಕ್ಷರು. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಸರ್ಕಾರಿ ಶಾಲೆ ನಡೆಯುತ್ತಿದ್ದು, ಇದಕ್ಕೆ ಜಾರಿ ಮಾಡಿರುವ ಖಾತೆಯನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಕೋರಿರುವ ಮೇರೆಗೆ ಕಂದಾಯ ಮೌಲ್ಯಮಾಪಕರು, ಸಹಾಯ ಕಂದಾಯ ಅಧಿಕಾರಿ ಹಾಗೂ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ಜಂಟಿಯಾಗಿ ಸ್ಥಳ ಮಾಡಲಾಯಿತು. ಇವ್ರು ಮಾತ್ರ. ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ದಕ್ಷ ಎ ವೇದಾಂತಗೌಡ ಮತ್ತು ಎಚ್ ಗಗನ್ ರವರು 31/10/2022 ಪ್ರತ್ಯೇಕವಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ 3400 ಚದರ ಅಡಿ ಹಾಗೂ 3400 ಚದರಗಳಲ್ಲಿ ಕ್ರಮವಾಗಿ ನೋಂದಾಯಿತ ದಾನಪತ್ರ ಹಾಗೂ ಇಸಿಗಳನ್ನು ಸಲ್ಲಿಸಿ ಬಿ ಖಾತಾ ನೀಡುವಂತೆ ಕೋರಿರುವ ಮೇರೆಗೆ ಪಾಲಿಕೆಗೆ ಕಂದಾಯ ಪಾವತಿ ಕಳುಹಿಸುವ ಸದರಿ
related, demand notice issued by the BBMP relating to ground rent. But it is slightly different, on facts, annexure H, page 88 was the first demand notice issued by the BBMP. This was questioned in WP 119287 of 2021, annexure J, page 90. There is an interim order subject to deposit of certain amounts. According to which annexure K, page 93 is the revised demand notice issued by BBMP in compliance with the interim order passed by the Honorable Court. At this amount, I have paid it at annexure L, page 95. That's now in annexure M, page 96. The notice stated to be the demand notice for difference of amount. Difference of amount means whatever this Honorable Court has stated in the earlier petition. They have issued this notice, and this notice was never dispatched to the petitioner. And in annexure N, page 98 is another demand notice which is issued at the time of issuance of occupancy certificate on 14/2023, in which there was a reference to the demand notice at annexure M, page 96. Then I sought from the information.
Yes. Power of attorney holder is goes before a bench of SGRG is not a partner.
Question PM.
Yes.
Page 24.
Hmm.
The conversion order. Therefore, my lords, annexure B.
34 is not conversion order.
Annexure A. 24. B also conversion order, my lords. As annexure A is the conversion order.
Annexure
A.
A.
A, my lords, page 24.
A is a conversion.
Yes, my lords.
Yes.
This is for the brick factory, my lords. Thereafter, as for the conversion of the land for commercial usage, page 26.
36.
26, my lords. Annexure B.
Yes.
This is for commercial purpose, my lords. Thereafter, my lords.
Yes.
Annexure C, my lords. Applied for the single plot development plan to the authority.
Yes.
Annexure C. Annexure, my lords, page 30. This is the plan, my lords, where page 30, my lords. This is the plan, my lords, where the commercial space left was, my lords, 5019 square meters. Park is for 641 meters. Parking is for 321 meters, and roads are 441 meters. Thereafter, my lords, annexure E, page 31, my lords.
Yes.
Page 31. Third paragraph, fourth line. Maluru Yojana Pradhikarada Vyaptiyalli. Continue, my lords.
Page 31.
Para 3, my lords. Tippani para 2.
Tippani para.
ಮಾಲೂರು ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಗ್ರಾಮಗಳ ಜಮೀನುಗಳನ್ನು ಈವರೆಗೂ ಯಾವ ವಲಯದಲ್ಲೂ ಗುರುತಿಸುವುದಿಲ್ಲ. ಮಾಲೂರು ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದ ಮಹಾಯೋಜನೆ ಕಾರ್ಯ ಪ್ರಗತಿಯಲ್ಲಿರುತ್ತದೆ. ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ವಾಸ್ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್, my lords. Thereafter, my lords.
17.
Yes, my lords. Last paragraph, my lords. Thereafter, approval was given by the president for the plan. Thereafter, my lords, annexure F. I paid the requisite payment, my lords, was made.
Yes.
33 is, my lords, the amount that I paid. Thereafter, my lords, 36, page 36, annexure J. The member planning authority, my lords, makes an approval, my lords. Under 17 subclause 2, page 36. My lords.
The council you are building is right below a high tension.
Yeah, the buffer zone bitbitu. There was a buffer. There was a high tension wire going.
Yes, to buffer zone bittigira.
As per the, I have produced the relevant documents also. As per the approvals at page, my lords,
Because that is not in question, my lords. I'll come there, my lords. I have the relevant portions also. Next, J.
Question, Bunny.
Now, my lords, what has happened? Annexure W, my lords. Annexure W. 6, my lords. Para 6. Now, without issuing any notice, my lords. ಒಂದುವರೆದು ಅಂದಿನ ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಸೋನ್ ಸರ್ಕಾರಕ್ಕೆ ಬರೆದು ಅನುಮೋದಿಸಿದ ಅಂಗಡಿ ದೇಶದ ಮಾರ್ಪಾಡಿತ ಏಕ ನಿವೇಶನ ವಿನ್ಯಾಸ ನಕ್ಷೆಯು ವಾಸ್ತವವಾಗಿ 3 ನಿವೇಶನಗಳ ವಿಂಗಡಿಸಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದನೆ ನೀಡಿದ್ದು ಸದರಿ ನಿವೇಶನ ವಿನ್ಯಾಸದಲ್ಲಿನ ಉದ್ಯಾನವನ ಹಾಗೂ ವಾಹನ ನಿಲುಗಡೆ ಪ್ರದೇಶವನ್ನು ಪಂಚಿತ ಪ್ರದೇಶದ ಮೂಲಕ ಹಸ್ತಾಂತರಿಸಿಕೊಳ್ಳದೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಉಲ್ಲಂಘನೆ ಯಾಗಿರುತ್ತದೆ ಉಲ್ಲೇಖಿಸಿ ಸರ್ಕಾರದ ಆಹ್ವಾನಿಗೆ ಹಾಗೂ ಸೂಕ್ತ ಕ್ರಮಕ್ಕಾಗಿ ಕಳಿಸಿರುತ್ತದೆ. Para 7, my lords.
Have you relinquished the open space?
That has been left, my lords. Still now, my lords, that plot which have been left it is as it is, my lords. They are not
Relinquished it.
not it, my lords, not it.
ಮಾಡ್ಕೊಡಿ.
ಮಾಡ್ಕೊಡ್ತೀವಿ ಅದೆಲ್ಲ ಅದು ನಾವು ನಮ್ಗೆ ನೋಟಿಸ್ ಬಂದಿಲ್ಲ ಏನೂ ಬಂದಿಲ್ಲ. Subsequently what has happened?
ಕೊಡೋದು ಬೇಕಾ ಇಲ್ಲ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ ನೀವೇ ಮಾಡಬೇಕು.
We are ready, my lords. We are ready. What has happened subsequent to this? The resolution, my lords, has been, my lords, they have passed a resolution, my lords, cancelling the plan.
Your plan was sanctioned in the year 2017.
In 2022.
For 5 years, you don't execute a relinquishment deed.
No, that will be done, my lords. We have now itself we'll do it, my lords. We undertake now after do it, my lords.
76.
ಇಲ್ಲ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪ್ರಾಧಿಕಾರ ಇರ್ಲಿಲ್ಲ ಅವಾಗ ಅವರೇನು ಇದು ಮಾಡ್ಲಿಲ್ಲ ಅದು ಹಂಗೆ ಇತ್ತು.
ಪ್ರಾಧಿಕಾರ ಯಾವಾಗ ಬಂತು?
ಆಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ 19 ಏನೋ ಬಂತು. ಇದಕ್ಕೆ ಹಂಗೆ ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Not doing it.
I'm sorry, my lords. That one we are ready, my lords. ಅದಾದ್ಮೇಲೆ annexure X.
Notice for respond number 1, who is for Malu planning? ಯೋಗೇಶ್ ನಾಯ್ಕ ಇದ್ದಾರೆ ಅದಕ್ಕೆ. Who is for Malu planning? So and so is that accept notice for respond number 2 and 3. The submission of the learned counsel for the petitioner is that due to inadvertence, the relinquishment deed was not executed post the sanction of plan. The petitioner is ready and willing to execute relinquishment deed as required. Even now, in view thereof, the operation of the resolution dated 2010-2022 at Annexure W and the correspondence dated 2022 at Annexure X is stated to the next date of the hearing.
Please.
38.
D number 68. And notice to DBMP. And of ground rent and other areas.
The Pawan Kumar exception respond number 3 and 4. AGA accepts notice for respond number 1 and 2 in view of the order passed and so on so. WP 4561 of 2022. We list on
5th April.
5th April. Connection.
39. S.A. Acharya.
APF petition. Point number 2 is the neighboring landowner. As per annexure B, he obtained a license for the construction of the commercial complex. Annexure B, page 15. ವಾಣಿಜ್ಯ ಕಟ್ಟಡದ ರಚನೆ ಬಗ್ಗೆ. Subsequently, my lord, as per annexure C, my lord, he makes an application and obtains an order, my lord. ಕಟ್ಟಡಕ್ಕೆ ಹೆಚ್ಚುವರಿಯಾಗಿ 65 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣ ಶೀಟ್ ಮಾಡಿದ ವರ್ಕ್ಶಾಪ್ ಶೆಡ್ ರಚನೆಗೆ and he obtains a license next to my lord for running the industry. I'll kindly look at my lord the conversion order obtained at annexure D, page 19 from the DC. Condition number 2. ಈ ಭೂವರ್ತಿತ ಭೂ ಪರಿವರ್ತಿತ ಜಮೀನನ್ನು ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕೆ ಮಾತ್ರ ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲು ಈ ಜಮೀನಿನ ಪೂರ್ವಾನುಮತಿ ಇಲ್ಲದೆ ಬೇರೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉಪಯೋಗಿಸಬಾರದು. Now he started industry, my lord, as per annexure E, I gave a complaint. Well, it has been acted over at the first instance, my lord, by the panchayat. Well, annexure E and F, my lord, F and G are the complaints by me and the neighboring landowner. Annexure H is the endorsement. Firstly given that ಮೇಲೆ ಈ ಮೇಲಿಗೆ ಉಲ್ಲೇಖದ ಸಂಬಂಧಿಸಿದ ಸ್ವಯಂಸೇವಕ ತಾವು ನೀಡಿರುವ ಆಕ್ಷೇಪ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿ ವರ್ಕ್ಶಾಪ್ ಮಾಲೀಕರಾದ ಸ್ವಯಂಸೇವಕರಿಗೆ ನೋಟಿಸ್ ನೀಡಿದ್ದು 3 ತಿಂಗಳೊಳಗೆ ತೆರವುಗೊಳಿಸಿ ಸ್ಥಳ ತಿಳಿಸುವುದನ್ನು ಹಿಂಬರ ನೀಡಲಾಗಿದೆ. After that, there is absolutely no persuasive action.
Annexure J and my lord further complaints is given. Now my lord on 22 my lord. And Sukta Vyavastha Model ಬಗ್ಗೆ ತಿಳಿಸಲಾಗಿದೆ ಅಂತ once again the very same notice issue. They are not really
asking for quashing annexure L.
For annexure my lord, they don't take action now. Annexure L the last condition very specifically stated. That means ಶಬ್ದಗಳಿಂದ ಸಾರ್ವಜನಿಕರ ಆರೋಗ್ಯ ಹಾಗೂ ಶಾಂತಿಗೆ ಧಕ್ಕೆ ಆಗಬಾರದು.
If you quash
Not pollution. They have to take action because they have taken their notice. Because if they are not taking action against
the council for respond number 1.
Respondent number 1 my lord.
Tankaru Panchayat Brahmavara.
Brahmavara my lord, this Mr. Chandranath Tariga he appears in other matters. In
Telegram channel list ಹಾಕಿದೀವಿ ನೋಡ್ಬಿಟ್ಟು ನೀವು ಹೇಳಬೇಕು.
ಇದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Telegram channel subscribe ಮಾಡಿದೀರಾ?
ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಈ ಪಂಚಾಯತಿ ಅವರು ಬೇರೆ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ.
Telegram channel subscribe ಮಾಡಿದೀರಾ ಮಿಸ್ಟರ್ ಆಚಾರ್ಯ?
ಮಾಡಲಿಲ್ಲ.
Telegram channel have you subscribed? The problem. You subscribe for it, there is a list there.
I'll take out emergency notice.
Not emergency.
I'll take out emergency.
ಯಾರು? ಬ್ರಹ್ಮಾವರ ಉಡುಪಿ.
ಅಶೋಕ್ ನಾಯ್ಕ
Chandranath Tariga appears, sir. Chandranath Tariga is directed to accept notice.
Ashok Naik.
Also, this will respond number 1. Issue notice to respond number 2, returnable by 17th April.
Yes.
Mamata Ji Kulkarni.
Worship, I appear for the petitioner. Worship, the council on record has engaged the services of Cine Council efficient. And worship, unfortunately, the Cine Council is out of station. Kindly afford me. Take your option.
And AG accepts notice for respond number 1 to 3. Sira town planning yaru?
Planning.
Other than the list ಮಾಡಿದ್ರು.
ಹೇಳಿದೆ ಮಾತಾಡಿದೆ. It also I'll make one list ಮಾಡಿ.
ಇವತ್ತು ಯಾಕೆ ಅದೇ ಇದಾವೆಲ್ಲ. So and so is directed to accept notice for respond number 4. ಯಾವ್ದು ಬರ್ತಾರೆ? Copy to be served on so and so. ಯಾವ್ದು ಬರ್ತಾರೆ? When do you want this?
Tomorrow he'll be here.
Released on 24.
41. A Sampath.
ಯಾರು ಕೊಡಬೇಕು? EVMP ನೀವೇ ಯಾಕೆ ಕೊಡಿ?
What has happened is, lordship, in EC, the name, some other name is reflecting my lordship. Like Mr. Mohammed Zahid, his name is reflecting in EC.
In the EC?
EC, yeah. That is why.
That is because, my lord, the one person, my lord, the page number, annexure D, my lord, page number 22. My lord, a suit was filed against that person, my lord, whose name is showing in the encumbrance. My lord, my sale deed is of the year, my lord, 2004. My lord, he also claims to be an sale deed holder of a sale deed. They started interfering with the petitioner, my lord, and he filed a suit, my lord, in annexure D, my lord, page number 22. Which was
filed by injunction suit.
Please, my lord, it was the secret, but lord, the sale deed, my lord, which is in the favor of petitioner is of the year 2004, my lord, and the sale deed he is claiming.
Even if you order this, you won't get it.
Even his suit also, he has also filed a counter suit, my lord.
Accepts notice for the respondent 1 to 3. The grievance of the petitioner is that the petitioner, being the owner of site carrying municipal number 19, situated second day main, Bhuvaneshwari Nagar, Cholnax village, municipal ward number 96. An application has been made for issuance of e-Khata. They said e-Khata has not been issued. A representation also has been submitted on 4/1/23. After annexure F, the same is not been considered. You are the other pass the following. Petition is allowed. Response are directed to consider the representation dated 4/1/23 at annexure F in accordance with law within a period of 4 weeks from the date of receipt of a copy of the order.
42. Submit this.
Pertains to ground rent at the time of occupancy certificate. Page 1 is the demand of the
6 crore 61 is towards the ground rent, scrutiny fee and the deviation fee, and 10 crore 75 lakhs is towards the retrospective demand matters. That is the balance from the initial demand which was stayed by this honorable court.
AGA accept notice for respondent 1, Pawan Kumar for 2 and 3. You have the order passed in?
Passed in the other matters, but the table is not extracted in those orders. Prior to the table getting formulated, table nan first page first page, in the first page of the memo, I put the table. They have just mentioned the sums in those orders. That's
Percentage. Percentage has been mentioned.
Percentage sum has been mentioned. My lords may kindly see page number 1. In page 1 only towards the deviation fee. So occupancy certificate time only they have this honorable court, my lords, coordinate benches have granted the relief. Only deviation fees has to be paid.
Where is the table?
Page 1, page 7 and page 1, page 7 and page 19 are the 3 interim orders, my lords. Only because the amounts are mentioned, I have enclosed the demand notices also along with it.
We have the orders passed in WP 14450, 10422 of 2022. I pass the following order. What is the demand made for
Lots the deviation fees in this particular matter will amount to 33,94,122.
Deviation fee amount demanded 33
94,122.
94
122.
122.
This 33,94,122.
It's an order in which the percentages have been worked out.
In these 3 orders, my lords, unfortunately, percentage is not mentioned. That is in the fresh plan order, some are 25.
How much are you willing to pay for that?
My lords, I'm willing to pay the deviation fee entirely, my lords.
Entire. Next.
The others, my lords, has been stayed. Ground rent, scrutiny fee and the retrospective demand have been stayed 100%.
Ground rent.
Scrutiny fee.
What is the amount?
My lords, the ground rent is but it is in 2 demand notices because 586 58 lakh 68,651 and 33 lakh 5,358.
Completely stayed. Next.
Scrutiny fee, my lords. That is also 13 lakh 83,184 and 12 lakh 24,207. My lords, and also the retrospective demand. That is the difference between what has been stayed initially and subsequent to the judgment. That is 10 crore 75 lakhs.
Retrospective demand 10 crore
75 lakh 29,756.
Completely stayed. Connect with so and so. Relist on 5th April.
One permission.
Accepting reason stated in I-1 of 23, production of certified copy of HK and L is dispensed with.
Earlier matter make it 6 weeks. I'm also have granted 4 weeks time.
Serial
number 41.
6 weeks.
Grateful, man.
43.
Appear for it. Next K, my lord, it is called in question in this statement.
Make sure K.
Please, my lord, page number 52, my lord. 57, pardon.
Yes. 57.
Annexure K, my lord. The first paragraph, my lord, is regarding an allegation that is made by one Chandrasekhar. And second para, my lord, it is stated that ಆದ್ದರಿಂದ ಅನಧಿಕೃತವಾಗಿ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವ ಕಟ್ಟಡದ ಕಾಮಗಾರಿಯನ್ನು ಕೂಡಲೇ ನಿಲ್ಲಿಸಿ ನಿಯಮಾನುಸಾರ ಕಟ್ಟಡ ಪರವಾನಗಿಯನ್ನು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದ ಪಡೆಯತಕ್ಕದ್ದು.
What is your plan sanction?
Pardon, my lord.
Where is your plan sanction?
My lord, I have got my case is, my lord, there is a deemed approval in my favor. In view of the fact, my lord, I have made an application at page number 46, annexure H. My lord, the application for building permit, my lord, have been.
Where is your plan sanction?
My lord, there is a deemed provision, my lord, under section 187, subsection 5. Section 187, subsection 5 of the Karnataka Municipalities Act.
That is only for the permit.
Pardon, my lord.
Building license and permit,
Building license.
not for the sanction plan. You have to first get the sanction plan and then you have to get the permit.
My lord, what is contemplated, my lord, in 187 is, my lord, seeking.
Where is your plan?
My lord, that has been for the plan, my lord, the proposed plan would be uploaded, my lord, along with the application.
Where is a copy of it?
This is what, my lord, the receipt that they generate.
And we.
My lord, these are the online, my lord. I do not have the copies, right? Unlike the original ones.
187?
187, please. 187, one, my lord, deals with the notice of the new building. My lord, I give such a notice, and 187.5, my lord, would be the property. A building proposed, may I say. Building proposed in a notice given under subsection 1 may be proceeded with in such manner as may have been specified in such notice, as is not inconsistent with any provision of this act or any rule or bylaw for the time being imposed thereunder in the following cases, that is to say, in the case the municipal council within 1 month from the receipt of the notice given under subsection 1 has neither passed orders under subsection 3 and served notice thereof in respect of the intended work, nor issued under subsection 4 any provisional order or any demand for further particulars. Neither of it, my lord, has been made to me. And hence, my lord, after the completion of 30 days, my lord, I'll be well within my limits to proceed with the construction.
This is a plan.
My lord, that is the proposed, my lord, would be.
Uploaded it is what you are saying.
Yes, please.
Chikwadapura Urban Development Authority.
For R2 is concerned, my lord, Sri Vijay Krishna Bhatt, my lord, is the panel council. R1, it is not notified. Not sure, my lord, who is here.
For Urban Development Authority also. So and is directed to take notice for respondent 1. So Vijay Krishna Bhatt is directed to accept notice for respondent number 2. Now, what are the issues?
Now they have asked me to stop the construction.
Right below the high tension wire.
My lord, it's on the either side, my lord. In fact, when the single site layout plan, my lord, have been got approved, my lord, it shows the presence of that line. But nevertheless, my lord, I have.
What is the buffer zone, Mr. McKin?
My lord, the buffer zone, my lord, is 7 feet, my lord, on either side is to be left. And I have specifically stated in my grounds that 33 feet on either side is what I have left. I have specifically stated in my petition. The horizontal clearance, my lord, is taken care of.
It's not a regular line, it's high tension wire.
Please, high tension wire itself, my lord, it's a 66 kV line. My lord, that's the requirement of law. 7 feet on either side, my lord, have to be left. So totally 15 feet would be the buffer zone.
Won't stay this.
My lord, there is no finding recorded regarding the said aspects, my lord.
Furnish a copy of the petition along with the annexes and said councils. Released on 6th April.
As for earlier date, my lord, because there is some difficulty.
31st March. You are taking too big a risk.
No, what has
He's
happened?
so close to it.
Well, there is no finding whatsoever in the notice as to whether there is any such violation. 31st month.
31st.
44.
Yeah, please.
Then covered,
For
Now-
approval of the private layout.
which is the,
Annexure, my lord, 31. Annexure F on page 31.
where is the order? Covered matter, la?
All matters. I have produced the certified,
Where is that order?
my lord finds it at page 37, 38, and 39.
37.
Annexure H, J, and K.
Was the order in 25145 of 2022. And AG accepts notice for respond number 1 and 2. Kanakpura Planning Authority. Yogesh Nayak accepts notice for respond number 3 and 4. Council for the petition to submit copy of the petition. In view of the order passed in WP 2745. Hearing. ಯಾವತ್ತಿದೆ ಇದು? Fifth ಅಲ್ಲ? 5-4.
Request for similar stay orders. Great.
45 is Sheshagiri Rao.
Additional in this matter, madam. The challenge is annexure J, page number 99. A portion of the property in survey number 6 of Gangadharpura village is the subject matter of the property. This was granted to one village in the year 1966 by the government, measuring about 8 guntas. Vedmurti, after purchasing the property, he sold it in favor of Shahnaz Begum in 1986.
The entire property?
Entire property. The Shahnaz Begum has sold a portion of 8 guntas in favor of one Narayanappa and Somshekara in the year 1987. This Narayanappa alone has sold that portion of the property in favor of one P. Ravindra Reddy in 1994.
What does Narayanappa share?
Later, he has taken a confirmation deed from other person, that is Somshekara, in 2018. That confirmation deed also has been produced. Subsequent to confirmation deed, this P. Ravindra Reddy goes before the authority with a request to enter Kata the property in his name on the basis of his sale deed. The local authority, before entering Kata the property in the name of this P. Ravindra Reddy, refers the matter to ascertain whether the land is granted to Vedmurti, whether the land is converted or not. The planning authority and Tahsildar intimates the local authority, yes, it has been granted to Vedmurti and it has been converted also. Annexure P, annexure C and D. Lordship, kindly, after that, Kata was entered in the name of this Ravindra Reddy. This Ravindra Reddy on 15/9/2021 sells the property in favor of the petitioner who is before this court. This, on the basis of the sale deed, Kata was entered in the name of the petitioner. After entering the Kata of the property, this gentleman goes before the local authority with a request to grant plan and license to put up construction of the property. On 2/12/2022, license and plan was sanctioned. Those documents have been produced and marked as exhibit H1 and H1. After 2/12/2022, he, in order to take up the construction, goes to the land. Respondent number 4, he is unconcerned to the property in question, interferes with the construction taken up by the petitioner. And there was a complaint against respondent number 4, that is on 25/12/2022. After the complaint has been lodged, this respondent number 4 gives a petition to the planning authority. The land is not granted to Vedmurti, the land is not converted. The planning authority informs the local authority, that is the CMC Dodbalapura, stop further action on the construction in question. On the basis of the intimation which has been given by the planning authority to the local authority issues annexed J to the writ petition. You stop the construction. We want to inquire whether the land is granted to Vedumurti, whether conversion is accorded or not. Your Lordship may kindly say, from the grant certificate itself, the conversion which has been accorded in 1966 is forthcoming. That apart, the Tahsildar intimates the local authority and the planning authority.
ಯಾವ document ಅದು?
Annexure?
81. Page 81.
Page 81. Tahsildar intimates. Pawra Ayukturu Nagarasabhe Dodballapura, dated 18/2/2021. ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಗಂಗಾಧರಪುರ ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆ ಪೈಕಿ 5 ಗುಂಟೆ ಜಮೀನನ್ನು ದೊಡ್ಡಬಳ್ಳಾಪುರ ಬ್ಲಾಕ್ ಕಾಂಗ್ರೆಸ್ ಸಮಿತಿಯ ಕಟ್ಟಡ ನಿರ್ಮಿಸುವ ಮಂಜೂರಾತಿ ಕೊಡುವ ಬಗ್ಗೆ ತಮ್ಮ ಕಚೇರಿಯ ಪತ್ರ ಸಂಖ್ಯೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದೊಡ್ಡಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸ್ಬಾ
access notice for respond number 1. CMC ದೊಡ್ಡಬಳ್ಳಾಪುರ ಯಾರು? ದೊಡ್ಡಬಳ್ಳಾಪುರ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ. Access notice for respond number 3. Issue emergency notice to respond number 4 returnable by 23rd May 2023. The operation, execution and enforcement of the order dated 9/1/23 at Annexure J is stayed for the next date of it. Those to and copy to submit by end of tomorrow in order.
Yes,
stand automatically with it.
46. Rohit Vijay.
Of mandamus is sought on consideration of my application for allotment of CH-18. If not for annexure F, it does not have knocked the doors of this court because they are having a meeting tomorrow for allotment of CH-18. I have been continuously applying for the CH-18. Agide notification agide.
Applied.
I have applied it. I have produced all those.
Application will be considered.
Yes, ma'am. That's what my friend.
To consider and kodakaya.
There's a subsequent development. The Lordships are aware that there is a subcommittee for recommendation to the main authority. But now the subcommittee has recommended to the main authority on 10th of March 2023, in which the petitioner is not selected. It is recommended in favor of another applicant. There are 12 applicants. But the authority will have to take a decision whether to accept the recommendation of subcommittee or not. If any
challenge
is passed, then he could have the opportunity to challenge it.
Because it is it's still in a subcommittee level. Let my representation be considered. It has not been allotted to anybody now.
We cannot direct a mandamus for CSI. The subcommittee was to decide.
Yes,
we should have a vested right for the mandamus. You don't have a vested.
Yes, because I am continuously applying from.
Problem to decide what you want to do.
If an order from this court, let my representation be considered.
That way. No vested right for a mandamus to be. Subcommittee will recommend, that is what will be considered. There's a process. It's not like Tata being transferred.
Yeah. I've been, my only grievance is, my lords, I also come in.
What do you want to do? Dismissal or withdrawal?
I'll withdraw with the liberty to approach the subcommittee. If I challenge the order of the Sun.
The TP Vivekananda access notice for respondents are charging for some time passing for the petitioner. Seeks permission to withdraw the above petition with liberty to approach the respondent. Reserving such liberty, the petition stands disposed.
If any application is filed to the subcommittee, let them consider.
There's nothing like that which can be done.
He can challenge the recommendation of subcommittee if he is agreed to
later.
47. Manu Shankar.
Paper petition trust and senior Pakkur.
Tumkur Mahanagar Palika. Access notice for respond number 1 and G. Respond 1 to 3. Counsel for the petition serve a copy of the petition along with connections. As that counsel released on 28.
48, Devi Prasad Shetty.
When this interim order be granted.
No, as per section 28B, my lord, the resignation was submitted on 6th. Now, 15 days period has not expired, and on the same day, my lord, special officer is appointed. No, which is in violation of section 28B.
See your interim order.
Alternative remedy is there.
For respond number 1.
May I make one submission? Alternative remedy, appeal it. One not.
Like in violation of the act.
28B na langen heladu. 28B may kindly be read, Mela. That's the ground on which this annexure C is under challenge.
Sorry, madam. Staying of the order.
Stay, madam. You can only challenge the appointment. That is to be done by an appeal.
Well, the appointment itself is in violation of 28.
28B.
Only sit 20.
Not before this court. You have appellate remedy.
The appellate tribunal is there, but it's not whirlpool judgment. Not it's in total violation of the act itself, my lord. It's in violation of the.
Without jurisdiction is.
It's in violation of the act itself. Provision of the act.
Provision of the act may.
And not the hurry. The lordship may kindly recollect. No, this is the very same society where they had issued notice on the section 30B 30. Your lordship had directed the deputy registrar how when there is no financial assistance. Very same society, my lord. Now they have.
May I make one submission?
How can you appoint a special officer? You won't have any right.
28B violation antu agilla.
Same society, my lord. Your lordship may allow that repeat.
It may be taken up on 29th.
Without jurisdiction.
And 28B violation antu agilla because that provision doesn't give 15 days time.
No jurisdiction in respect of that.
29th.
Number 1. He seeks for and is granted a week's time to.
Please.
Instruction, make a submission, release on 29th.
Further hearing, serial number.
Now, my lord, a democratically elected body is not is superseded, my lord. What will happen? The creditors, the depositors of Relap, they will not withdraw the amount, all those things will happen. But in total violation of the act itself. 28, they did not even wait for. And kindly see, the petitioner, the petitioner number 7 and 8 who had submitted the
Have it on 23rd, madam.
Please.
23rd. Accepting reasons stated in I have 1 of 23 allowed. See your connection.
Number 45.
Appearing for petition, appearing for petitioner in this case. Reply has been served to PDM. They have to come back.
Well, they've not given us a copy as usual.
Who has not given you a
This
copy?
morning we were there. Our petitioners have not given us.
You have filed it.
Yes, ma'am. I've given.
Why haven't you given it to Mr. KT?
KT. Now I'll give him. PDM.
Where's Mr. Touching?
Mike.
Counsel for the petition submit that a memo along with documents have been filed. Copy to be served on the counsels for the respondents released on 10th April at 2:30 p.m. Which matters in every time.
Only. 234 matter, DN Shetty.
First, may kindly see the page number 60. The license issued by the licensing authority, my lord. Annexure D is the license, trade license they issued. Then, my lord, I'm doing the bar and restaurant business. I got shifted this business to the premises. Page number 14, my lord, Annexure C. The authority, excise authority is instructed the spot
and said, my lord, in rule 5 will be not applicable to rule 5, and they granted the license saying that, my lord, there is no objection, public objection are not there. And rule 5 also, it is, there is no restrictions. My lord, accordingly, the license was also issued, my lord, CL7 license. Then, my lord, you will ask me kindly see, without notice to me, my lord, without cancelling, without any inquiry also, annexure A, impugned order notice was issued, my lord.
Survey number 12/1, you shifted it to Kata number 571.
Yes, ma'am.
Yes. Is annexure E.
Annexure E is the endorsement, my lord. It says that public has objected it, so cancel, withdraw your license. It says last, my lord, it says last 3 lines. ಅನುಮತಿ ವ್ಯಕ್ತವಾಗಿರುತ್ತೆ. ಹೀಗಾಗಿ ಬೊಮ್ಮಸಂದ್ರ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಸೋಸಿಯೇಷನ್ ನಿರೀಕ್ಷಣಾ ಪತ್ರದಲ್ಲಿ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ನೀಡ್ತಾರೆ ಇಲ್ಲ ಅನುಮತಿ ನೀಡೋದಲ್ಲಿ ಕೂಡಲೇ ಹಿಂಪಡೆಯಬೇಕು ಅಂತ ಕೋರಿರ್ತಾರೆ. ಅವರು ಎನ್ಕ್ವೈರಿ ಕೇಳಿದ್ದಾರೆ ಅಂತ ಇವರು he passed the order saying that I withdrawn the license. Annexure A is the impugned notice, my lord. Page 11.
This is a KDB property.
ಇಲ್ಲ ಸರ್, KFD ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ, ಪ್ರೈವೇಟ್ ವಿ ಆರ್ ರನ್ನಿಂಗ್ ಇಂಡಸ್ಟ್ರಿ ಏರಿಯಾದಲ್ಲಿ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ರನ್ ಮಾಡ್ತಾ ಇದೀವಿ. Even this court has held, my lord, it is also an industry. Hotel is also an industry.
Hotel is a industry is different from a bar and restaurant.
No, my lord. Even the bar and restaurant in my one case, my lord, court said
hotel with a bar and restaurant is different. That comes under 27A as industry. Bar and restaurant.
The same bar and restaurant was in the industrial area, the Manekal industrial area, my lord. It was challenged, and this court held, my lord, the bar and restaurant hotel is also in industry and allowed them to do the business. I am having
AMC Edbagodi are. Only directed the accept notice for response. Counsel for the petition serve a copy of the petition along with connections on the said counsel relist on
24 hours next year, my lord. You Rashmi kindly see next year.
Industrial area.
My lord, Rashmi taken my words, my lord. It is the judgment is there, my lord. This court, coordinate bench of this court is held, my lord.
Not in an industrial area.
In an industrial area, my lord. It is industrial area.
In an industrial area, you can't have a bar and restaurant.
My lord, yes, my lord. This court has said, my lord. My word, my statement may be taken on record, my lord. I myself is appeared in that case.
What is judgment? We can't take.
My lord, I'll produce that judgment, my lord.
On 24th.
Final hearing, serial number 6. BB Gunjar.
Unlikely that we can finish anything. We'll attend. We list on.
ಅದು ಲೇಬರ್ ಸೇರ್ಕೊಂಡು ಸರಿ ಮಾಡಿಲ್ಲ ಸರ್. ಲೇಬರು ಎಲ್ಲ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಸೇರ್ಕೊಂಡಿದ್ದಾರೆ, ಸರಿ ಮಾಡಿಲ್ಲ ಅವರು. ನಾಳೆ 120 ಎಷ್ಟು ತೋರಿಸ್ತಿದೆಯಲ್ಲ ಅದು ಬರೀ 39 ಇದೆ ಅಷ್ಟೇ. ನಾವು ಒಂದೇ ಸಿಟ್ ಕೋಡಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರ್ತೀವಿ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ತಗೊಂಡು ಮಾಡಿಲ್ಲ.
ಬೇರೆ ಪ್ರಿಂಟ್ to 53 we list on 31st. 54 54 56 57 59 to 62 we list on 10th April.
Serial number 51. A short point is involved, my lord. May request tomorrow. Tomorrow.
ಯಾವ್ದು 62 ವರೆಗೂ ಆಯ್ತಲ್ಲ. 64 to 67 10th April. 69 to
Not in 69, there is an interim order which may be.
will be extended
Thank you.
to 75 or the 76 to 80.
76, EDR matter, what matter?
11th April.
Endorsement-
It is a short matter once it is taken up.
The reason in the given in the endorsement is, reason given in the endorsement is already decided, my lord, by
81 name.
81, my lord. As for compliance, BDA has preferred an appeal, but no stay has been granted, my lord. They are not compliant.
81 relist on 6th at 2:30 p.m.
But civil number 64. Let's kindly have it after 2 weeks.
We have adjourned. This two, serial number 3, 4, 6, 8, and 12.
Serial number 12, my lords.
Yes.
Serial number 12, Sri A.M. Surya Prakash name may be deleted, my lords. He is no more. And yes, Sumati name shall be shown, my lords.
Delete Sumati. 12, 14.
Applies.
My lord, and serial number 6, my lord.
10.
Lord, 17, my lords.
Serial number 6, if I may make a mention, my lord. The BBMP has filed its counter admitting that it's residential mixed, my lord. They had issued a notice saying residential main.
They're only adjourning, so.
My lord, 17, my lord.
My name may kindly be shown, my lord. Senior's name is still being shown in 6.
6. Delete B.K. Sampath Kumar and for print the name of Suraj Sampath as that appearing for the petitioner.
Please, my lord.
Lord, 17, my lord.
17, yes.
The ground rent matter, my lords, prior to the amendment. Covered by the judgment of the Honorable Court.
Prior to the amendment.
Covered by the judgment of the Honorable Court.
So we'll have to dispose the matter.
Please. Lord, serial number 20, my lord.
17 lost on 27.
Lord, the petitioner is no more.
Which one?
Serial number 22nd.
21 to 24 has been disposed.
20.
20.
Serial number 20.
List 2. In serial number 20. Head.
Serial number 20. The petitioner is no more. Will take necessary steps to.
20. We list on petition submit that petitioner is no more. We list on 17th April. N.R. Jagdishwara has entered appearance for R1 to R4. Delete E.R. Ramchandran. Dr. Ramchandran has that appearance. 25 to 30. We list on 11th April. Serial number 83. Madam, tomorrow we can't take. We'll have to take it up on Thursday. 83 at 4 p.m. on 23rd. Yes.
Serial number 80, madam. Serial number 80, encroachment of public road. Short point.
Yella short point, Umesh. If it reaches.
Project
We'll take it up on those dates. That
interim order.
51 may request on 27. 51.
You'll do request, Mark. The whole purpose of listing so many is now that it comes out, there's a date fixed. It's out in circulation.
Please.
All of it won't reach, but it is in circulation. Many of these have not been listed from 2016.
Please, ours is also 16, but.
List at the lab. One thought.
Serial number 70. Madam 70. 70, madam. 70. 70. Madam, 70.
Madam, serial number 61.
54, madam.
61.
70. Madam, 70. 70.
Serial number 72, madam.
Madam, serial number 61.
79. 79. ಬರ್ತಾರೆ ಒಂದ್ ನಿಮಿಷ ಟೈರ್ ಹತ್ರ ಮಾತಾಡ್ತಾರೆ ಕರ್ವ್ ಮಾಡಿ
80 ಎಷ್ಟು? ಆವಾಗಲೇ ನೀವು ಕೇಳಿದ್ರ
Still number 65.
79, madam. 79.
Serial number.
79. Madam, entry model is there.
Madam, serial number 61.
29.
ಬರ್ತಾರೆ ಇನ್ನು ಲಾಯರ್ ಹತ್ರ ಮಾತಾಡ್ತಾರೆ ಬರ್ತಾರೆ.
Okay, okay.
Still number 65.
Till next date of hearing ಅಂತ ಇದೆ. 79.
80, madam.
ಹಾ ಇದೆ. ಸರ್ ಹೇಳಿ ಸರ್.
Serial number 61, madam.
61 10th April.
10th April. Sorry, madam.
Serial number 66, madam.
66 10th April.
10th April, sorry, madam. Thank you.